Subtitle C, Lands. Section 50301. Section 50302, Timber Sales and Long-Term Contracting for the Forest Service and the Bureau of Land Management. Section 50303, Renewable Energy Fees on Federal Land. Section 50304, Renewable Energy Revenue Sharing. Section 50305, Rescission of National Park Service and Bureau of Land Management Funds. Section 50306, Celebrating America's 250th Anniversary. Subtitle D, Strategic Petroleum Reserve. Section 50401, Strategic Petroleum Reserve. Section 50402, Repeals Rescissions. Section 50403, Energy Dominance Financing. Section 50404, Transformational Artificial Intelligence Models. Subtitle E, Water. Section 50501, Water Conveyance and Surface Water Storage Enhancement. Title 6, Committee on Environment and Public Works. Section 60001, Rescission of Funding for Clean Heavy-Duty Vehicles. Section 60002, Repeal of Greenhouse Gas Reduction Fund. Section 60003, Rescission of Funding for Diesel Emission Reductions. Section 60004, Rescission of Funding to Address Air Pollution. Section 60005, Rescission of Funding to Address Air Pollution at Schools. Section 60006, Rescission of Funding for Low Emissions Electricity Program. Section 60007, Rescission of Funding for Section 211.0 of the Clean Air Act. Section 60008, Rescission of Funding for Implementation of the American Innovation and Manufacturing Act. Section 60009, Rescission of Funding for Enforcement, Technology, and Public Information. Section 60010, Rescission of Funding for Greenhouse Gas Corporate Reporting. Section 60011, Rescission of Funding for Environmental Product Declaration Assistance. Section 60012, Rescission of Funding for Methane Emissions and Waste Reduction Incentive Program for Petroleum and Natural Gas Systems. Section 60013, Rescission of Funding for Greenhouse Gas, Air Pollution Plans, and Implementation Grants. Section 60014, Rescission of Funding for Environmental Protection Agency Efficient, Accurate, and Timely Reviews. Section 60015, Rescission of Funding for Low Embodied Carbon Labeling for Construction Materials. Section 60016, Rescission of Funding for Environmental and Climate Justice Block Grants. Section 60017, Rescission of Funding for ESA Recovery Plans. Section 60018, Rescission of Funding for Environmental and Climate Data Collection. Section 60019, Rescission of Neighborhood Access and Equity Grant Program. Section 60020, Rescission of Funding for Federal Building Assistance. Section 60021, Rescission of Funding for Low Carbon Materials for Federal Buildings. Section 60022, Rescission of Funding for GSA Emerging and Sustainable Technologies. Section 60023, Rescission of Environmental Review Implementation Funds. Section 60024, Rescission of Low Carbon Transportation Materials Grants. Section 60025, John F. Kennedy Center for Performing Arts. Section 60026, Project Sponsor Opt-in Fees for Environmental Services. Title VII, Finance. Subtitle A, Tax. Section 70001, references to the Internal Revenue Code of 1986, etc. Chapter 1, providing permanent tax relief for middle-class families and workers. Section 70101, extension and enhancement of reduced rates. Section 70102, extension and enhancement of increased standard deduction. Section 70103, termination of deduction of personal exemptions other than temporary senior deduction. Section 70104, extension and enhancements of increased child tax credit. Section 70105, extension and enhancement of deduction for qualified business income. Section 70106, extension and enhancement of increased estate and gift tax exemption amounts. Section 70107, extension of increased alternative minimum tax exemption amounts and modification of phase-out thresholds. Section 70108, extension and modification of limitation on deduction for qualified residence interest. Section 70109, extension and modification of limitation on casualty loss deduction. Section 70110, termination of miscellaneous itemized deductions other than educator expenses. Section 70111, limitation on tax benefits of itemized deductions. Section 70112, extension and modification of qualified transportation fringe benefits. Section 70113, extension and modification of limitation on deduction and exclusions for moving expenses. Section 70114, extension and modification of limitation on wagering losses. Section 70115, extension and enhancement of increased limitation on contributions to ABLE accounts. Section 70116, extension and enhancement of savers credit allowed for ABLE contributors. Section 70117, extension of rollovers for qualified tuition programs to ABLE accounts permitted. Section 70118, extension of treatment of certain individuals performing services in the Sinai Peninsula and enhancement to include additional areas. Section 70119, extension and modification and exclusion from gross income of student loans discharged on account of death or disability. Section 70120, limitation on individual deductions for certain state and local taxes, etc. Chapter 2, delivering on presidential priorities to provide new middle-class tax relief. Section 70201, no tax on tips. Section 70202, no tax on overtime. Section 70203, no tax on car loan investment. Section 70204, Trump accounts and contribution pilot program. Chapter 3, establishing certainty and competitiveness for American job creators. Subtitle A, permanent U.S. business tax reform and boosting domestic investment. Section 70301, full expensing for certain business property. Section 70302, full expensing of domestic research and experimental expenditures. Section 70303, modification of limitation on business interest. Section 70304, extension and enhancement of paid family and medical leave credit. Section 70305, exceptions from limitations on deduction for business meals. Section 70306, increased dollar limitations for expensing of certain depreciable business assets. Section 70307, special depreciation allowance for qualified production property. Section 70308, enhancement of advanced manufacturing investment credit. Section 70309, spaceports are treated like airports under exempt facility bond rules. Subtitle B, permanent America First international tax reforms. Part 1, foreign tax credit. Section 70311, modifications related to foreign tax credit limitation. Section 70312, modifications to determination of deemed paid credit for taxes properly attributable to tested income. Section 70313, sourcing certain income from the sale of inventory produced in the United States. Part 2, foreign-derived deduction eligible income and net CFC tested income. Section 70321, modification of deduction for foreign-derived deduction-eligible income and net CFC-tested income. Section 70322, determination of deduction-eligible income. Section 70323, rules related to deemed intangible income. Part 3, base erosion minimum tax. Section 70331, extension and modification of base erosion minimum tax amount. Part 4, business interest limitation. Section 70341, coordination of business interest limitation and interest capitalization provisions. Section 70342, definition of adjusted taxable income for business interest limitation. Part 5, other international tax reforms. Section 70351, permanent extension of look-through rule for related controlled foreign corporations. Section 70352, repeal of election for 1 month deferral and determination of taxable year of specified foreign corporations. Section 70353, restoration of limitation on downward attribution of stock ownership in applying constructive ownership rules. Section 70354, modification to pro rata share rules. Chapter 4, investing in American families, communities, and small businesses. Subchapter A, permanent investments in families and children. Section 70401, enhancement of employer-provided child care credit. Section 70402, enhancement of adoption credit. Section 70403, recognizing Indian tribal governments for purposes of determining whether a child has special needs for purposes of the adoption credit. Section 70404, enhancement of the Dependent Care Assistance Program. Section 70405, enhancement of Child and Dependent Care Tax Credit. Subtitle B, permanent investments in students and reforms to tax-exempt institutions. Section 70411, tax credit for contributions of individuals to scholarship-granting organizations. Section 70412, exclusion for employer payments of student loans. Section 70413, additional expenses treated as qualified higher education expenses for purpose of 529 accounts. Section 70414, certain post-secondary credentializing expenses treated as qualified higher education expenses for purposes of 529 accounts. Section 70415, modification of excise tax on investment income of certain private colleges and universities. Section 70416, expanding application of tax on excess compensation within tax-exempt organizations. Subchapter C, permanent investments in community development. Section 70421, permanent renewal and enhancement of opportunity zones. Section 70422, permanent enhancement of low-income housing tax credit. Section 70423, permanent extension of new markets tax credit. Section 70424, permanent and expanded reinstatement of partial deduction for charitable contributions of individuals who do not elect to itemize. Section 70425, 0.5% floor on deduction of contributions made by individuals. Section 70426, 1% floor on deduction of charitable contributions made by corporations. Section 70427, permanent increase in limitations on cover over of tax on distilled spirits. Section 70428, nonprofit community development activities in remote native languages. Section 70429, adjustment of charitable deduction for certain expenses incurred in support of Native Alaskan subsistent whaling. Section 70430, exception to percentage of completion method of accounting for certain residential construction contracts. Subchapter D, permanent investments in small business and rural America. Section 70431, expansion of qualified small business stock gain exclusion. Section 70432, repeal of revision to de minimis rules for third-party network transactions. Section 70433, increase in threshold for requiring information reporting with respect to certain payees. Section 70434, treatment of certain qualified sound recording productions. Section 70435, exclusion of interest on loans secured by rural or agricultural real property. Section 70436, reduction of transfer and manufacturing taxes for certain devices. Section 70437, treatment of capital gains from the sale of certain farmland property. Section 70438, extension of rules for treatment of certain disaster-related personal casualty losses. Chapter 5, ending Green New Deal spending, promoting America First energy, and other reforms. Subchapter A, termination of Green New Deal subsidies. Section 70501, termination of previously owned clean vehicle credit. Section 70502, termination of clean vehicle credit. Section 70503, termination of qualified commercial clean vehicles credit. Section 70504, termination of alternative fuel vehicle refueling property credit. Section 70505, termination of energy efficient home improvement credit. Section 70506, termination of residential clean energy credit. Section 70507, termination of energy efficient commercial building deduction. Section 70508, termination of new energy efficient home credit. Section 70509, termination of cost recovery for energy, property, and qualified clean energy facilities, property, and technology. Section 70510, modifications of zero-emission nuclear power production credit. Section 70511, termination of clean hydrogen production credit. Section 70512, termination and restrictions on clean electricity production credit. Section 70513, termination and restrictions on clean electricity investment credit. Section 70514, phase out and restrictions on advanced manufacturing production credit. Section 70515, restriction on the extension of advanced energy project credit program. Subchapter B, enhancement of America First energy policy. Section 70521, extension and modification of clean fuel production credit. Section 70522, restrictions on carbon oxide sequestration credit. Section 70523, intangible drilling and development costs taken into account for purposes of computing adjusted financial statement income. Section 70524, income from hydrogen storage, carbon capture, advanced nuclear, hydropower, and geothermal energy added to qualifying income of certain publicly traded partnerships. Section 70525, allow for payments to certain individuals who die fuel. Subchapter C, other reforms. Section 70531, modifications to de minimis entry privilege for commercial shipments. Chapter 6, enhancing deduction and income tax credit, guardrails, and other reforms. Section 70601, modification and extension of limitation on excess business losses of non-corporate taxpayers. Section 70602, treatment of payments for partnerships to partners for property or services. Section 70603, excessive employee remuneration from controlled group members and allocation of deduction. Section 70604, third-party litigation funding reforms. Section 70605, excise tax on certain remittance transfers. Section 70606, enforcement provisions with respect to COVID-related employee retention credits. Section 70607, Social Security number requirement for American Opportunity and Lifetime Learning credits. Section 70608, Task Force on the Replacement of the Direct File. Subtitle B, Health. Chapter 1, Medicaid. Chapter A, Reducing Fraud and Improving Enrollment Processes. Section 71101, Moratorium on Implementation of Rule relating to eligibility and enrollment in Medicare savings programs. Section 71102, Moratorium on Implementation of Rule relating to eligibility and enrollment for Medicaid, CHIP, and the Basic Health Program. Section 71103, Reducing Duplicate Enrollment under the Medicaid and CHIP programs. Section 71104, Ensuring deceased individuals do not remain enrolled. Section 71105, Ensuring deceased providers do not remain enrolled. Section 71106, Payment reduction related to certain erroneous excess payments under Medicaid. Section 71107, Eligibility redeterminations. Section 71108, Revising home equity limit for determining eligibility for long-term care services under the Medicaid program. Section 71109, Alien Medicaid eligibility. Section 71110, Expansion FMAP for certain states providing payments for health care furnished to certain individuals. Section 71111, Expansion of FMAP for emergency Medicaid. Subchapter B, Preventing Wasteful Spending. Section 7112, Moratorium on Implementation of Rule relating to staffing standards for long-term care facilities under the Medicare and Medicaid programs. Section 71113, Reducing State Medicaid Costs. Section 71114, Prohibiting federal Medicaid and CHIP funding for certain items and services. Section 71115, Federal Payments to Prohibited Entities. Subchapter C, Stopping Abusive Financing Practices. Section 7116, Sunsetting Increased FMAP Incentive. Section 71117, Provider Taxes. Section 71118, State-Directed Payments. Section 71119, Requirements regarding waiver of uniform tax requirement for Medicaid provider tax. Section 71120, requiring budget neutrality for Medicaid demonstration projects under Section 1115. Subchapter D, increasing personal accountability. Section 71121, requirement for states to establish Medicaid community requirements for certain individuals. Section 71122, modifying cost-sharing requirements for certain expansion individuals under the Medicaid program. Subchapter E, expanding access to care. Section 71123, making certain adjustments to coverage of home or community-based services under Medicaid. Section 71124, determination of FMAP for high-poverty states. Chapter 2, Medicare. Subchapter A, strengthening eligibility requirements. Section 71201, limiting Medicare coverage of certain individuals. Subchapter B, improving services for seniors. Section 71202, temporary payment, increase under the Medicare physician fee schedule to account for exceptional circumstances. Section 71203, expanding and clarifying the exclusion for orphan drugs under the Drug Price Negotiation Program. Section 71204, application of cost living adjustment to non-labor related portion for hospital outpatient department services furnished in Alaska and Hawaii. Chapter 3, health tax. Subchapter A, improving eligibility criteria. Section 71301, permitting premium tax credit only for certain individuals. Section 71302, disallowing premium tax credit during periods of Medicaid ineligibility due to alien status. Subchapter B, preventing waste, fraud, and abuse. Section 71303, requiring verification of eligibility for premium tax credit. Section 71304, disallowing premium tax credit in case of certain coverage enrolled in during special enrollment period. Section 71305, eliminating limitation on recapture of advance payment of premium tax credit. Section 71306, permanent extension of safe harbor for absence of deductible for telehealth services. Section 71307, allowance of bronze and catastrophic plans and connection with health savings accounts. Section 71308, treatment of direct primary care service arrangements. Chapter 4, protecting rural hospitals and providers. Section 71401, rural health transformation program. Subtitle C, increase in debt limit. Section 72001, modification of limitation on the public debt. Title 8, Committee on Health, Education, Labor, and Pensions. Subtitle A, exemption of certain assets. Section 80001, exemption of certain assets. Subtitle B, loan limits. Section 81001, establishment of loan limits for graduate and professional students and parent borrowers, termination of graduate and professional plus loans. Subtitle C, loan repayment. Section 82001, loan repayment. Section 82002, deferment, forbearance. Section 82003, loan rehabilitation. Section 82004, public service loan forgiveness. Section 82005, student loan servicing. Subtitle D, Pell Grants. Section 83001, eligibility. Section 83002, workforce Pell Grants. Section 83003, Pell shortfall. Section 83004, federal Pell Grants exclusion relating to other grant aid. Subtitle E, accountability. Section 84001, ineligibility based on low earnings outcomes. Subtitle F, regulatory relief. Section 85001, delay of rule relating to borrower defense to repayment. Section 85002, delay of rule relating to closed school discharges. Subtitle G, limitation on authority. Section 86001, limitation on proposing or issuing regulations and executive actions. Subtitle H, Garden of Heroes. Section 87001, Garden of Heroes.
Subtitle 1, Office of Refugee Resettlement, Section 88001, Potential Sponsor Vetting for Unaccompanied Alien Children Appropriation. Title 9, Committee on Homeland Security and Governmental Affairs. Subtitle A, Homeland Security Provisions. Section 90001, Border Infrastructure and Wall System. Section 90002, U.S. Customs and Border Protection personnel, fleet vehicles, and facilities. Section 90003, detention capacity. Section 90004, border security, technology, and screening. Section 90005, state and local assistance. Section 90006, Presidential Residence Protection. Section 90007, Department of Homeland Security Appropriations for Border Support. Subtitle B, Governmental Affairs Provisions. Section 90101, FEHB Improvements. Section 90102, Pandemic Response Accountability Committee. Section 90103, Appropriation for the Office of Management and Budget. Title 10, Committee on the Judiciary. Subtitle A, Immigration and Law Enforcement Matters. Part 1, Immigration Fees. Section 100001, Applicability of the Immigration Laws. Section 100002, Asylum Fee. Section 100003, Employment Authorization Document Fees. Section 100004, Immigration Parole Fee. Section 100005, Special Immigrant Juvenile Fee. Section 100006, Temporary Protected Status Fee. Section 100007, Visa Integrity Fee. Section 100008, Form I-94 Fee. Section 100009, Annual Asylum Fee. Section 100010, Fee relating to renewal and extension of employment authorization for parolees. Section 100011, Fee relating to renewal or extension of employment authorization for asylum applicants. Section 100012, Fee relating to renewal and extension of employment authorization for aliens granted temporary protected status. Section 100013, Fees relating to applications for adjustment of status. Section 100014, Electronic System for Travel Authorization Fee. Section 100015, Electronic Visa Update System Fee. Section 100016, Fee for aliens ordered removed in absentia. Section 100017, Inadmissible Alien Apprehension Fee. Section 100018, Amendment to Authority to Apply for Asylum. Part 2, Immigration and Law Enforcement Funding. Section 100051, Appropriation for the Department of Homeland Security. Section 10052, Appropriation for U.S. Immigration and Customs Enforcement. Section 10053, Appropriation for Federal Law Enforcement Training Centers. Section 10054, Appropriation for the Department of Justice. Section 10055, Bridging Immigration-Related Deficits Experienced Nationwide Reimbursement Fund. Section 10056, Appropriation for the Bureau of Prisons. Section 10057, Appropriation for the United States Secret Service. Subtitle B, Judiciary Matters. Section 100101, Appropriation to the Administrative Office of the United States Courts. Section 100102, Appropriation to the Federal Judicial Center. Subtitle C, Radiation Exposure Compensation Matters. Section 100201, Extension of Fund. Section 100202, Claims relating to atmospheric testing. Section 100203, Claims relating to uranium mining. Section 100205, Limitations on Claims. Title 1, Committee on Agriculture, Nutrition, and Forestry. Subtitle A, Nutrition. Section 10101, Reevaluation of Thrifty Food Plan. A, in general, Section 3 of the Food and Nutrition Act of 2008, 7 U.S.C. 2012 is amended by striking subsection U and inserting the following. U, Thrifty Food Plan. 1, in general, the term Thrifty Food Plan means a diet required to feed a family of 4 persons consisting of a man and a woman ages 20 through 50, a child ages 6 through 8, and a child ages 9 through 11, using the items and quantities of food described in the report of the Department of Agriculture entitled Thrifty Food Plan 2021, and each successor report updated pursuant to this subsection, subject to the conditions that A, the relevant market baskets of the Thrifty Food Plan shall only be changed pursuant to paragraph 4. B, the cost of the Thrifty Food Plan shall be the basis for uniform allotments for all households regardless of the actual composition of the household. And C, the cost of the Thrifty Food Plan may only be adjusted in accordance with this subsection. 2, household adjustments. The Secretary shall make household adjustments using the following ratios of household size as a percentage of the maximum four-person allotment. A, for a one-person household, 30%. B, for a two-person household, 55%. C, for a three-person household, 79%. D, for a four-person household, 100%. E, for a five-person household, 119%. F, for a six-person household, 143%. G, for a seven-person household, 158%. H, for an eight-person household, 180%. I, for a household of 9 persons or more, an additional 22% per person, which additional percentage shall not total more than 200%. 3, allowable cost adjustments. The Secretary shall, A, make cost adjustments in the Thrifty Food Plan for Hawaii and the urban and rural parts of Alaska to reflect the cost of food in Hawaii and urban and rural Alaska. B, make cost adjustments in the separate Thrifty Food Plans for Guam and the Virgin Islands of the United States to reflect the cost of food in those states, but not to exceed the cost of food in the 50 states and the District of Columbia. And C, on October 1st, 2025, and on each October 1st thereafter, adjust the cost of the Thrifty Food Plan to reflect changes in the Consumer Price Index for all urban consumers published by the Bureau of Labor Statistics of the Department of Labor for the most recent 12-month period ending in June. 4, reevaluation of market baskets. A, reevaluation. Not earlier than October 1st, 2027, the Secretary may reevaluate the market baskets of the Thrifty Food Plan based on current food prices, food composition data, consumption patterns, and dietary guidance. B, cost neutrality. The Secretary shall not increase the cost of the Thrifty Food Plan based on a reevaluation under this paragraph. B, conforming amendments. 1, Section 16C1A22 of the Food and Nutrition Act of 2008, 7 U.S.C. 2025 C1A22 is amended by striking Section 3U4 and inserting Section 3U3. 2, Section 19A2A2 of the Food and Nutrition Act of 2008, 7 U.S.C. 2028A2A2 is amended by striking Section 3U4 and inserting Section 3U3. 3, Section 27A2 of the Food and Nutrition Act of 2008, 7 U.S.C. 2036A2 is amended by striking Section 3U4, each place it appears, and inserting Section 3U3. Section 1012, modifications to SNAP work requirements for able-bodied adults. A, exceptions. Section 6.0 of the Food and Nutrition Act of 2008, 7 U.S.C. 20150 is amended by striking paragraph 3 and inserting the following. 3, exceptions. Paragraph 2 shall not apply to an individual if the individual is A, under 18 or over 65 years of age, B, medically certified as physically or mentally unfit for employment, C, a parent or other member of a household with responsibility for a dependent child under 14 years of age, D, otherwise exempt under subsection D2, E, a pregnant woman, F, an Indian or urban Indian, as such terms are defined in paragraphs 13 and 28 of Section 4 of the Indian Healthcare Improvement Act, or G, a California Indian described in Section 809A of the Indian Healthcare Improvement Act. B, standardizing enforcement. Section 604 of the Food and Nutrition Act of 2008, 7 USC 201504 is amended, 1, in subparagraph A by striking clause 2 and inserting the following. 2, is in a non-contiguous state and has an unemployment rate that is at or above 1.5 times the national unemployment rate, 8%, and 2, by adding at the end the following. C, definition of non-contiguous state. 1, in general, in this paragraph, the term non-contiguous state means a state that is not one of the contiguous 48 states or the District of Columbia. 2, exclusion. The term non-contiguous state does not include Guam or the Virgin Islands of the United States. C, waiver for non-contiguous states. Section 60 of the Food and Nutrition Act of 2008, 7 USC 2015 is amended, 1, by redesignating paragraph 7 as paragraph 8, and 2, by inserting after paragraph 6 the following. 7, exemption for non-contiguous states. A, definition of non-contiguous state. 1, in general, in this paragraph, the term non-contiguous state means a state that is not one of the contiguous 48 states or the District of Columbia. 2, exclusions. In this paragraph, the term non-contiguous state does not include Guam or the Virgin Islands of the United States. B, exemption. Subject to subparagraph D, the Secretary may exempt individuals in a non-contiguous state from compliance with the requirements of paragraph 2 if 1, the state agency submits to the Secretary a request for that exemption made in such form and at such time as the Secretary may require, and including the information described in subparagraph C, and 2, the Secretary determines that based on that request, the state agency is demonstrating a good faith effort to comply with the requirements of paragraph 2. C, good faith effort determination. In determining whether a state agency is demonstrating a good faith effort or for purposes of subparagraph B2, the Secretary shall consider 1, any action taken by the state agency toward compliance with the requirements of paragraph 2, 2, any significant barriers to or challenges in meeting those requirements, including barriers or challenges relating to funding, design, development, procurement, or installation of necessary systems or resources. 3, the detailed plan and timeline of the state agency for achieving full compliance with those requirements, including any milestones as defined by the Secretary. And 4, any other criteria determined appropriate by the Secretary. D, duration of exemption. 1, in general, an exemption granted under subparagraph B shall expire not later than December 31st, 2028, and may not be renewed beyond that date. 2, early termination. The Secretary may terminate an exemption granted under subparagraph B prior to that expiration date of that exemption if the Secretary determines that the state agency, 1, has failed to comply with the reporting requirements described in subparagraph E, or 2, based on the information provided pursuant to subparagraph E, failed to make continued good faith efforts towards compliance with the requirements of this subsection. E, reporting requirements. A state agency granted an exemption under subparagraph B shall submit to the Secretary 1, quarterly progress reports on the status of the state agency in achieving the milestones toward full compliance described in subparagraph C3, and 2, information on specific risks or newly identified barriers or challenges to full compliance, including the plan of the state agency to mitigate those risks, barriers, or challenges. Section 10103, availability of standard utility allowances based on receipt of energy assistance. A, standard utility allowance. Section 5E 6C 4I of the Food and Nutrition Act of 2008, 7 USC 2014 E6C 4I is amended by inserting with an elderly or disabled member after households. B, third-party energy assistance payments. Section 5K4 of the Food and Nutrition Act of 2008, 7 USC 2014 K4 is amended, 1, in subparagraph A by inserting without an elderly or disabled member before shall be, and 2, in subparagraph B by inserting with an elderly or disabled member before under a state law. Section 10104, restrictions on internet expenses. Section 5E6 of the Food and Nutrition Act of 2008, 7 U.S.C. 2014 E6, is amended by adding at the end of the following. E, restrictions on internet expenses. Any service fee associated with internet connection shall not be used in computing the excess shelter expense deduction under this paragraph. Section 10105, matching funds requirements. A, in general, Section 4A of the Food and Nutrition Act of 2008, 7 U.S.C. 2013a, is amended, 1, by striking A subject to and inserting the following. A, program. 1, establishment subject to, and 2, by adding at the end the following. 2, state quality control incentive. A, definition of payment error rate. In this paragraph, the term payment error rate has the meaning given the term in Section 16C2. B, state cost share. 1, in general, beginning in fiscal year 2028, if the payment error rate of a state is determined under Clause 2 is 1, less than 6%, the federal share of the cost of the allotment described in paragraph 1 for that state in a fiscal year shall be 100%, and the state share shall be 0%. 2, equal to or greater than 6%, but less than 8%. The federal share of the cost of the allotment described in paragraph 1 for that state in a fiscal year shall be 95%, and the state share shall be 5%. 3, equal to or greater than 8%, but less than 10%. The federal share of the cost of the allotment described in paragraph 1 for that state in a fiscal year shall be 90%, and the state share shall be 10%. And 4, equal to or greater than 10%. The federal share of the cost of the allotment described in paragraph 1 for that state in a fiscal year shall be 85%, and the state share shall be 15%. 2, elections. 1, fiscal year 2028. For fiscal year 2028, to calculate the applicable state share under Clause 1, a state may elect to use the payment error rate of the state from fiscal year 2025 or 2026. 2, fiscal year 2029 and thereafter. For fiscal year 2029 and each fiscal year thereafter, to calculate the applicable state share under Clause 1, the Secretary shall use the payment error rate of the state for the third fiscal year preceding the fiscal year for which the state share is being calculated. 3, maximum federal payment. The Secretary may not pay towards the cost of an allotment described in paragraph 1 an amount that is greater than the applicable federal share under paragraph 2. 4, waiver authority. A, in general, the Secretary may waive the requirement under paragraph 2 for a non-contiguous state excluding Guam and the Virgin Islands of the United States for a period of not more than 2 years if, 1, the Secretary determines that the waiver is necessary, and 2, the non-contiguous state is 1, actively implementing a corrective action plan as described in Section 275.17 of Title VII Code of Federal Regulations or a successor regulation, and 2, carrying out any other activities determined necessary by the Secretary to reduce its payment error rate as defined in paragraph 2. B, termination of authority. The waiver authority under subparagraph A shall terminate on the date that is 4 years after the date of enactment of this paragraph. B, limitation on authority. Section 13A1 of the Food and Nutrition Act of 2008, 7 U.S.C. 2022A1 is amended in the first sentence by inserting or the payment or disposition of a state share under Section 4A2 after 16C1D12. Section 10106, administrative cost sharing. Section 16A of the Food and Nutrition Act of 2008, 7 U.S.C. 2025A, is amended in the matter preceding paragraph 1 by striking agency an amount equal to 50 per centum and inserting agency through fiscal year 2026, 50%, and for fiscal year 2027 and each fiscal year thereafter, 25%. Section 10107, National Education and Obesity Prevention Grant Program. Section 28D1F of the Food and Nutrition Act of 2008, 7 U.S.C. 2036A D1F is amended by striking for fiscal year 2016 and each subsequent fiscal year, and inserting for each of fiscal years 2016 through 2025. Section 10108, Alien SNAP eligibility. Section 6F of the Food and Nutrition Act of 2008, 7 U.S.C. 2015F, is amended to read as follows. F, no individual who is a member of a household otherwise eligible to participate in the Supplemental Nutrition Assistance Program under this section shall be eligible to participate in the Supplemental Nutrition Assistance Program as a member of that or any other household unless he or she is, 1, a resident of the United States, and 2, either A, a citizen or national of the United States, B, an alien lawfully admitted for permanent residence as an immigrant as defined by sections 101A15 and 101A20 of the Immigration and Nationality Act, excluding, among others, alien visitors, tourists, diplomats, and students who enter the United States temporarily with no intention of abandoning their residence in a foreign country. C, an alien who has been granted the status of Cuban and Haitian entrant as defined in Section 501E of the Refugee Education Assistance Act of 1980, Public Law 96-422, or D, an individual who lawfully resides in the United States in accordance with a compact of free association referred to in Section 402B2G of the Personal Responsibility and Work Opportunity Reconciliation Act of 1996. The income less at state option or a pro rata share and financial resources of the individual rendered ineligible to participate in the Supplemental Nutrition Assistance Program under this subsection shall be considered in determining the eligibility and the value of the allotment of the household of which such individual is a member. Subtitle B, Forestry. Section 10201, Rescission of Amounts for Forestry. The unobligated balances of amounts appropriated by the following provisions of Public Law 117-169 are rescinded. 1. Paragraphs 3 and 4 of Section 23001, A, 136, Stat 2023. 2. Paragraphs 1 through 4 of Section 23002A, 136, Stat 2025. 3. Section 23003, A2, 136, Stat 2026. 4. Section 23005, 136, Stat 2027. Subtitle C, Commodities. Section 10301, Effective Reference Price, A, Effective Reference Price. Section 11118B2 of the Agricultural Act of 2014, 7 U.S.C. 90118B2 is amended by striking 85 and inserting beginning with the crop year 2025, 88. B, Reference Price. Section 1111 of the Agricultural Act of 2014, 7 U.S.C. 9011, is amended by striking paragraph 19 and inserting the following. 19, Reference Price. A, in general, effective beginning with the 2025 crop year, subject to subparagraphs B and C, the term reference price with respect to a covered commodity for a crop year means the following. 1, for wheat, $6.35 per bushel. 2, for corn, $4.10 per bushel. 3, for grain, sorghum, $4.40 per bushel. 4, for barley, $5.45 per bushel. 5, for oats, $2.65 per bushel. 6, for long grain rice, $16.90 per hundredweight. 7, For medium grain rice, $16.90 per hundredweight. 8, for soybeans, $10 per bushel. 9, for other oil seeds, $23.75 per hundredweight. 10, for peanuts, $630 per ton. 11, for dry peas, $13.10 per hundredweight. 12, for lentils, $23.75 per hundredweight. 13, for small chickpeas, $22.65 per hundredweight. 14, for large chickpeas, $25.65 per hundredweight. 15, for seed cotton, 42 cents per pound. B, effectiveness. Effective beginning with the 2031 crop year, the reference price is defined in subparagraph A with respect to a covered commodity shall equal the reference price in the previous crop year multiplied by 1.005. C, limitation. In no case shall a reference price for a covered commodity exceed 113% of the reference price for such covered commodity listed in subparagraph A. Section 10302, base acres. Section 1112 of the Agricultural Act of 2014, 7 U.S.C. 9012, is amended, 1, in subsection D3A by striking 2023 and inserting 2031, and by adding at the end of the following. E, additional base acres. 1, in general, as soon as practicable after the date of enactment of this subsection and notwithstanding subsection A, the Secretary shall provide notice to owners of eligible farms pursuant to paragraph 3 and allocate to those eligible farms a total of not more than an additional 30 million base acres in the manner provided in this subsection. An owner of a farm that is eligible to receive an allocation of base acres may elect to not receive that allocation by notifying the Secretary not later than 90 days after receipt of the notice provided by the Secretary under this paragraph. 2, content of notice. The notice under paragraph 1 shall include the following. A, information that the allocation is occurring. B, information regarding the eligibility of the farm for an allocation of base acres under paragraph 3. C, information regarding how an owner may appeal a determination of ineligibility for an allocation of base acres under paragraph 3.
Through an appeals process established by the Secretary. 3, eligibility. A, in general, subject to subparagraph D, effective beginning with the 2026 crop year, a farm is eligible to receive an allocation of base acres if, with respect to the farm, the amount described in subparagraph B exceeds the amount described in subparagraph C. B, 5-year average sum. The amount described in this subparagraph with respect to a farm is the sum of I, the 5-year average of I, the acreage planted on the farm to all covered commodities for harvest, grazing, haying, silage, or other similar purposes for the 2019 through 2023 crop years. And 2, any acreage on the farm that the producers were prevented from planting during the 2019 through 2023 crop years to covered commodities because of drought, flood, or other natural disaster, or other conditions beyond the control of the producers as determined by the Secretary, plus 2, the lesser of 1, subsection 1, 15% of the total acres on the farm, and 2, the 5-year average of AA, the acreage planted on the farm to eligible non-covered commodities for harvest, grazing, haying, silage, or other similar purposes for the 2019 through 2023 crop years, and subsection BB, any acreage on the farm that producers were prevented from planting during the 2019 through 2023 crop years to eligible non-covered commodities because of drought, flood, or other natural disaster, or other condition beyond the control of the producers, as determined by the Secretary. C, total number of base acres for covered commodities. The amount described in this subparagraph with respect to a farm is the total number of base acres for covered commodities on the farm, excluding unassigned crop base, as in effect on September 30, 2024. D, effect of no recent plantings of covered commodities in the case of a farm for which the amount determined under Clause I of subparagraph B is equal to 0. That farm shall be ineligible to receive an allocation of base acres under the subsection. E, acreage planted on the farm to eligible non-covered commodities defined in this paragraph. The term acreage planted on the farm to eligible non-covered commodities means acreage planted on a farm to commodities other than covered commodities, trees, bushes, vines, grass, or pasture, including cropland that was idle or fallow, as defined by the Secretary. 4, number of base acres, subject to paragraphs 3 and 8. The number of base acres allocated to an eligible farm shall, subsection A, be equal to the difference obtained by subtracting the amount determined under subparagraph C of paragraph 3 from the amount determined under subparagraph B of that paragraph, and B, include unassigned crop base. 5, allocation of acres. A, allocation. The Secretary shall allocate the number of base acres under paragraph 4 among those covered commodities planted on the farm at any time during the 2019 through 2023 crop years. B, allocation formula. The allocation of additional base acres for covered commodities shall be in proportion to the ratio of subsection I, the 5-year average of I, the acreage planted on the farm to each covered commodity for harvest, grazing, haying, silage, or other similar purposes for the 2019 through 2023 crop years. And 2, any acreage on the farm that producers were prevented from planting during the 2019 through 2023 crop years to that covered commodity because of drought, flood, or other natural disaster, or other condition beyond the control of the producers as determined by the Secretary to the 5-year average determined under paragraph 3BI. Inclusion of all 5 years in average. For the purpose of determining a 5-year acreage average under subparagraph B for a farm, the Secretary shall not exclude any crop year in which a covered commodity was not planted. D, treatment of multiple planting or prevented planting. For the purpose of determining under subparagraph B the acreage on a farm that producers planted or were prevented from planting during the 2019 through 2023 crop years to covered commodities, if the acreage that was planted or prevented from being planted was devoted to other covered commodity in the same crop year, other than a covered commodity produced under an established practice of double cropping, the owner may elect the covered commodity to be used for that year in determining the 5-year average, but may not include both the initial covered commodity and the subsequent covered commodity. E, limitation. The allocation of additional base acres among covered commodities on a farm under this paragraph may not result in a total number of base acres for the farm in excess of the number of acres on the farm. 6, reduction by the Secretary. In carrying out this subsection, if the total number of eligible acres allocated to base acres across all farms in the United States under this subsection would exceed 30 million acres, the Secretary shall apply an across-the-board prorated reduction to the number of eligible acres to ensure the number of allocated base acres under this subsection is equal to 30 million acres. 7, payment yield. Beginning with crop year 2026, for the purpose of making price loss coverage payments under section 1116, the Secretary shall establish payment yields to base acres allocated under this subsection equal to A, the payment yield established on the farm for applicable covered commodity, and B, if no such payment yield for the applicable covered commodity exists, a payment yield equal to the average payment yield for the covered commodity for the county in which the farm is situated, or to determine pursuant to section 1113C. 8, treatment of new owners. In the case of a farm for which the owner on the date of enactment of this subsection was not the owner for the 2019 through 2023 crop years, the Secretary shall use the planting history of the prior owner or owners of that farm for the purposes of determining A, eligibility under paragraph 3, B, eligibility acres under paragraph 4, and C, the allocation of acres under paragraph 5. Section 10303, producer election. A, in general section 1115 of the Agricultural Act of 2014, 7 U.S.C. 9015 is amended 1, in subsection A, in the matter preceding paragraph 1, by striking 2023 and inserting 2031. 2, in subsection C, A, in the matter preceding paragraph 1, I, by striking crop year or and inserting crop year, and 2, by inserting or the 2026 crop year after 2019 crop year. B, in paragraph 1, I, by striking crop year or and inserting crop year, and II, by inserting or the 2026 crop year after 2019 crop year. And C, in paragraph 2, I, in subparagraph A, by striking and at the end, II. In subparagraph B, by striking the period at the end and inserting and. And 3, by adding at the end the following. C, the same coverage for each covered commodity on the farm for the 2027 through 2031 crop years as was applicable for the 2025 crop year. And 3, by adding at the end the following. 1, higher of price loss coverage payments and agricultural risk coverage payments. For the 2025 crop year, the Secretary shall, on a covered commodity by covered commodity basis, make the higher of price loss coverage payments under Section 1116 and agricultural risk covered county coverage payments under Section 1117 to the producers on a farm for the payment acres for each covered commodity on the farm. B, federal crop insurance supplemental coverage options. Section 508C4C4IV of the Federal Crop Insurance Act 7 U.S.C. 1508 C4 CIV is amended by striking crops for which the producer has elected under Section 1116 of the Agricultural Act of 2014 to receive agricultural risk coverage in acres and inserting acres. Section 10304 price loss coverage. Section 1116 of the Agricultural Act of 2014, 7 U.S.C. 9016 is amended. 1, in subsection A2, in the matter preceding subparagraph A by striking 2023 and inserting 2031. 2, in subsection C1B, A, in the subparagraph heading by striking 2023 and inserting 2031. And B, in the matter preceding clause I by striking 2023 and inserting 2031. 3, in subsection D, in the matter preceding paragraph 1 by striking 2025 and inserting 2031. And 4, in subsection G, A, by striking subparagraph F of section 111119 and inserting paragraph 19A VI of section 1111. And B, by striking 2012 through 2016, each place it appears, and inserting 2017 through 2021. Section 10305, agricultural risk coverage. Section 1117 of the Agricultural Act of 2014, 7 U.S.C. 9017 is amended. 1, in subsection A, in the matter preceding paragraph 1 by striking 2023 and inserting 2031. 2, in subsection C, A, in paragraph 1 by inserting for each of the 2014 through 2024 crop years and 90% of the benchmark revenue for each of the 2025 through 2031 crop years before the period at the end. B, by striking 2023, each place it appears, and inserting 2031. And C, in paragraph 4B, in the subparagraph heading, by striking 2023 and inserting 2031. 3, in subsection D1, by striking subparagraph B and inserting the following. BI, for each of the 2014 through 2024 crop years, 10% of the benchmark revenue for the crop year applicable under subsection C and II. For each of the 2025 through 2031 crop years, 12% of the benchmark revenue for the crop year applicable under subsection C and 4 in subsections E, G5, and I5 by striking 2023, each place it appears, and inserting 2031. Section 10306, equitable treatment of certain entities. A, in general, Section 1001 of the Food Security Act of 1985, 7 U.S.C. 1308, is amended. 1, in subsection A, by designated paragraph 5 as paragraph 6, and B, by inserting after paragraph 4 the following. 5, qualified pass-through entity. The term qualified pass-through entity means A, a partnership within the meaning of subchapter K of Chapter 1 of the Internal Revenue Code of 1986. B, an S corporation as defined in Section 1361 of that code. C, a limited liability company that does not affirmatively elect to be treated as a corporation. And D, a joint venture or general partnership. 2, in subsections B and C by striking except a joint venture or general partnership, each place it appears, and inserting except a qualified pass-through entity, and 3, in subsection D by striking subtitle B of Title I of the Agricultural Act of 2014, or B, attribution of payment, section 1001E3BII of the Food Security Act of 1985, 7 U.S.C. 1308E3BII is amended. 1, in the clause heading by striking joint ventures and general partnerships and inserting qualified pass-through entities. 2, by striking a joint venture or a general partnership and inserting a qualified pass-through entity. 3, by striking joint ventures and general partnerships and inserting qualified pass-through entities. And 4, by striking the joint venture or general partnership and inserting the qualified pass-through entity. C, persons actively engaged in farming. Section 1001AB2 of the Food Security Act of 1985, 7 U.S.C. 1308 1B2 is amended. 1, subparagraphs A and B by striking a general partnership, a participant in a joint venture, each place it appears, and inserting a qualified pass-through entity. And 2, in subparagraph C by striking a general partnership, joint venture, or similar entity and inserting a qualified pass-through entity or a similar entity. D, joint and several liability. Section 100BD of the Food Security Act of 1985, 7 U.S.C. 1308-2D is amended by striking partnerships and joint ventures and inserting qualified pass-through entities. E, exclusion from AGI calculation. Section 1001D of the Food Security Act of 1985, 7 U.S.C. 1308-3AD is amended by striking general partnership or joint venture, each place it appears. Section 10307, payment limitations. Section 1001 of the Food Security Act of 1985, 7 U.S.C. 1308 is amended. 1, in subsection B, A, by striking the and inserting subject to subsection I, the, and B, by striking $125,000 and inserting $155,000. And 2, in subsection C, A, by striking the and inserting subject to subsection I, the, and B, by striking $125,000 and inserting $155,000. And 3, by adding at the end the following. I, adjustment for the 2025 crop year and each crop year thereafter. The Secretary shall annually adjust the amounts described in subsections B and C for inflation based on the Consumer Price Index for all urban consumers published by the Bureau of Labor Statistics of the Department of Labor. Section 10308, adjusted gross income limitation. Section 1001DB of the Food Security Act of 1985, 7 U.S.C. 1308-3AB is amended. 1, in paragraph 1 by striking paragraph 3 and inserting paragraphs 3 and 4. And 2, by adding at the end the following. 4, exception for certain operations. A, definitions. In this paragraph, I, accepts payment or benefit. The term accepted payment or benefit means I, a payment or benefit under subtitle E of Title I of the Agricultural Act of 2014, 7 U.S.C. 908 at sequence. 2, a payment or benefit under Section 19 Rural Agricultural Improvement and Reform Act of 1996, 7 U.S.C. 7333, and 3, a payment or benefit described in paragraph 2C received on or after October 1st, 2024. II, farming, ranching, or silviculture activities. The term farming, ranching, or silviculture activities include agritourism, direct-to-consumer marketing of agricultural products, the sale of agricultural equipment owned by the person or legal entity, and other agricultural-related activities as determined by the Secretary. B, exception. In the case of an accepted payment or benefit, the limitation established by paragraph 1 shall not apply to a person or legal entity during a crop, fiscal, or program year as appropriate, if greater than or equal to 75% of the average gross income of the person or legal entity derives from farming, ranching, or silviculture activities. Section 10309, marketing loans. A, availability of non-recourse marketing assistance loans for loan commodities. Section 1201B1 of the Agricultural Act of 2014, 7 U.S.C. 9031B1 is amended by striking 2023 and inserting 2031. B, loan rates for non-recourse marketing assistance loans. Section 1202 of the Agricultural Act of 2014, 7 U.S.C. 9032 is amended 1 in subsection B. A, in the subsection heading by striking 2023 and inserting 2025, and B, in the matter preceding paragraph 1 by striking 2023 and inserting 2025. 2, by redesignating subsection C and D as subsections D and E respectively. 3, by inserting after subsection B the following. C, 2026 through 2031 crop years. For the purposes of each of the 2026 through 2031 crop years, the loan rate for a marketing assistance loan under Section 1201 for a loan commodity shall be equal to the following. 1, in the case of wheat, $3.72 per bushel. In the case of corn, $2.42 per bushel. In the case of grain sorghum, $2.42 per bushel. 4, in the case of barley, $2.75 per bushel. 5, in the case of oats, $2.20 per bushel. 6, in the case of upland cotton, 55 cents per pound. 7, in the case of extra long staple cotton, $1 per pound. In the case of long grain rice, $7.70 per hundredweight. 9, in the case of medium grain rice, $7.70 per hundredweight. 10, in the case of soybeans, $6.82 per bushel. 11, in the case of other oil seeds, $11.10 per hundredweight for each of the following kinds of oil seeds. A, sunflower seed. B, rapeseed. C, canola. D, safflower. E, flaxseed. F, mustard seed. G, cranberry. H, sesame seeds. I, other oil seeds designated by the Secretary. 12, in the case of dry peas, $6.87 per hundredweight. 13, in the case of lentils, $14.30 per hundredweight. 14, in the case of small chickpeas, $11 per hundredweight. 15, in the case of large chickpeas, $15.40 per hundredweight. 16, in the case of grated wool, $1.60 per pound. 17, in the case of non-grated wool, 55 cents per pound. 18, in the case of mohair, $5 per pound. 19, in the case of honey, $1.50 per pound. 20, in the case of peanuts, $390 per ton. 4, in subsection D, as so redesignated by striking A11 and B11 and inserting A11, B11, and C11, and 5, in subsection E, as so redesignated in paragraph 1 by striking 25 cents and inserting 30 cents. C, payment of cotton storage costs. Section 1204G of the Agricultural Act of 2014, 7 U.S.C. 9034G is amended 1 by striking effective and inserting the following. 1, crop years 2014 through 2025, effective. 2, in paragraph 1, as so designated by striking 2023 and inserting 2025. And 3, by adding at the end the following. 2, payment of cotton storage costs effective for each of the 2026 through 2031 crop years. The Secretary shall make cotton storage payments for upland cotton and extra long staple cotton available in the same manner as the Secretary provided storage payments for the 2006 crop of upland cotton, except that the payment rate shall be equal to the lesser of A, the submitted storage charge for the current marketing year, and B, in the case of storage in I, California or Arizona, a payment rate of $4.90, and 2, II, any other state, a payment rate of $3. D, loan deficiency payments. 1, continuation. Section 1205A2B of the Agricultural Act of 2014, 7 U.S.C. 9035A2B is amended by striking 2023 and inserting 2031. 2, payments in lieu of LDPS. Section 1206 of the Agricultural Act of 2014, 7 U.S.C. 9036 is amended in subsections A and D by striking 2023, each place it appears, and inserting 2031. E, special competitive provisions for extra long staple cotton. Section 1208A of the Agricultural Act of 2014, 7 U.S.C. 9038A is amended in the matter preceding paragraph 1 by striking 2026 and inserting 2032. F, availability of recourse loans. Section 1209 of the Agricultural Act of 2014, 7 U.S.C. 9039 is amended in subsections A, 2, B, and C by striking 2023, each place it appears, and inserting 2031. Section 310, repayment of marketing loans. Section 1204 of the Agricultural Act of 2014, 7 U.S.C. 9034 is amended 1 in subsection B, A, by redesignating paragraph 1 as subparagraph A and indenting appropriately. B, in the matter preceding subparagraph A, as so redesignated by striking the Secretary and inserting the following. 1, in general, the Secretary, and C, by striking paragraph 2 and inserting the following. BI, in the case of long grain rice and medium grain rice, the prevailing world market price for the commodity as determined and adjusted by the Secretary in accordance with this section, or II, in the case of upland cotton, the prevailing world market price for the commodity as determined and adjusted by the Secretary in accordance with this section. 2, refund for upland cotton. In the case of repayment for a marketing assistance loan for upland cotton at a rate described in paragraph 1 BII, the Secretary shall provide the producer a refund, if any, in an amount equal to the difference between the lowest prevailing world market price as determined and adjusted by the Secretary in accordance with this section during the 30-day period following the date on which the producer repays the marketing assistance loan, and the repayment rate. 2, in subsection C, A, by striking the period at the end and inserting semicolon, and B, by striking at the loan rate and inserting the following, at a rate that is lesser of 1, the loan rate, and C, by adding at the end the following. 2, the prevailing world market price for the commodity as determined and adjusted by the Secretary in accordance with this section. 3, subsection D, A, in paragraph 1, by striking and medium grain rice and inserting medium grain rice and extra long staple cotton. B, by redesignating paragraphs 1 and 2 as subparagraphs A and B respectively and indenting appropriately. C, in the matter preceding subparagraph A as so redesignated by striking for purposes and inserting the following. 1, in general, for purposes, and D, by adding at the end the following. 2, upland cotton. In the case of upland cotton, for any period when price quotations for middling M 3/32-inch cotton are available, the formula under paragraph 1A shall be based on the average of the 3 lowest price growths that are quoted. And 4, in subsection E, A, in the subsection heading by inserting extra long staple cotton and upland cotton. B, in paragraph 2I, in the paragraph heading by inserting upland before cotton, and 2 in subparagraph, and II in subparagraph B, in the matter preceding clause I by striking 2024 and inserting 2032. C, by redesignating paragraph 3 as paragraph 4, and D, by inserting after paragraph 2 the following. 3, extra long staple cotton. The prevailing world market price for extra long staple cotton determined under subsection D, A, shall be adjusted to United States quality and location, with the adjustment to include the average cost to market the commodity, including average transportation cost, as determined by the Secretary, and B, may be further adjusted during the period beginning on the date of enactment of the act entitled An Act to Provide for Reconciliation pursuant to Title II of H. Con. Res. 14, 119th Congress, and ending on July 31st, 2032. If the Secretary determines the adjustment is necessary, I, to minimize potential loan forfeitures, I, to minimize the accumulation of stocks of extra long staple cotton by the federal government, I, to ensure that extra long staple cotton produced in the United States can be marketed freely and competitively, and IV, to ensure an appropriate transition between current crop and forward crop price quotations, except that the Secretary may use forward crop price quotations prior to July 31st of a marketing year only if I, there are insufficient current crop price quotations, and I, the forward crop price quotation is the lowest such quotation available. Section 10.311, Economic Adjustment Assistance for Textile Mills. Section 1207C of the Agricultural Act of 2014, 7 U.S.C. 9037C, is amended by striking paragraph 2 and inserting the following. 2, value of assistance. The value of the assistance provided under paragraph 1 shall be A, for the period beginning on August 1st, 2013 and ending on July 31st, 2025, 3 cents per pound, and B, beginning on August 1st, 2025, 5 cents per pound. Section 10.312, Sugar Program Updates. A, loan rate modification. Section 156 of the Federal Agricultural Improvement and Reform Act of 1996, 7 U.S.C. 7272, is amended. 1, in subsection A, in paragraph 4 by striking and at the end, B, in paragraph 5 by striking 2023 crop years and inserting 2024 crop years, and C, by adding at the end the following. 6, 24 cents per pound for raw cane sugar for each of the 2025 through 2031 crop years. 2, in subsection B-A, in paragraph 1, by striking "and" at the end. B, in paragraph 2, by striking 2023 crop years and inserting 2024 crop years. And C, by adding at the end the following. 3, a rate that is equal to 136.55% of the loan rate per pound of raw cane sugar under subsection A6 for each of the 2025 through 2031 crop years. And 3, in subsection I, by striking 2023 and inserting 2031. B, adjustments to Commodity Credit Corporation storage rates. Section 167 of the Federal Agricultural Improvement and Reform Act of 1996, 7 U.S.C. 7287, is amended 1, by striking subsection A and inserting the following. A, in general, for the 2025 crop year and each subsequent crop year, the Commodity Credit Corporation shall establish rates for the storage of forfeited sugar in an amount that is not less than 1, in the case of refined sugar, 34 cents per hundredweight per month, and 2, in the case of raw cane sugar, 27 cents per hundredweight per month, and 2, in subsection B, A, in the subsection heading by striking subsequent and inserting prior, and B, by striking and subsequent and inserting through 2024. C, modernization beet sugar allotments. 1, sugar estimates. Section 359BA1 of the Agricultural Adjustment Act of 1938, 7 U.S.C. 1359BBA1 is amended by striking 2023 and inserting 2031. 2, allocation to the processors. Section 359CG2 of the Agricultural Adjustment Act of 1938, 7 U.S.C. 1359CCG2 is amended A by striking in the case and inserting the following. A, in general, except as provided in subparagraph B in the case, and B, by adding at the end the following. B, exception. If the Secretary makes an upward adjustment of paragraph 1A in adjusting allocations among beet sugar processors, the Secretary shall give priority to beet sugar processors with available sugar. 3, timing of reassignment. Section 359EB2 of the Agricultural Adjustment Act of 1938, 7 U.S.C. 1359EEB2 is amended A by redesignating subparagraphs A through C as clauses I through III, respectively, and indenting appropriately. B, in the matter preceding clauses I as so redesignated by striking if the Secretary and inserting the following. A, in general, if the Secretary, and C, by adding at the end the following. B, timing. In carrying out subparagraph A, the Secretary shall I make an initial determination based on the World Agricultural Supply and Demand estimates approved by the World Agricultural Outlook Board for January that shall be applicable to the crop year for which allotments are required, and II provide for an initial reassignment under subparagraph AI not later than 30 days after the date on which the World Agricultural Supply and Demand estimates described in Clause I is released. D, reallocations of tariff rate quota shortfall. Section 359K of the Agricultural Adjustment
Act of 1938, 7 U.S.C. 1359KK is amended by adding at the end the following. C, reallocation. 1, initial reallocation. Subject to paragraph 3, following the establishment of the tariff rate quotas under subsection A for a quota year, the Secretary shall, A, determine which countries do not intend to fulfill their allocation for the quota year, and B, reallocate any forecasted shortfall in the fulfillment of the tariff rate quotas as soon as practicable. 2, subsequent reallocation. Subject to paragraph 3, not later than March 1 of a quota year, the Secretary shall reallocate any additional forecasted shortfall in the fulfillment of the tariff rate quotas for raw cane sugar established under subsection A1 for that quota year. 3, cessation of effectiveness. Paragraphs 1 and 2 shall cease to be in effect if A, the agreement suspending the countervailing duty investigation on sugar from Mexico signed December 19, 2014 is terminated, and B, no countervailing duty order under Subtitle A of Title VII of the Tariff Act of 1930, 19 U.S.C. 1671 et sequitur, is in effect with respect to sugar from Mexico. D, refined sugar. 1, definition of domestic sugar industry. In this subsection, the Term domestic sugar industry means domestic A, sugar beet producers and processors, B, producers and processors of sugar cane, and C, refiners of raw cane sugar. 2, study required. A, in general, not later than 180 days after the date of enactment of this subsection, the Secretary shall conduct a study on whether the establishment of additional terms and conditions with respect to refined sugar imports is necessary and appropriate. B, elements. In conducting the study under subparagraph A, the Secretary shall examine the following. I, the need for 1, defining refined sugar as having a minimum polarization of 99.8 degrees or higher. 2, establishing a standard for color or reflectance-based units for refined sugar such as those utilized by the International Commission on Uniform Methods of Sugar Analysis. 3, prescribing specifications for packaging type for refined sugar. 4, prescribing specifications for transportation modes for refined sugar. 5, requiring evidence that sugar imported as refined sugar will not undergo further refining in the United States. 6, prescribing appropriate terms and conditions to avoid unlawful sugar imports. And 7, establishing other definitions, terms, and conditions or other requirements. II, the potential impact of modifications described in each of the subclauses 1 through 7 of Clause I of the domestic sugar industry. III, whether based on the needs described in Clause I and the impact described in Clause II, the establishment of additional terms and conditions is appropriate. C, consultation. In conducting the study under subparagraph A, the Secretary shall consult with representatives of the domestic sugar industry and users of refined sugar. D, report. Not later than 1 year after the date of enactment of this subsection, the Secretary shall submit to the Committee on Agriculture of the House of Representatives and the Committee on Agriculture, Nutrition, and Forestry of the Senate a report that describes the findings of the study conducted under subparagraph A. 3, establishment of additional terms and conditions permitted. A, in general, based on the findings in the report submitted under paragraph 2D, and after providing notice to the Committee on Agriculture of the House of Representatives and the Committee on Agriculture, Nutrition, and Forestry of the Senate, the Secretary may issue regulations in accordance with subparagraph B to establish additional terms and conditions with respect to refined sugar imports that are necessary and appropriate. B, promulgation of regulations. The Secretary may issue regulations under subparagraph A if the regulations, 1, do not have an adverse impact on the domestic sugar industry, and 2, are consistent with the requirements of this part, Section 156 of the Federal Agriculture Improvement and Reform Act of 1996, 7 U.S.C. 7272, and obligations under international trade agreements that have been approved by Congress. E, clarification of tariff rate quota adjustments. Section 359KB1 of the Agriculture Adjustment Act of 1938, 7 U.S.C. 1359KKB1 is amended in the matter preceding subparagraph A by striking "if there is N" and inserting "for the sole purpose of responding directly to N." F, period of effectiveness. Section 359LA of the Agriculture Adjustment Act of 1938, 7 U.S.C. 1359 LLA, is amended by striking 2023 and inserting 2031. Section 10313, Dairy Policy Updates. A, dairy margin coverage production history. 1, definition. Section 14018 of the Agricultural Act of 2014, 7 U.S.C. 9051-8, is amended by striking "when the participating dairy operation first registers to participate in dairy margin coverage." 2, production history of participating dairy operations. Section 1405 of the Agricultural Act of 2014, 7 U.S.C. 9055, is amended by striking subsections A and B and inserting the following. A, production history. except as provided under subsection B, the production history of a dairy operation for dairy margin coverage is equal to the highest annual milk marketings of the participating dairy operation during any one of the 2021, 2022, or 2023 calendar years. B, election by new dairy operations. In the case of a participating dairy operation that has been in operation for less than a year, the participating dairy operations shall elect one of the following methods for the Secretary to determine the production history of the participating dairy operation. 1, the volume of the actual milk marketings for the months the participating dairy operation has been in operation extrapolated to a yearly amount. 2, an estimate of the actual milk marketings of the participating dairy operation based on the herd size of the participating dairy operation relative to the national rolling herd average data published by the Secretary. B, dairy margin coverage payments. Section 1406A1C of the Agricultural Act of 2014, 7 U.S.C. 9056A1C, is amended by striking $5 million each place it appears and inserting $6 million. C, premiums for dairy margins. 1, Tier 1. Section 1407B of the Agricultural Act of 2014, 7 U.S.C. 9057B is amended. A, in the subsection heading by striking $5 million and inserting $6 million, and B, in paragraph 1 by striking $5 million and inserting $6 million. 2, Tier 2. Section 1407C of the Agricultural Act of 2014, 7 U.S.C. 9057C, is amended. A, in the subsection heading by striking $5 million and inserting $6 million, and B, in paragraph 1 by striking $5 million and inserting $6 million. 3, premium discounts. Section 1407G of the Agricultural Act of 2014, 7 U.S.C. 9057G, is amended. A, in paragraph 1 by striking 2019 through 2023 and inserting 2026 through 2031, and 2, by striking January 2019 and inserting January 2026, and B, in paragraph 2 by striking 2023 each place it appears and inserting 2031. D, duration. Section 1409 of the Agricultural Act of 2014, 7 U.S.C. 9059, is amended by striking 2025 and inserting 2031. Section 10314, implementation. Section 1614C of the Agricultural Act of 2015, 7 U.S.C. 9097C, is amended by adding at the end the following. 5, further funding. The Secretary shall make available to carry out Subtitle C of Title I of the Act entitled An Act to Provide for Reconciliation Pursuant to Title II of H. Con. Res. 14, 119th Congress, and the amendments made by that subtitle, $50 million to remain available until expended, of which, A, not less than $5 million shall be used to carry out paragraphs 3 and 4 of subsection B. B, $3 million shall be used for activities described in paragraph 3A. C, $3 million shall be used for activities described in paragraph 3B. D, $9 million shall be used, 1, to carry out mandatory surveys of dairy production costs and product yield information to be reported by manufacturers required to report under Section 273 of the Agricultural Marketing Act of 1946, 7 U.S.C. 1637B, for all products processed in the same facility or facilities, and 2, to publish the results of such surveys biennially, and E, $1 million shall be used to conduct the study under subsection D of Section 359K of the Agricultural Adjustment Act of 1938, 7 U.S.C. 1359KK. Subtitle D, Disaster Assistance Programs. Section 10401, Supplemental Agricultural Disaster Assistance. A, livestock indemnity payments. Section 1501B of the Agricultural Act of 2014, 7 U.S.C. 9081B is amended. 1, by striking paragraph 2 and inserting the following. 2, payment rates. A, losses due to predation. Indemnity payments to an eligible producer on a farm under paragraph 1A shall be made at a rate of 100% of the market value of the affected livestock on the applicable date as determined by the Secretary. B, losses due to adverse weather or disease. Indemnity payments to an eligible producer on a farm under subparagraph B or C of paragraph 1 shall be made at a rate of 75% of the market value of the affected livestock on the applicable date as determined by the Secretary. C, determination of market value. In determining the market value described in subparagraphs A and B, the Secretary may consider the ability of eligible producers to document regional price premiums for affected livestock that exceed the national average market price for those livestock. D, applicable date defined. In this paragraph, the term applicable date means, with respect to livestock, as applicable, 1, the day before the date of death of the livestock, or 2, the day before the date of the event that caused the harm of the livestock to the livestock that resulted in a reduced sale price. And 2, by adding at the end the following. 5, additional payment for unborn livestock. A, in general, in the case of unborn livestock death losses incurred on or after January 1, 2024, the Secretary shall make an additional payment to eligible producers on farms that have incurred such losses in excess of the normal mortality due to a condition specified in paragraph 1. B, payment rate. Additional payments under subparagraph A shall be made at a rate 1, determined by the Secretary, and 2, less than or equal to 85% of the payment rate established with respect to the lowest weight class of the livestock, as determined by the Secretary, acting through the administrator of the Farm Service Agency. C, payment amount. The amount of a payment to an eligible producer that has incurred unborn livestock death losses shall be equal to the payment rate determined under subparagraph B multiplied in the case of livestock described in 1, subparagraph A, B, or F of subsection A4 by 1, 2, subparagraph D of each subsection by 2, 3, subparagraph E of each subsection by 12, and 4, subparagraph G of such subsection by the average number of birthed animals for one gestation cycle for the species of such livestock as determined by the Secretary. D, unborn livestock death losses defined. In this paragraph, the term unborn livestock death losses means losses of any livestock described in subparagraph A, B, D, E, F, or G of subsection A4 that was gestating on the date of the death of the livestock. B, livestock forage disaster program. Section 1501 C3D21 of the Agricultural Act of 2014, 7 U.S.C. 9081 C3D21 is amended. 1, by striking 1 monthly payment and inserting 2 monthly payments. And 2, by striking county for at least 8 consecutive and inserting the following. County for not less than AA, 4 consecutive weeks during the normal grazing period for the county, as determined by the Secretary, shall be eligible to receive assistance under this paragraph in an amount equal to 1 monthly payment using the monthly payment rate determined under subparagraph B or BB, 7 of the previous 8 consecutive. C, emergency assistance for livestock, honeybees, and farm-raised fish. 1, in general, Section 1501D of the Agricultural Act of 2014, 7 U.S.C. 9081D, is amended by adding at the end the following. 5. Assistance for losses due to bird depredation. A. Definition of farm-raised fish. In this paragraph, the term farm-raised fish means fish propagated and reared in a controlled freshwater environment. B. Payments. Eligible producers of farm-raised fish, including fish grown as food for human consumption, shall be eligible to receive payments under this subsection to aid in the reduction of losses due to piscivorous birds. C. Payment rate. 1. In general, the payment rate for payments under subparagraph B shall be determined by the Secretary, taking into account 1. Costs associated with the deterrence of piscivorous birds. 2. The value of lost fish and revenue due to bird depredation. And 3. Costs associated with disease loss from bird depredation. 2. Minimum rate. The payment rate for payments under subparagraph B shall be not less than $600 per acre of farm-raised fish. D. Payment amount. The amount of a payment under subparagraph B shall be the product obtained by multiplying 1. The applicable payment rate under subparagraph C, and 2. 85% of the total number of acres of farm-raised fish that the eligible producer has in production for the calendar year. 2. Emergency assistance for honeybees. In determining honeybee colony losses eligible for assistance under Section 1501D of the Agricultural Act of 2014, 7 U.S.C. 9081D, the Secretary shall utilize a normal mortality rate of 15%. D. Tree Assistance Program. Section 1501E of the Agricultural Act of 2014, 7 U.S.C. 9081E, is amended 1. In paragraph 2B by striking 15%, adjusted for normal mortality, and inserting normal mortality. And 2. In paragraph 3, A, in subparagraph A1 by striking 15% mortality, adjusted for normal mortality, and inserting normal mortality. And B, in subparagraph B, 1, by striking 50 and inserting 65, and 2, by striking 15% damage or mortality, adjusted for normal tree damage and mortality, and inserting normal tree damage or mortality. Subtitle E, Crop Insurance. Section 10501, Beginning Farmer and Rancher Benefit. A, Definitions. 1. In general, Section 502B3 of the Federal Crop Insurance Act, 7 U.S.C. 1502B3, is amended by striking 5 and inserting 10. 2. Conforming amendment. Section 522C7 of the Federal Crop Insurance Act, 7 U.S.C. 1522C7, is amended by striking subparagraph F. B. Increase in assistance. Section 508E of the Federal Crop Insurance Act, 7 U.S.C. 1508E, is amended by adding at the end the following. 9. Additional support. A. In general, in addition to any other provision of this subsection, except paragraph 2A regarding payment of a portion of premiums, a beginning farmer or rancher shall receive additional premium assistance that is the number of percentage points specified in subparagraph B greater than the premium assistance that would otherwise be available for the applicable policy, plan of insurance, and coverage level selected by the beginning farmer or rancher. B. Percentage points adjustments. The percentage points referred to in subparagraph A are the following. 1. For each of the first and second reinsurance years that a beginning farmer or rancher participates as a beginning farmer or rancher in the applicable policy or plan of insurance, 5 percentage points. 2. For the third reinsurance year that a beginning farmer or rancher participates as a beginning farmer or rancher in the applicable policy or plan of insurance, 3 percentage points. 3. For the fourth reinsurance year that a beginning farmer or rancher participates as a beginning farmer or rancher in the applicable policy or plan of insurance, 1 percentage point. Section 10502, Area-Based Crop Insurance Coverage and Affordability. A. Coverage level. Section 508C4 of the Federal Crop Insurance Act, 7 U.S.C. 1508C4 is amended, 1, in subparagraph A by striking Clause 2 and inserting the following. 2, may be purchased at any level not to exceed 1, in the case of the individual yield or revenue coverage, 85%. 2, in the case of individual yield or revenue coverage aggregated across multiple commodities, 90%. And 3, in the case of area yield or revenue coverage as determined by the corporation, 95%. And 2, in subparagraph C. A, in Clause 2 by striking 14 and inserting 10. And B, in Clause 3(1) by striking 86 and inserting 90. B, premium subsidy. Section 508E2H1 of the Federal Crop Insurance Act, 7 U.S.C. 1508E2H1, is amended by striking 65 and inserting 80. Section 10503, administrative and operating expense adjustments. Section 508K of the Federal Crop Insurance Act, 7 U.S.C. 1508K, is amended by adding at the end the following. 10, additional expenses. A, in general, beginning with the 2026 reinsurance year and for each reinsurance year thereafter, in addition to the terms and conditions of the standard reinsurance agreement, to cover additional expenses for loss adjustment procedures, the corporation shall pay an additional administrative and operating expense subsidy to approved insurance providers for eligible contracts. B, payment amount. In the case of an eligible contract, the payment to an approved insurance provider required under subparagraph A shall be the amount equal to 6% of the net book premium. C, definitions. In this paragraph, 1, eligible contract. The term eligible contract, 1, means a crop insurance contract entered into by an approved insurance provider in an eligible state, and 2, does not include a contract for AA, catastrophic risk protection under subsection B, BB, an area-based plan of insurance or similar plan of insurance as determined by the corporation, or CC, a policy under which an approved insurance provider does not incur loss adjustment expenses as determined by the corporation. 2, eligible state. The term eligible state means a state in which, with respect to an insurance year, the loss ratio for eligible contracts is greater than 120% of the total net book premium written by all approved insurance providers. 11, specialty crops. A, minimum reimbursement. Beginning with the 2026 reinsurance year and for each reinsurance year thereafter, the rate of reimbursement to approved insurance providers and agents for administrative and operating expenses with respect to crop insurance contracts covering agricultural commodities described in Section 101 of the Specialty Crops Competitiveness Act of 2004, 7 U.S.C. 1621 Note, Public Law 108-465, shall be equal to or greater than the percentage that is the greater of the following. 1, 17% of the premium used to define loss ratio. 2, the percent of the premium used to define loss ratio that is otherwise applicable for the reinsurance year under the terms of the standard reinsurance agreement in effect for the reinsurance year. B, other contracts. In carrying out subparagraph A, the corporation shall not reduce, with respect to any reinsurance year, the amount or the rate of reimbursement to approved insurance providers and agents under the standard reinsurance agreement described in Clause 2 of such subparagraph for administrative and operating expenses with respect to contracts covering agricultural commodities that are not subject to such subparagraph. C, administration. The requirements of this paragraph and the adjustments made pursuant to this paragraph shall not be considered a renegotiation under paragraph 8A. 12, A&O inflation adjustment. In general, subject to subparagraph B, beginning with the 2026 reinsurance year and for each reinsurance year thereafter, the corporation shall increase the total administrative and operating expense reimbursements otherwise required under the standard reinsurance agreement in effect for the reinsurance year in order to account for inflation in a manner consistent with the increases provided with respect to the 2011 through 2015 reinsurance years under the enclosure included in Risk Management Agency Bulletin numbered MGR 10007 and dated June 30, 2010. B, special rule for 2026 reinsurance year. The increase under subparagraph A for the 2026 reinsurance year shall not exceed the percentage change for the preceding reinsurance year included in the Consumer Price Index for all urban consumers published by the Bureau of Labor Statistics and the Department of Labor. C, administration. An increase under subparagraph A, 1, shall apply with respect to all contracts covering agricultural commodities that were subject to an increase during the period of the 2011 through 2015 reinsurance years under the enclosure referred to in that subparagraph, and 2, shall not be considered a renegotiation under paragraph 8A. Section 10504, premium support. Section 508E2 of the Federal Crop Insurance Act, 7 U.S.C. 1508E2 is amended, 1, in subparagraph C1 by striking 64 and inserting 69, 2, in subparagraph D1 by striking 59 and inserting 64, 3, in subparagraph E1 by striking 55 and inserting 60, 4, in subparagraph F1 by striking 48 and inserting 51, and 5, in subparagraph G1 by striking 38 and inserting 41. Section 10505, Program Compliance and Integrity. Section 515L2 of the Federal Crop Insurance Act, 7 U.S.C. 1515L2, is amended by striking "than" and all that follows through the period at the end and inserting the following: "than A, $4 million for each of fiscal years 2009 through 2025, and B, $6 million for fiscal year 2026 and each subsequent fiscal year." Section 10506, Reviews, Compliance, and Integrity. Section 516B2C1 of the Federal Crop Insurance Act, 7 U.S.C. 1516B2C1, is amended in the matter preceding subclause 1 by striking "for each fiscal year" and inserting "for each of fiscal years 2014 through 2025, and $10 million for fiscal year 2026 and each fiscal year thereafter."
Section 10507, Poultry Insurance Pilot Program. Section 523 of the Federal Crop Insurance Act, 7 U.S.C. 1523, is amended by adding at the end the following: J, Poultry Insurance Pilot Program. 1, in general, notwithstanding subsection A2, the corporation shall establish a pilot program under which contract poultry growers, including growers of broilers and laying hens, may elect to receive index-based insurance from extreme weather-related risk resulting in increased utility costs, including costs of natural gas, propane, electricity, water, and other appropriate costs, as determined by the corporation, associated with poultry production. 2, stakeholder engagement. The corporation shall engage with poultry industry stakeholders in establishing the pilot program under paragraph 1. 3, location. The pilot program established under paragraph 1 shall be conducted in a sufficient number of counties to provide a comprehensive evaluation of the feasibility, effectiveness, and demand among producers in the top poultry producing states as determined by the corporation. 4, approval of policy or plan, notwithstanding section 5081. The board shall approve a policy or plan of insurance based on the pilot program under paragraph 1. A, in accordance with section 508H, and B, not later than 2 years after the date of enactment of this subsection. Subtitle F, Additional Investments in Rural America, section 10601, Conservation. A, in general, Section 1241A of the Food Security Act of 1985, 16 U.S.C. 3841A is amended. 1, in paragraph 2 by striking subparagraphs A through F and inserting the following. A, $625 million for fiscal year 2026. B, $650 million for fiscal year 2027. C, $675 million for fiscal year 2028. D, $700 million for fiscal year 2029. E, $700 million for fiscal year 2030. And F, $700 million for fiscal year 2031. And 2, in paragraph 3, A and subparagraph A by striking clauses 1 through 5 and inserting the following. 1, $2,655 million for fiscal year 2026. 2, $2,855 million for fiscal year 2027. 3, $3,255 million for fiscal year 2028. 4, $3,255 million for fiscal year 2029. 5, $3,255 million for fiscal year 2030. And 6, $3,255 million for fiscal year 2031. And B, in subparagraph B, by striking clauses 1 through 5 and inserting the following. 1, $1,300 million for fiscal year 2026. 2, $1,325 million for fiscal year 2027. 3, $1,350 million for fiscal year 2028. 4, $1,375 million for fiscal year 2029. 5, $1,375 million for fiscal year 2030. And 6, $1,375 million for fiscal year 2031. B, Regional Conservation Partnership Programs, Section 1271D of the Food Security Act of 1985, 16 U.S.C. 3871D is amended by striking subsection A and inserting the following. A, availability of funding. Of the funds of the Commodity Credit Corporation, the Secretary shall use to carry out the program to the maximum extent practicable. 1, $425 million for fiscal year 2026. 2, $450 million for fiscal year 2027. 3, $450 million for fiscal year 2028. 4, $450 million for fiscal year 2029. 5, $450 million for fiscal year 2030. And 6, $450 million for fiscal year 2031. C, Grassroots Source Water Protection Programs, Section 1240 OB of the Food Security Act of 1985, 16 U.S.C. 3839 BB. 2B is amended. 1, in paragraph 1 by striking 2023 and inserting 2031. And 2, in paragraph 3A and subparagraph A by striking and at the end. B, in subparagraph B by striking the period at the end and inserting and. C, by adding at the end of the following. C, $1 million beginning in fiscal year 2026 to remain available until expended. D, voluntary public access and habitat incentive programs, Section 1240 RF1 of the Food Security Act of 1985, 16 U.S.C. 3839 BB. 5F1 is amended. 1, by striking 2023 and inserting 2023. And 2, by inserting and $70 million for the period of fiscal years 2025 through 2031 before the period at the end. E, watershed protection and flood prevention. Section 15 of the Watershed Protection and Flood Prevention Act, 16 U.S.C. 1012A is amended by striking $50 million for fiscal year 2019 and each fiscal year thereafter, and inserting $150 million for fiscal year 2026 and each fiscal year thereafter to remain available until expended. F, Feral Swine Eradication and Control Pilot Program, Section 2408G1 of the Agricultural Improvement Act of 2018, 7 U.S.C. 8351, note, Public Law 115-334 is amended. 1, by striking 2023 and inserting 2023, and 2, by inserting and $105 million for the period of fiscal years 2025 through 2031 before the period at the end. G, rescission. The unobligated balances of amounts appropriated by Section 21001A of Public Law 117-169, 136 Stat 2015 are rescinded. Section 10602 Supplemental Agricultural Trade Promotion Program. A, in general, the Secretary of Agriculture shall carry out a program to encourage the accessibility, development, maintenance, and expansion of commercial export markets for United States agricultural commodities. B, funding. Of the funds of the Commodity Credit Corporation, the Secretary of Agriculture shall make available to carry out this section $205 million for fiscal year 2027 and each fiscal year thereafter. Section 10603, Nutrition, Section 203D, D5 of the Emergency Food Assistance Act of 1983, 7 U.S.C. 7507, D5, is amended by striking 2024 and inserting 2031. Section 10604, Research, A, Urban, Indoor, and Other Emerging Agricultural Programs, Production, Research, Education, and Extension Initiative, Section 1672 ED1B of the Food, Agricultural, Conservation, and Trade Act of 1990, 7 U.S.C. 5925 GD1B, is amended by striking fiscal year 2024 to remain available until expended, and inserting each of fiscal years 2024 through 2031. B, Foundation for Food and Agricultural Research. Section 7601 G1A of the Agricultural Act of 2014, 7 U.S.C. 5939 G1A, is amended by adding at the end of the following. 4, further funding not later than 30 days after the date of enactment of this clause of the funds of the Commodity Credit Corporation, the Secretary shall transfer to the Foundation to carry out this section $37 million to remain available until expended. C, scholarships for students at 1890 institutions, Section 1446B1 of the National Agricultural Research Extension and Teaching Policy Act of 1977, 7 U.S.C. 3222A-B1, is amended by adding at the end the following. C, further funding of the funds of the Commodity Credit Corporation, the Secretary shall make available to carry out this section $60 million for fiscal year 2026 to remain available until expended. D, Assistive Technology Program for Farmers with Disabilities, Section 1680 of the Food, Agricultural, Conservation, and Trade Act of 1990, 7 U.S.C. 5933, is amended 1 in subsection C2 by inserting and subsection D after paragraph 1 and 2 by adding at the end of the following. D, mandatory funding. Subject to subsection C2 of the funds of the Commodity Credit Corporation, the Secretary shall use to carry out this section $8 million for fiscal year 2026 to remain available until expended. E, Specialty Crop Research Initiative. Section 412K1B of the Agricultural Research, Extension, and Education Reform Act of 1998, 7 U.S.C. 7632 K1B, is amended by striking section $80 million for fiscal year 2014 and inserting the following section. 1, $80 million for each of fiscal years 2014 through 2025, and 2, $175 million for fiscal year 2026. F, Research Facilities Act, Section 6 of the Research Facilities Act, 7 U.S.C. 390D, is amended 1 in subsection C by striking subsection A and inserting subsections A and E, and 2 by adding at the end the following. E, mandatory funding subject to subsections B, C, and D of the funds of the Commodity Credit Corporation. The Secretary shall make available to carry out the competitive grant program under Section 4, $125 million for fiscal year 2026 and each fiscal year thereafter. Section 10605, Energy, Section 9005 G1F of the Farm Security and Rural Investment Act of 2002, 7 U.S.C. 8105 G1F, is amended by striking 2024 and inserting 2031. Section 10606, Horticulture. A, Plant, Pest, and Disease Management and Disaster Prevention, Section 420F of the Plant Protection Act, 7 U.S.C. 7721F, is amended 1 in paragraph 5 by striking and at the end, 2 by redesignating paragraph 6 as paragraph 7, 3 by inserting after paragraph 5 the following. 6, $75 million for each of fiscal years 2018 through 2025, and 4 in paragraph 7 as so redesignated by striking $75 million for fiscal year 2018 and inserting $90 million for fiscal year 2026. B, Specialty Crop Block Grants, Section 10111 of the Specialty Crops Competitiveness Act of 2004, 7 U.S.C. 1621, note, Public Law 108, 465 is amended 1 in subparagraph D by striking and at the end, 2 by redesignating subparagraph E as subparagraph F, 3 by inserting after subparagraph D the following. E, $85 million for each of fiscal years 2018 through 2025, and 4 in subparagraph F as so redesignated by striking $85 million for fiscal year 2018 and inserting $100 million for fiscal year 2026. C, Organic Production and Market Data Initiative, Section 7407 D1 of the Farm Security and Rural Investment Act of 2002, 7 U.S.C. 5925 CD1 is amended 1 in subparagraph B by striking and at the end, 2 in subparagraph C by striking the period at the end and inserting and by 3 by adding at the end the following. D, $10 million for the period of fiscal years 2026 through 2031 D, modernization and improvement of international trade technology systems and data collection, Section 2123C4 of the Organic Foods Production Act of 1997, USC 6522C4 is amended in the matter proceeding, subparagraph A, by striking and $1 million for fiscal year 2024 and inserting $1 million for fiscal years 2024 and 2025 and $5 million for fiscal year 2026. E, National Organic Certification Cost Share Program, Section 10606D1C of the Farm Security and Rural Investment Act of 2002, 7 USC 6523. D1C is amended by striking 2024 and inserting 2031. F, Multiple Crop and Pesticide Use Survey, Section 10109C of the Agricultural Improvement Act of 2018, Public Law 115-334, 132, Stat 4907 is amended by adding at the end the following. 3, further mandatory funding of the funds of the Commodity Credit Corporation. The Secretary shall use to carry out the Section $5 million for fiscal year 2026 to remain available until expended. Section 10607, miscellaneous. A, Animal Disease Prevention and Management. Section 10409AD1 of the Animal Health Protection Act, 7 U.S.C. 8308AD1 is amended. 1, in subparagraph B. A, in the heading by striking subsequent fiscal years and inserting fiscal years 2023 through 2025, and B, by striking fiscal year 2023 and each fiscal year thereafter and inserting each of fiscal years 2023 through 2025, and 2, by adding at the end the following. C, fiscal years 2026 through 2030 of the funds of the Commodity Credit Corporation. The Secretary shall make available to carry out the Section $233 million for each of fiscal years 2026 through 2030, of which 1, not less than $10 million shall be made available for each such fiscal year to carry out subsection A. 2, not less than $70 million shall be made available for each such fiscal year to carry out subsection B. And 3, not less than $153 million shall be made available for each such fiscal year to carry out subsection C. D, subsequent fiscal years. Of the funds of the Commodity Credit Corporation, the Secretary shall make available to carry out the section $75 million for fiscal year 2031, each fiscal year thereafter, of which not less than $45 million shall be made available for each of those fiscal years to carry out subsection B. B, Sheep Production and Marketing Grant Program, Section 209C of the Agricultural Marketing Act of 1946, 7 U.S.C. 1627 AC is amended. 1, by striking 2019 and inserting 2019, and 2, by inserting and $3 million for fiscal year 2026 after fiscal year 2024. The C, Pima Agricultural Cotton Trust Fund, Section 12314 of the Agricultural Act of 2014, 7 U.S.C. 2101, Note, Public Law 113-79 is amended. 1, in subsection B in the matter preceding paragraph 1 by striking 2024 and inserting 2031, and 2, in subsection H by striking 2024 and inserting 2031. D, Agricultural Wool Apparel Manufacturers Trust Fund, Section 12315 of the Agricultural Act 2014, 7 U.S.C. 7101, Note, Public Law 113-79 is amended by striking 2024 each place it appears and inserting 2031. E, Wool Research and Promotion, Section 12316A of the Agricultural Act of 2014, 7 U.S.C. 7101, Note, Public Law 113-79 is amended by striking 2024 and inserting 2031. F, Emergency Citrus Disease Research and Development Trust Fund, Section 12605D of the Agricultural Improvement Act of 2018, 7 U.S.C. 7632, Note, Public Law 115-334 is amended by striking 2024 and inserting 2031. Title II, Committee on Armed Services, Section 20001, Enhancement of Department of Defense Resources for Improving the Quality of Life for Military Personnel. A, appropriations. In addition to amounts otherwise available, there are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $230,480,000 for restoration and modernization costs under the Marine Corps Barracks 2030 Initiative. 2, $119 million for base operating support costs under the Marine Corps. 3, $1 billion for Army, Navy, Air Force, and Space Force sustainment, restoration, and modernization of military unaccompanied housing. $2 billion for the Defense Health Program. 5, $2.9 billion to supplement the basic allowance for housing payable to members of the Army, Air Force, Navy, Marine Corps, and Space Force, notwithstanding Section 403 of Title 37 United States Code. 6, $50 million for bonuses, special pays, and incentive pays for members of the Army, Air Force, Navy, Marine Corps, and Space Force pursuant to Titles 10 and 37 United States Code. 7, $10 million for the defense activity for non-traditional Education supports online academic skills course program for members of the Army, Air Force, Navy, Marine Corps, and Space Force. 8, $100 million for tuition assistance for members of the Army, Air Force, Navy, Marine Corps, and Space Force pursuant to Title 10 United States Code. 9, $100 million for child care fee assistance for members of the Army, Air Force, Navy, Marine Corps, and Space Force under Part 2 of Chapter 88 of Title 10 United States Code. 10, $590 million to increase the temporary lodging expense allowance under Chapter 8 of Title 37 United States Code to 21 days. 11, $100 million for Department of Defense impact aid payments to local educational agencies under Section 2008 of Title 10 United States Code. 12, $10 million for military spouse professional licensure under Section 1784 of Title 10 United States Code. 13, $6 million for Armed Forces Retirement Home Facilities. 14, $100 million for the Defense Community Infrastructure Program. 15, $100 million for Defense Advanced Research Projects Agencies, DARPA, Casualty Care Research, and 16, $62 million for modernization of Department of Defense Child Care Center staffing. B, temporary increase in percentage of value of authorized investment in certain privatized military housing projects, 1, in general. During the period beginning on the date of the enactment of this section and ending on September 30th, 2029, the Secretary concerned shall apply. A, paragraph 1 of subsection C of Section 2875 of Title 10 United States Code by substituting 60% of 33 and a third percent, and B, paragraph 2 of such subsection by substituting 60% for 45%. 2, secretary concerned defined. In this subsection, the term secretary concerned has the meaning given such term in Section 101 of Title 10 United States Code. C, temporary authority for acquisition or construction of privatized military unaccompanied housing. Section 2881A of Title 10 United States Code is amended. 1, by striking the heading and inserting temporary authority for acquisition or construction of privatized military unaccompanied housing. 2, by striking Secretary of the Navy each place it appears and inserting secretary concerned. 3, by striking under the pilot projects each place it appears and inserting pursuant to this section. 4, in subsection A, by striking the heading and inserting in general, and B, by striking carry out not more than 3 pilot projects under the authority of this section or another provision of this subchapter to use the private sector, and inserting use the authority under this subchapter to enter into contracts with appropriate private sector entities. 5, in subsection C, by striking privatized housing and inserting privatized housing units. 6, by redesignating subsection F as subsection E, and 7, in subsection E as so redesignated. A, by striking under the pilot programs and inserting under this section, and B, by striking September 30th, 2009 and inserting September 30th, 2029. Section 20002, enhancement of Department of Defense resource for shipbuilding. In addition to amounts otherwise available, there are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $250 million for the expansion of accelerated training and defense manufacturing program. 2, $250 million for United States production of turbine generators for shipbuilding and industrial bases. 3, $450 million for United States additive manufacturing for wire production and machining capacity for shipbuilding and industrial base. 4, $492 million for the next generation shipbuilding techniques. 5, $85 million for United States made steel plate for shipbuilding industrial base. 6, $50 million for machining capacity for naval propellers for shipbuilding industrial base. 7, $110 million for rolled steel and fabrication facility for shipbuilding industrial base. 8, $400 million for expansion of collaborative campus for naval shipbuilding. 9, $450 million for application of autonomy and artificial intelligence to naval shipbuilding. 10, $500 million for the adoption of advanced manufacturing techniques in the shipbuilding industrial base. 11, $500 million for additional dry dock capability. 12, $50 million for the expansion of cold spray repair technologies. 13, $450 million for additional maritime industrial workforce development programs. 14, $750 million for additional supplier development across the naval shipbuilding industrial base. 15, $250 million for additional advanced manufacturing processes across the naval shipbuilding industrial base. 16, $4,600 million for a second Virginia-class submarine in fiscal year 2026. 17, $5,400 million for 2 additional guided missile destroyers, DDG ships. 18, $160 million for advanced procurement of landing ship medium. 19, $1,803,941,000 for procurement of landing ship medium. 20, $295 million for development of a second landing craft utility shipyard and production of additional landing craft utility. 21, $100 million for advanced procurement for light replenishment oiler program. 22, $600 million for the lease or purchase of new ships through the National Defense Sea Lift Fund. 23, $2,725 million for the procurement of TAO oilers. 24, $500 million for cost to complete for rescue and salvage ships. 25, $300 million for production of ship-to-shore connectors. 26, $1,470 million for the implementation of a multi-ship amphibious warship contract. 27, $80 million for accelerated development of vertical launch system reloading at sea. 28, $250 million for expansion of Navy corrosion control programs. 29, $159 million for leasing of ships for Marine Corps operations. 30, $1,534 million for expansion of small unmanned surface vessel production. 31, $2,100 million for development, procurement, and integration of purpose-built medium unmanned surface vessels. 32, $1,300 million for expansion of unmanned underwater vehicle production. 33, $188,360,000 for the development of testing of maritime robotic autonomous systems and enabling technologies. 34, $170 million for the development of a test resource management center robotic autonomous systems proving ground. 35, $250 million for the development, production, and integration of wave-powered unmanned underwater vehicles. And 36, $150 million for retention of inactive reserve fleet ships. Section 20003, enhancement of Department of Defense resources for integrated air and missile defense. A, next-generation missile defense technologies, in addition to amounts otherwise available, there are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $250 million for development and testing of directed energy capabilities by the Undersecretary for Research and Engineering. 2, $500 million for national security space launch infrastructure. 3, $2 billion for air-moving target indicator military satellites. 4, $400 million for expansion of multi-service advanced capability hypersonic test bed program. 5, $5,600 million for development of space-based and boost phase intercept capabilities. 6, $7,200 million for the development, procurement, and integration of military space-based sensors. And 7, $2,550 million for the development, procurement, and integration of military missile defense capabilities. B, Laird Homeland Defense. In addition to amounts otherwise available, there are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $2,200 million for acceleration of hypersonic defense systems. 2, $800 million for accelerated development and deployment of next-generation intercontinental ballistic missile defense systems. 3, $408 million for Army space and strategic missile test range infrastructure restoration and modernization in the United States Indo-Pacific Command Area of Operations west of the International Date Line. 4, $1,975 million for improved ground-based missile defense radars. And 5, $530 million for the design and construction of Missile Defense Agency missile instrumental range safety ship. Section 20004, enhancement of Department of Defense resources for munitions and defense supply chain resiliency. A, appropriations. In addition to amounts otherwise available, there are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $400 million for the development, production, and integration of Navy and Air Force long-range anti-ship missiles. 2, $380 million for production capacity expansion for Navy and Air Force long-range anti-ship missiles. 3, $490 million for the development, production, and integration of Navy and Air Force long-range air-to-surface missiles. 4, $94 million for the development, production, and integration of alternative Navy and Air Force long-range air-to-surface missiles. 5, $630 million for the development, production, and integration of long-range Navy air defense and anti-ship missiles. 6, $688 million for the development, production, and integration of long-range multi-service cruise missiles. 7, $250 million for the production, capacity expansion, and supplier base strengthening of long-range multi-service cruise missiles. 8, $70 million for the development, production, and integration of short-range Navy and Marine Corps anti-ship missiles. 9, $100 million for the development of an anti-ship seeker for short-range Army ballistic missiles. 10, $175 million for production capacity expansion for next-generation Army medium-range ballistic missiles. 11, $50 million for the mitigation of diminishing manufacturing sources for medium-range air-to-air missiles. 12, $250 million for the procurement of medium-range air-to-air missiles. 13, $225 million for the expansion of production capacity for medium-range air-to-air missiles. 14, $50 million for the development of second sources for components of short-range air-to-air missiles. 15, $325 million for production capacity improvements for air-launched anti-radiation missiles. 16, $50 million for the accelerated development of Army next-generation medium-range anti-ship ballistic missiles. 17, $114 million for the production of Army next-generation medium-range ballistic missiles. 18, $300 million for the production of Army medium-range ballistic missiles. 19, $85 million for the accelerated development of Army long-range ballistic missiles. 20, $400 million for the production of heavyweight torpedoes. 21, $200 million for the development, procurement, and integration of mass-producible autonomous underwater munitions. 22, $70 million for the improvement of heavyweight torpedo maintenance activities. 23, $200 million for the production of lightweight torpedoes. 24, $500 million for the development, procurement, and integration of maritime mines. 25, $50 million for the development, procurement, and integration of new underwater explosives. 26, $55 million for the development, procurement, and integration of lightweight multi-mission torpedoes. 27, $80 million for the production of sono buoys. 28, $150 million for the development, procurement, and integration of air-delivered long-range maritime mines. 29, $61 million for the acceleration of Navy expeditionary loitering munitions deployment. 30, $50 million for the acceleration of one-way attack unmanned aerial systems with advanced autonomy. 31, $1 billion for the expansion of the one-way attack unmanned aerial systems industrial base. 32, $200 million for investments in solid rocket motor industrial base through the Industrial Base Fund established under Section 4817 of Title 10 United States Code. 33, $400 million for investments in the emerging solid rocket motor industrial base through the Industrial Base Fund established under Section 4817 of Title 10 United States Code. 34, $42 million for investments in second sources for large diameter solid rocket motors for hypersonic missiles. 35, $1 billion for the creation of next-generation automated munitions production factories. 36, $170 million for the development of advanced radar depot for repair, testing, and production of radar and electronic warfare systems. 37, $25 million for the expansion of the Department of Defense industrial base policy analysis workforce. 38, $30,300,000 for the repair of Army missiles. 39, $100 million for the production of small and medium ammunition. 40, $2 billion for additional activities to improve the United States stockpile of critical minerals through the National Defense Stockpile Transaction Fund, authorized by Subchapter 3 of Chapter 5 of Title 5 United States Code. 41, $10 million for the expansion of Department of Defense armaments cooperation workforce. 42, $500 million for the expansion of the Defense Exportability Features Program. 43, $350 million for protection of Navy long-range air and missile defense interceptors. 44, $93 million for replacement of Navy long-range air and missile defense interceptors. 45, $100 million for development of a second solid rocket motor source for Navy air defense and anti-ship missiles. 46, $65 million for expansion of production capacity of Missile Defense Agency long-range anti-ballistic missiles. 47, $225 million for expansion of production capacity for Navy air defense and anti-ship missiles. 48, $103,300,000 for expansion of depot-level maintenance facility for Navy long-range air and missile defense interceptors. 49, $18 million for creation of domestic source for guidance section of Navy short-range air defense missiles. 50, $65 million for integration of Army medium-range air and missile defense interceptor with Navy ships. 51, $176,100,000 for production of Army long-range movable missile defense radar. 52, $167 million for accelerated fielding of Army short-range gun-based air and missile defense system. 53, $40 million for development of low-cost alternatives to air and missile defense interceptors. 54, $50 million for acceleration of Army next-generation shoulder-fired air defense system. 55, $91 million for production of Army next-generation shoulder-fired air defense system. 56, $500 million for development, production, and integration of counter-unmanned aerial system programs. 57, $350 million for development, production, and integration of non-kinetic counter-unmanned aerial systems programs. 58, $250 million for development, production, and integration of land-based counter-unmanned aerial systems programs. 59, $200 million for development, production, and integration of ship-based counter-unmanned aerial systems programs. 60, $400 million for acceleration of hypersonic strike programs. 61, $167 million for procurement of additional launchers for Army medium-range air and missile defense interceptors. 62, $500,000 for expansion of defense advanced manufacturing techniques. 63, $1 million for establishment of the Joint Energetics Transition Office. 64, $200 million for acceleration of Army medium-range air and missile defense interceptors. 65, $150 million for additive manufacturing for propellant. 66, $250 million for expansion and acceleration of penetrating munitions production. And 67, $50 million for development, procurement, and integration of precision extended range artillery.
B, appropriation. In addition to amounts otherwise available, there is appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029, $3.3 billion for grants and purchase commitments made pursuant to the Industrial Base Fund established under Section 4817 of Title 10, United States Code. C, appropriation, in addition to amounts otherwise available, there is appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029, $5 billion for investments in critical mineral supply chains made pursuant to the Industrial Base Fund established under Section 4817 of Title 10, United States Code. D, appropriations. In addition to amounts otherwise available, there is appropriated to the Secretary of Defense out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029, $500 million to the Department of Defense Credit Program account to carry out the Capital Assistance Program, including loans, loan guarantees, and technical assistance established under Section 149E of Title 10, United States Code for critical minerals and related industries and projects, including related covered technology categories, provided that 1, such amounts are available to subsidize gross obligations for the principal amount of direct loans and total loan principal, any part of which is to be guaranteed, not to exceed $100 billion, and 2, such amounts are available to cover all costs and expenditures as provided under Section 149E5B of Title 10, United States Code. Section 20005, enhancement of Department of Defense resources for scaling low-cost weapons into production. A, appropriations. In addition to amounts otherwise available, there are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029, 1, $25 million for the Office of Strategic Capital Global Technology Scout Program, 2, $1.4 billion for the expansion of the Small Unmanned Aerial System Industrial Base, 3, $400 million for the development and deployment of the Joint Fires Network and associated joint battle management capabilities, 4, $400 million for the expansion of advanced command and control tools to combatant commands and military departments, 5, $100 million for the development of shared secured facilities for the Defense Industrial Base, 6, $50 million for the creation of additional Defense Innovation Unit on-ramp hubs, 7, $600 million for the acceleration of strategic capabilities office programs, 8, $650 million for the expansion of mission capabilities office joint prototyping and experimentation activities for military innovation, 9, $500 million for the accelerated development and integration of advanced 5G, 6G technologies for military use, 10, $25 million for testing of simultaneous transmit and receive technology for military spectrum agility, 11, $50 million for the development, procurement, and integration of high-altitude stratospheric balloons for military use, 12, $120 million for the development, procurement, and integration of long-endurance unmanned aerial systems for surveillance, 13, $40 million for the development, procurement, and integration of alternative positioning and navigation technology to enable military operations in contested electromagnetic environments. 14, $750 million for the acceleration of innovative military logistics and energy capability development and deployment. 15, $125 million for the acceleration of development of small, portable, modular nuclear reactors for military use. 16, $1 billion for the expansion of programs to accelerate the procurement and fielding of innovative technologies. 17, $90 million for the development of reusable hypersonic technology for military strikes. 18, $2 billion for the expansion of Defense Innovation Unit sealing of commercial technology for military use. 19, $500 million to prevent delays in delivery of attributable autonomous military capabilities. 20, $1.5 billion for the development, procurement, and integration of low-cost cruise missiles. 21, $124 million for improvements to Test Resource Management Center artificial intelligence capabilities. 22, $145 million for the development of artificial intelligence to enable one-way attack, unmanned aerial systems, and naval systems. 23, $250 million for the development of the Test Resource Management Center digital test environment. 24, $250 million for the advancement of the artificial intelligence ecosystem. 25, $250 million for the expansion of Cyber Command artificial intelligence lines of effort. 26, $250 million for the acceleration of the quantum benchmarking initiative. 27, $1 billion for the expansion and acceleration of qualification activities and technical data management to enhance competition in defense industrial base. 28, $400 million for the expansion of the Defense Manufacturing Technology Program. 29, $1,685 million for military cryptographic modernization activities. 30, $90 million for Apex accelerators, the Mentor Protege program, and cybersecurity support to small non-traditional contractors. 31, $250 million for the development, procurement, and integration of Air Force low-cost counter-air capabilities. 32, $10 million for additional Air Force wargaming activities. And 33, $20 million for the Office of Strategic Capital Workforce. B, appropriations. In addition to amounts otherwise available, there are appropriated to the Secretary of Defense out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029, $1 billion to the Department of Defense Credit Program account to carry out the Capital Assistance Program, including loans, loan guarantees, and technical assistance established under Section 149E of Title 10 U.S. Code, provided that 1, such amounts are available to subsidize gross obligations for the principal amount of direct loans and total loan principal, any part of which is to be guaranteed not to exceed $100 billion, and 2, such amounts are available to cover all costs and expenditures as provided under Section 149E5B of Title 10 U.S. Code. Section 20006, enhancement of Department of Defense resources for improving the efficiency and cybersecurity of the Department of Defense. In addition to amounts otherwise available, they are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $150 million for business systems replacement to accelerate the audits of the financial statements of the Department of Defense pursuant to Chapter 9A and Section 2222 of Title 10 U.S. Code. 2, $200 million for the deployment of automation and artificial intelligence to accelerate the audits of the financial statements of the Department of Defense pursuant to Chapter 9A and Section 2222 of Title 10 United States Code. 3, $10 million for the improvement of the budgetary and programmatic infrastructure of the Office of the Secretary of Defense. And 4, $20 million for defense cybersecurity programs of the Defense Advanced Research Projects Agency. Section 20007, enhancement of Department of Defense resources for air superiority. In addition to amounts otherwise available, they are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $3,150 million to increase F-15 aircraft production. 2, $361,220,000 to prevent the retirement of F-22 aircraft. 3, $127,460,000 to prevent the retirement of F-15E aircraft. 4, $187 million to accelerate installation of F-16 electronic warfare capability. 5, $116 million for C-17A mobility aircraft connectivity. 6, $84 million for KC-135 mobility aircraft connectivity. 7, $440 million to increase C-130J production. 8, $474 million to increase EA-37B production. 9, $678 million to accelerate the Collaborative Combat Aircraft Program. 10, $400 million to accelerate production of the F-47 aircraft. 11, $750 million to accelerate the F/A-XX aircraft. 12, $100 million for production of advanced aerial sensors. 13, $160 million to accelerate V-22 reliability and safety improvements. 14, $100 million to accelerate production of MQ-25 aircraft. 15, $270 million for development, procurement, and integration of Marine Corps unmanned combat aircraft. 16, $96 million for the procurement and integration of infrared search and track pods. 17, $50 million for the procurement and integration of additional F-15EX fuel tanks. 18, $600 million for the development, procurement, and integration of Air Force long-range strike aircraft. 19, $500 million for the development, procurement, and integration of Navy long-range strike aircraft. Section 20008, Enhancement of Resources for Nuclear Forces. A, DoD appropriations. In addition to amounts otherwise available, they are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $2.5 billion for risk reduction activities for the Sentinel Intercontinental Ballistic Missile Program. 2, $4.5 billion only for expansion of production capability of B-21 long-range bomber aircraft and the purchase of aircraft only available through the expansion of production capabilities. 3, $500 million for improvements to the Minuteman III intercontinental ballistic missile system. 4, $100 million for capability enhancements to intercontinental ballistic missile reentry vehicles. 5, $148 million for the expansion of D5 missile motor production. 6, $400 million to accelerate the development of Trident D5 LE-2 submarine-launched ballistic missiles. 7, $2 billion to accelerate the development, procurement, and integration of the nuclear-armed sea-launched cruise missile. 8, $62 million to convert Ohio-class submarine tubes to accept additional missiles not to be obligated before March 1st, 2026. 9, $168 million to accelerate the production of the Survivable Airborne Operations Center program. 10, $65 million to accelerate the modernization of nuclear command, control, and communications. 11, $210,300,000 for the increased production of MH-139 helicopters. And 12, $150 million to accelerate the development, procurement, and integration of military nuclear weapons delivery programs. B, NNSA appropriations. In addition to amounts otherwise available, they are appropriated to the Administrator of the National Nuclear Security Administration for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $200 million to perform National Nuclear Security Administration Phase 1 studies pursuant to Section 3211 of the National Nuclear Security Administration Act, 50 U.S.C. 2401. 2, $540 million to address deferred maintenance and repair needs of the National Nuclear Security Administration pursuant to Section 3211 of the National Nuclear Security Administration Act, 50 U.S.C. 2401. 3, $1 billion to accelerate the construction of National Nuclear Security Administration facilities pursuant to Section 3211 of the National Nuclear Security Administration Act, 50 U.S.C. 2401. 4, $400 million to accelerate the development, procurement, and integration of the warhead for the nuclear-armed sea-launched cruise missile pursuant to Section 3211 of the National Nuclear Security Administration Act, 50 U.S.C. 2401. 5, $750 million to accelerate primary capability modernization pursuant to Section 3211 of the National Nuclear Security Administration Act, 50 U.S.C. 2401. 6, $750 million to accelerate secondary capability modernization pursuant to Section 3211 of the National Nuclear Security Administration Act, 50 U.S.C. 2401. 7, $120 million to accelerate domestic uranium enrichment centrifuge deployment for defense purposes pursuant to Section 3211 of the National Nuclear Security Administration Act, 50 U.S.C. 2401. 8, $10 million for National Nuclear Security Administration evaluation of spent fuel reprocessing technology. And 9, $115 million for accelerating nuclear national security missions through artificial intelligence. Section 20009, enhancement of Department of Defense resources to improve capabilities of United States Indo-Pacific Command. In addition to amounts otherwise available, there are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $365 million for Army exercises and operations in the Western Pacific Area of Operations. 2, $53 million for Special Operations Command exercises and operations in the Western Pacific Area of Operations. 3, $47 million for Marine Corps exercises and operations in Western Pacific Area of Operations. 4, $90 million for Air Force exercises and operations in Western Pacific Area of Operations. 5, $532,600,000 for the Pacific Air Force biennial large-scale exercise. 6, $19 million for the development of naval small craft capabilities. 7, $35 million for military additive manufacturing capabilities in the United States Indo-Pacific Command Area of Operations west of the International Date Line. 8, $450 million for the development of airfields within the area of operations of the United States Indo-Pacific Command. 9, $1.1 billion for development of infrastructure within the area of operations of United States Indo-Pacific Command. 10, $124 million for mission networks for United States Indo-Pacific Command. 11, $100 million for the Air Force regionally based cluster preposition base kits. 12, $115 million for exploration and development of existing Arctic infrastructure. 13, $90 million for the accelerated development of non-kinetic capabilities. 14, $20 million for United States Indo-Pacific Command military exercises. 15, $143 million for anti-submarine sonar arrays. 16, $30 million for surveillance and reconnaissance capabilities for United States Africa Command. 17, $30 million for surveillance and reconnaissance capabilities for United States Indo-Pacific Command. 18, $500 million for the development, coordination, and deployment of economic competition effects within the Department of Defense. 19, $10 million for the expansion of Department of Defense workforce for economic competition. 20, $1 billion for offensive cyber operations. 21, $500 million for personnel and operations costs associated with forces assigned to United States Indo-Pacific Command. 22, $300 million for the procurement of mesh network communications capabilities for Special Operations Command Pacific. 23, $850 million for the replenishment of military articles. 24, $200 million for the acceleration of Guam Defense System program. 25, $68 million for the Space Force facilities improvements. 26, $150 million for ground moving target indicator military satellites. 27, $528 million for DARC and Silent Barker military space situational awareness programs. 28, $80 million for Navy Operational Support Division. 29, $1 billion for the X-37B military spacecraft program. 30, $3.65 billion for the development, procurement, and integration of United States military satellites and the protection of United States military satellites. 31, $125 million for the deployment, procurement, and integration of military space communications. 32, $350 million for the development, procurement, and integration of military space command and control systems. Section 20010, enhancement of Department of Defense resources for improving the readiness of the Department of Defense. In addition to amounts otherwise available, they are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. $1.4 billion for a pilot program on OPN 8 maritime spares and repair pool. 2, $700 million for a pilot program on OPN 8 maritime spares and repair pool for amphibious ships. 3, $2.118 billion for spares and repairs to keep Air Force aircraft mission capable. 4, $1.5 billion for Army depot modernization and capacity enhancement. 5, $2 billion for Navy depot and shipyard modernization and capacity enhancement. 6, $250 million for Air Force depot modernization and capacity enhancement. 7, $1.640 billion for Special Operations Command equipment, readiness and operations. 8, $500 million for National Guard unit readiness. 9, $400 million for Marine Corps readiness and capabilities. 10, $20 million for upgrades to Marine Corps utility helicopters. 11, $310 million for next generation vertical lift, assault and infrastructure acro medical aircraft. 12, $75 million for the procurement of anti-lock braking systems for the Army wheeled transport vehicles. 13, $230 million for the procurement of Army wheeled combat vehicles. 14, $63 million for the development of advanced rotary wing engines. 15, $241 million for the development, procurement, and integration of Marine Corps amphibious vehicles. 16, $250 million for the procurement of Army tracked combat transport vehicles. 17, $98 million for the additional advanced Army light rotary wing capabilities. 18, $1.5 billion for increased depot maintenance and shipyard maintenance activities. 19, $2.5 billion for Air Force facilities sustainment, restoration, and modernization. 20, $92,500,000 for the completion of robotic combat vehicle prototyping. 21, $125 million for Army operations. 22, $10 million for the Air Force Concepts Development and Management Office. And 23, $320 million for Joint Special Operations Command. Section 20011, improving Department of Defense border support and countering drug missions. In addition to amounts otherwise available, they are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029, $1 billion for the deployment of military personnel in support of border operations, operations and maintenance activities in support of border operations, counter-narcotics and counter-transnational criminal organization mission support, the operation of national defense areas and construction in national defense areas, and the temporary detention of migrants on Department of Defense installations in accordance with Chapter 15 of Title 10, United States Code. Section 20012, Department of Defense Oversight. In addition to amounts otherwise available, there is appropriated to the Inspector General of the Department of Defense for fiscal year 2025, out of any money in the Treasury not otherwise appropriated, $10 million to remain available through September 30th, 2029, to monitor Department of Defense activities for which funding is appropriated in this title, including 1, programs with mutual technological dependencies, 2, programs with related data management and data ownership considerations, and 3, programs particularly vulnerable to supply chain disruptions and long lead time components. Section 20013, military construction projects authorized. A, authorization of appropriations. Funds are hereby authorized to be appropriated for military construction, land acquisition, and military family housing functions of each military department as defined in Section 101A of Title 10, United States Code, as specified in this title. B, spending plan. No later than 30 days after the date of the enactment of this title, the Secretary of each military department shall submit to the Committees on Armed Services of the Senate and House of Representatives a detailed spending plan by project for all funds made available by this title to be expended on military construction projects. Section 20014, multi-year operational plan. A, in general, not later than 60 days after the date of the enactment of this act, the Secretary of Defense and the Administrator of the National Nuclear Security Administration shall submit to the Committees on Armed Services of the Senate and the House of Representatives a plan detailing how the funds appropriated to the Department of Defense the National Nuclear Security Administration under the Act will be spent over the 4-year period ending with fiscal year 2029. B, quarterly updates. 1, in general, not later than the last day of each calendar quarter beginning during the applicable period, the Secretary of Defense shall submit to the Committees on Armed Services of the Senate and the House of Representatives a report on the plan established under subsection A, including A, any updates to the plan, B, progress made in implementing the plan, and C, any changes in circumstances or challenges in implementing the plan. 2, applicable period. For purposes of paragraph 1, the applicable period is the period beginning 1 year after the date of the plan required under subsection A is due and ending on September 30th, 2029. C, reduction in appropriation. 1, in general, in the case of any failure to submit a plan required under subsection A or the report required under subsection B by the date specified in paragraph 2, the amounts made available to the Department of Defense under this act shall be reduced by $100,000 for each day after such specified date that the report has not been submitted to Congress. 2, specified date. For purposes of the reduction in appropriations under paragraph 1, the specified date is the date that is 60 days after the date the plan or report is required to be submitted under subsection A or B, as the case may be. Title 3, Committee on Banking, Housing, and Urban Affairs. Section 30001, Funding Cap for the Bureau of Consumer Financial Protection. Section 1017A2A3 of the Consumer Financial Protection Act 2010, 12 U.S.C. 5497A2A3 is amended by striking 12 and inserting 6.5. Section 30002, Rescission of Funds for Green and Resilient Retrofit Program for Multifamily Housing. The unobligated balances of amounts made available under Section 30002A of the Act entitled An Act to Provide for Reconciliation pursuant to Title II of S. Con. Res. 14, approved August 16, 2022, Public Law 117, 169, 136, Statute 2027, are rescinded. Section 30003, Securities and Exchange Commission Reserve Fund. A, in general, Section 4 of the Securities Exchange Act of 1934, 15 U.S.C. 78D is amended, 1, by striking subsection 1, and 2, by redesignating subsections J and K as subsections I and J, respectively. B, technical and conforming amendment. Section 21FG2 of the Securities Exchange Act of 1934, 15 U.S.C. 78U G 6.2 is amended to read as follows. A, use of fund. The fund shall be available to the Commission without further appropriation or fiscal year limitation for paying awards to whistleblowers as provided in subsection B. C, transition provision. During the period beginning on the date of enactment of this Act and ending on October 1st, 2025, the Securities and Exchange Commission may expend amounts in the Securities and Exchange Commission Reserve Fund that were obligated before the date of enactment of this Act for any program, project, or activity that is ongoing as of the day before the date of enactment of this Act, in accordance with subsection 1 of subsection 4 of the Securities Exchange Act of 1934, 15 U.S.C. 78D, as in effect on the day before the date of enactment of this Act. D, transfer of remaining amounts. Effective on October 1st, 2025, the obligated and unobligated balances of amounts in the Securities and Exchange Commission Reserve Fund shall be transferred to the General Fund of the Treasury. E, closing of account. For the purposes of Section 1555 of Title 31, United States Code, the Securities and Exchange Commission Reserve Fund shall be considered closed and thereafter shall not be available for obligation or expenditure for any purpose upon execution of the transfer required under subsection D. Section 30004, Appropriations for Defense Production Act. In addition to amounts otherwise available, there is appropriated for fiscal year 2025, out of amounts not otherwise appropriated, $1 billion to remain available until September 30th, 2027, to carry out the Defense Production Act, 50 U.S.C. 4501. Title 4, Committee on Commerce, Science, and Transportation.
Section 40001, Coast Guard Mission Readiness. A, in general, Chapter 11 of Title 14 United States Code is amended by adding at the end the following. Subchapter 5, Coast Guard Mission Readiness. Section 1181, Special Appropriations. In addition to amounts otherwise available, there is appropriated to the Coast Guard for fiscal year 2025 out of any money in the Treasury not otherwise appropriated, $24,593,500,000,000 to remain available until September 30th, 2029, notwithstanding paragraphs 1 and 2 of Section 1105A and Sections 1131, 1132, 1133, and 1156 to use expedited processes to procure or acquire new operational assets and systems, to maintain existing assets and systems, to design, construct, plan, engineer, and improve necessary shore infrastructure, and to enhance operational resilience for monitoring, search and rescue, interdiction, hardening of maritime approaches, and navigational safety, of which $1,142,500,000,000 is provided for procurement and acquisition of fixed-wing aircraft, equipment related to such aircraft, and training simulators and program management for such aircraft to provide for security of the maritime border. $2,283,000,000,000 is provided for procurement and acquisition of rotary wing aircraft, equipment related to such aircraft, and training simulators and program management for such aircraft to provide for security of the maritime border. 3, $266 billion is provided for procurement and acquisition of long-range unmanned aircraft and base stations, equipment related to such aircraft and base stations, and program management for such aircraft and base stations to provide for security of the maritime border. 4, $4,300,000,000,000 is provided for procurement of offshore patrol cutters, equipment related to such cutters, and program management for such cutters to provide operational presence and security of the maritime border for the interdiction of persons and controlled substances. 5, $1 trillion is provided for procurement of fast response cutters, equipment related to such cutters, and program management for such cutters to provide operational presence and security of the maritime border for interdiction of persons and controlled substances. 6, $4,300,000,000,000 is provided for procurement of polar security cutters, equipment related to such cutters, and program management for such cutters to ensure timely presence of the Coast Guard in the Arctic and Antarctic regions. 7, $3,500,000,000 is provided for procurement of Arctic security cutters, equipment related to such cutters, and program management for such cutters to ensure timely presence of the Coast Guard in the Arctic and Antarctic regions. 8, $816 billion is provided for procurement of light and medium ice-breaking cutters and equipment related to such cutters from shipyards that have demonstrated success in the cost-effective application of design standards and in delivering on schedule and within budget vessels of size and tonnage that are not less than the size and tonnage of the cutters described in this paragraph, and for program management for such cutters to expend domestic icebreaking capacity. 9, $126 billion is provided for procurement of waterways, commerce cutters, equipment related to such cutters, and program management for such cutters to support aids to navigation, waterways, and coastal security, and to search and rescue in inland waterways. 10, $4,379,000,000,000 is provided for design, planning, engineering, recapitalization, construction, rebuilding, and improvement of, and program management for shore facilities, of which A, $425 billion is provided for design, planning, engineering, construction of, and program management for 1, the enlisted boot camp barracks and multi-use training center, and 2, other related facilities at the enlisted boot camp. B, $500 billion is provided for 1, construction, improvement, and dredging of the Coast Guard yard, and 2, acquisition of a floating dry dock for the Coast Guard yard. C, not more than $2,729,500,000 is provided for home ports and hangars for cutters and aircraft for which funds are appropriated under paragraph 1 through 9, and D, $300 billion is provided for home porting of the existing polar icebreaker commissioned into service in 2025. 11, $2,200 billion is provided for aviation cutter and shore facility depot maintenance and maintenance of command control communication, computer and cyber assets. 12, $170 billion is provided for improving maritime domain awareness on the maritime border at United States ports and land-based facilities and in the cyber domain. And 13, $75 billion is provided to contract the services of acquire or procure autonomous maritime systems. B, technical and conforming amendment. The analysis for Chapter 11 of Title 14 United States Code is amended by adding at the end the following. Subchapter 5, Coast Guard Mission Readiness, 1181, Special Appropriations. Section 4002, Spectrum Auctions. A, definitions. In this section, 1, Assistant Secretary. The term Assistant Secretary means the Assistant Secretary of Commerce for Communications and Information. 2, Commission. The term Commission means the Federal Communications Commission. 3, Covered Band. The term covered band, A, except as provided in subparagraph B, means the band of frequencies between 1.3 gigahertz and 10.5 gigahertz, and B, does not include 1, the band of frequencies between 3.1 gigahertz and 3.45 gigahertz for purpose of auction, reallocation, modification, or withdrawal, or 2, the band of frequencies between 7.4 gigahertz and 8.4 gigahertz for purpose of auction, reallocation, modification, or withdrawal. 4, full power commercial licensed use cases. The term full power commercial licensed use cases means flexible use wireless broadband services with base station power levels sufficient for high power, high density, and wide area communication mobile services consistent with the service rules under Part 27 of Title 47, Code of Federal Regulations, or any successor regulations for wireless broadband deployment through the covered band. B, General Auction Authority. 1, Amendment. Section 309(1)11 of the Communications Act of 1934, 47 U.S. Code 309(1)11 is amended by striking, grant a license or permit under this subsection shall expire March 9, 2023, and all that follows, and inserting the following, complete a system of competitive bidding under this subsection shall expire September 30th, 2034, except that with respect to the electromagnetic spectrum, A, between frequencies of 3.1 gigahertz and 3.45 gigahertz, such authority shall not apply. And B, the frequencies of 7.4 gigahertz and 8.4 gigahertz, such authority shall not apply. 2, spectrum auctions. The Commission shall grant licenses through systems of competitive bidding before the expiration of the general auction authority of the Commission under Section 309(1)11 of the Communications Act of 1934, 47 U.S.C. 309(1)11 as amended by paragraph 1 of this subsection for not less than 300 megahertz, including by completing a system of competitive bidding not later than 2 years after the date of enactment of this act for not less than 100 megahertz in the band between 3.9 gigahertz and 4.2 gigahertz. C, identification for reallocation. In general, the Assistant Secretary, in consultation with the Commission, shall identify 500 megahertz of frequencies in the covered band for reallocation to non-federal use, shared federal and non-federal use, or a combination thereof, for full power commercial licensed use cases that, A, as of the date of enactment of this act are allocated for federal use, and B, shall be in addition to the 300 megahertz of frequencies for which the Commission grants licenses under subsection B2. 2, schedule. The Assistant Secretary shall identify the frequencies under paragraph 1 according to the following schedule. A, not later than 2 years after the date of enactment of this act, the Assistant Secretary shall identify not less than 200 megahertz of frequencies within the covered band. B, not later than 4 years after the date of enactment of this act, the Assistant Secretary shall identify any remaining bandwidth required to be identified under paragraph 1. 3, required analysis. A, in general, in determining under paragraph 1 which specific frequencies within the covered band to reallocate, the Assistant Secretary shall determine the feasibility of the reallocation of frequencies. B, requirements. In conducting the analysis of subparagraph A, the Assistant Secretary shall assess the net revenue potential, relocation or sharing costs as applicable, and the feasibility of reallocating specific frequencies with the goal of identifying the best approach to maximize net proceeds of system of competitive bidding for the Treasury, consistent with Section 3091 of the Communication Act of 1934, 47 U.S. Code 3091. D, auction. The Commission shall grant licenses for the frequencies identified for a reallocation under subsection C through systems of competitive bidding in accordance with the following schedule. 1, not later than 4 years after the date of enactment of this act, the Commission shall, after notifying the Assistant Secretary, complete one or more systems of competitive bidding for not less than 200 megahertz of the frequencies. 2, not later than 8 years after the date of enactment of this act, the Commission shall, after notifying the Assistant Secretary, complete one or more systems of competitive bidding for any frequencies under subsection C that remain to be auctioned after compliance with paragraph 1 of this subsection. E, limitation. The President shall modify or withdraw any frequencies proposed for reallocation under this section not later than 60 days before the commencement of a system of competitive bidding scheduled by the Commission with respect to that frequency. If the President determines that such modification or withdrawal is necessary to protect the national security of the United States. F, appropriation. In addition to amounts otherwise available, there is appropriated to the Department of Commerce for fiscal year 2025 out of any money in the Treasury not otherwise appropriated, $50 billion to remain available through September 30th, 2034 to provide additional support for the Assistant Secretary to 1, conduct a timely spectrum analysis of the bands of frequencies, A, between 2.7 gigahertz and 2.9 gigahertz, B, between 4.4 gigahertz and 4.9 gigahertz, C, between 7.25 gigahertz and 7.4 gigahertz, and 2, publish a biennial report with the last report to be published not later than June 30th, 2034, on the value of all spectrum used by federal entities as defined in Section 113(1) of the National Telecommunication and Information Administration Organization Act, 47 U.S.C. 923(1), that assesses the value of bands of frequencies of increments of not more than 100 megahertz. Section 40003, Air Traffic Control Improvements. A, in general, for the purpose of the acquisition, construction, sustainment, and improvement of facilities and equipment necessary to improve or maintain aviation safety, in addition to amounts otherwise made available, there is appropriated to the Administrator of the Federal Aviation Administration for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $4,750 billion for telecommunications and infrastructure modernization and system upgrades, $3 trillion for radar system replacement, $500 billion for runway safety technologies, runway lighting systems, airport surface surveillance technologies, and to carry out Section 347 of the FAA Reauthorization Act of 2024 for $300 billion for enterprise information systems, display systems, $80 billion to acquire and install not less than 50 automated weather observing systems, to acquire and install not less than 60 visual weather observing systems, to acquire and install not less than 64 weather camera sites, and to acquire and install weather stations. 6, $40 billion to carry out Section 44745 of Title 49 United States Code, except for the activities described in paragraph 5. 7, $1,900 billion for necessary actions to construct a new air route traffic control center in the subsection referred to as ARTCC, provided that not more than 2% of such amount is used for planning or administrative purposes, provided further that at least 3 existing ARTCCs are divested and integrated into the newly constructed ARTCC. 8, $100 billion to conduct an ARTCC realignment and consolidation effort under which at least 10 existing ARTCCs are closed or consolidated to facilitate recapitalization of ARTCC facilities owned and operated by the Federal Aviation Administration. 9, $1 trillion to support recapitalization and consolidation of terminal radar approach control facilities. In this subsection, referred to as TRACONs, the analysis of identification of TRACONs for divestment, consolidation, or integration, planning, site selection, facility acquisition, and transition activities and other appropriate activities for carrying out such divestment, consolidation, or integration, and the establishment of brand new TRACONs. 10, $350 billion for unstaffed infrastructure and replacement. 11, $50 billion to carry out Section 961 of FAA Reauthorization Act of 2024. 12, $300 billion to carry out Section 619 of the FAA Reauthorization Act of 2024. 13, $50 billion to carry out Section 621 of the FAA Reauthorization Act of 2024 and to deploy remote tower technology in untowered airports. 14, $100 billion for air traffic control advanced training technologies. B, quarterly reporting. Not later than 180 days after the date of enactment of this act, and every 90 days thereafter, the Administrator of the Federal Aviation Administration shall submit to Congress a report that describes any expenditures under this section. Section 40004, Space Launch and Reentry Licensing and Permitting User Fees. A, in general, Chapter 509 of Title 51, United States Code, is amended by adding at the end of the following new section. Section 50924, Space Launch and Reentry Licensing and Permitting User Fees. A, fees. 1, in general, the Secretary of Transportation shall impose a fee which shall be deposited in the account established under subsection B on each launch or reentry carried out under a license or permit issue under Section 50904 during 2026 or a subsequent year, in an amount equal to the lesser of A, the amount specified in paragraph 2 for the year involved per pound of the weight of the payload, or B, the amount specified in paragraph 3 for the year involved. 2, paragraph 2 specified amount. The amount specified in this paragraph is A, for 2026, 25 cents, B, for 2027, 35 cents, C, for 2028, 50 cents, D, for 2029, 60 cents, E, for 2030, 75 cents, F, for 2031, $1, G, for 2032, $1.25, C, for 2033, $1.50, and I for 2034 and each subsequent year, the amount specified in this paragraph for the previous years increased by the percentage increase in the Consumer Price Index for all urban consumers, all items United States city average over the previous year. 3, paragraph 3, specified amount. The amount specified in this paragraph is A for 2026, $30,000, B for 2027, $40,000, C for 2028, $50,000, D for 2029, $75,000, E for 2030, $100,000, F for 2031, $125,000, G for 2032, $170,000, H for 2033, $200,000, and I for 2034 and each subsequent year. The amount specified in this paragraph for the previous year increased by the percentage increase in the Consumer Price Index for all urban consumers, all items United States city average over the previous year. B, Office of Commercial Space Transportation Launch and Reentry Licensing and Permitting Fund. There is established in the Treasury of the United States a separate account which shall be known as the Office of Commercial Space Transportation Launch and Reentry Licensing and Permitting Fund for the purposes of expenses of the Office of Commercial Space Transportation of the Federal Aviation Administration and to carry out Section 603B of the FAA Reauthorization Act of 2024. 70% of the amounts deposited into the fund shall be available for such purposes and shall be available without further appropriation and without fiscal year limitations. B, clerical amendment. The table of sections for Chapter 509 of Title 51 United States Code is amended by inserting after the item relating to Section 50923 the following. 50924, Space Launch and Reentry Licensing and Permitting User Fees. Section 40005, Mars Missions, Artemis Missions, and Moon to Mars Program. In general, Chapter 203 of Title 51 United States Code is amended by adding at the end of the following. Section 20306, Special Appropriations for Mars Missions, Artemis Missions, and Moon to Mars Program. A, in general, in addition to amounts otherwise available, there is appropriated to the administration for the fiscal year 2025 out of any money in the Treasury not otherwise appropriated, $9,995 billion to remain available until September 30th, 2032 to use as follows. $700 billion to be obligated not later than fiscal year 2026 for the procurement using a competitively bid firm fixed price contract with the United States commercial provider as defined in Section 501017 of a high-performance Mars telecommunications orbiter. A, that one is capable of providing robust continuous communication for a Mars sample return mission as described in Section 4323C of the National Aeronautics and Space Transition Authorization Act of 2017, 51 U.S. Code 20302, note Public Law 115-10. And 2, future Mars surface, orbital, and human exploration missions. 2, supports autonomous operations, onboard processing, and extended mission duration capabilities. And 3, is selected from among the commercial proposals that 1, receive funding from the administration in fiscal year 2024 or 2025 for commercial design studies for Mars sample returns, and 2, proposed a separate, independently launched Mars telecommunications orbiter supporting an end-to-end Mars sample return mission, and B, which shall be delivered to the administration not later than December 31st, 2028. 2, $2.6 trillion to meet the requirements of Section 20302A using the program of record known as of the date of the enactment of this section as Gateway and as described in Section 10811B2B4 of the National Aeronautics and Space Administration Authorization Act of 2022, 51 U.S.C. 20302, note Public Law 117-167, of which not less than $750 billion shall be obligated for each of fiscal years 2026, 2027, and 2028. 3, $4.1 trillion for expenses related to meeting the requirements of Section 10812 of the National Aeronautics and Space Administration Authorization Act of 2022, 5 U.S. Code 2031301, Public Law 117-167, for the procurement, transportation, integration, operation, and other necessary expenses of the Space Launch System for Artemis Mission 4 and 5, of which not less than $1.025 billion shall be obligated for each of fiscal years 2026, 2027, 2028, 2029. 4, $20 billion for expenses related to the continued procurement of the multipurpose crew vehicle described in Section 303 of the National Aeronautics and Space Administration Authorization Act of 2020, 42 U.S. Code 18323, known as the Orion, for use with the Space Launch System on the Artemis 4 mission and reuse in subsequent Artemis missions, of which not less than $20 billion shall be obligated not later than fiscal year 2026. 5, $1.25 billion for expenses related to the operation of the International Space Station and for the purpose of meeting the requirements under Section 503A of the National Aeronautics and Space Administration Authorization Act of 2010, 42 U.S.C. 18353A, of which not less than $250 billion shall be obligated for such expenses for each of fiscal years 2025, 2026, 2027, 2028, and 2029. 6, $1 trillion for infrastructure improvements at the manned spaceflight centers of the administration, of which not less than $120 billion shall be obligated not later than fiscal year 2026 for the construction, revitalization, recapitalization, and other infrastructure projects and improvements at the center described in Executive Order 12641, 53 Federal Register 18816, related to designating certain facilities of the National Aeronautics and Space Administration in the state of Mississippi as the John C. Stennis Space Center. B, $250 billion shall be obligated not later than fiscal year 2026 for construction, revitalization, recapitalization, and other infrastructure projects and improvements at the center described in Executive Order 11129, 28 Federal Register 12787, relating to designating certain facilities in the National Aeronautics and Space Administration and of the Department of Defense in the state of Florida at the John F. Kennedy Space Center. C, $300 billion shall be obligated not later than fiscal year 2026 for construction, revitalization, recapitalization, and other infrastructure projects and improvements at the center described in the joint resolution entitled Joint Resolution to Designate the Manned Spacecraft Center in Houston, Texas as the Lyndon B. Johnson Space Center in honor of the late president, approved February 17, 1973, Public Law 93-8, 87, Statute 7. D, $100 billion shall be obligated not later than fiscal year 2026 for construction, revitalization, recapitalization, and other infrastructure projects and improvements at the center described in Executive Order 10870, 25 Federal Register 2197, relating to designating the facilities of the National Aeronautics and Space Administration in Huntsville, Alabama as the George C. Marshall Space Flight Center. E, $300 billion shall be obligated not later than fiscal year 2026 for construction, revitalization, recapitalization, and other infrastructure projects and improvements at the Michaud Assembly Facility in New Orleans, Louisiana. And F, $85 billion shall be obligated to carry out subsection B, of which not less than $5 million shall be designated for the transportation of the space vehicle described in that subsection, with the remainder transferred not later than the date, that is 18 months after the date of enactment of this section, and entity designated under the subsection for the purpose of constructing a facility to house the space vehicle referred to in that subsection. 7, $325 billion to fulfill contract number 80JSC024CA002 issued by the National Aeronautics and Space Administration on June 26, 2024, space vehicle transfer in general not later than 30 days after the date of enactment of this section. The administrator shall identify the space described in paragraph 2 to be
B, placed on public exhibition at an entity within the metropolitan statistical area where such center is located. 2, space vehicle described. A space vehicle described in this paragraph is a vessel that A, has flown into space, B, has carried astronauts, and C, is selected with the concurrence of an entity designated by the administrator. 3, transfer. A, in general, not later than 18 months after the date of the enactment of this section, the space vehicle identified under paragraph 1 shall be transferred to an entity designated by the administrator. B, title, not later than 1 year after the date on which a space vehicle is identified under paragraph 1, the federal government shall, as applicable, transfer the title to the space vehicle to the entity designated by the administrator. C, responsibility. The transfer under this paragraph shall be carried out under the administrator or acting administrator. C, obligation of funds. Funds appropriated under subsection A shall be obligated as follows. 1, not less than 50% of the total funds in subsection A shall be obligated not later than September 30th, 2028. 2, 100% of funds shall be obligated not later than September 30th, 2029. 3, all associated outlays shall occur not later than September 30th, 2034. B, clerical amendment. The table of sections for Chapter 203 of Title 51 United States Code is amended by adding at the end the following: 20306, Special Appropriations for Mars Missions, Artemis Missions, and Moons to Mars Program. Section 40006, Corporate Average Fuel Economy Civil Penalties. A, in general, Section 32912 of Title 49 United States Code is amended. 1, in subsection B, in the matter preceding paragraph 1 by striking $5 and inserting $0, and 2, in subsection C1B by striking $10 and inserting $0. B, effect applicability. The amendments made by subsection A shall 1, take effect on the date of the enactment of this section, and 2, apply to all model years of manufacture for which the Secretary of Transportation has not provided a notification pursuant to Section 32903B2B of Title 49 United States Code, specifying the penalty due for the average fuel economy of that manufacturer being less than the applicable standard prescribed under Section 32902 of that title. Section 40007, payments for lease of metropolitan Washington airports. Section 49104B of Title 49 United States Code is amended to read as follows. B, payments. 1, in general, subject to paragraph 2, under the lease, the airport's authority must pay to the general fund of the Treasury annually an amount computed using the GNP price deflator, A, during the period from 1987 to 2026, equal to $3 million in 1987 dollars, and B, for 2027 and subsequent years, equal to $15 million in 2027 dollars. 2, renegotiation. The Secretary and Airports Authority shall renegotiate the level of lease payments at least once every 10 years to ensure that in no year the amount specified in paragraph 1B is less than $15 million in 2027 dollars. Section 40008, rescission of certain amounts for the National Oceanic and Atmospheric Administration. Any unobligated balances of amounts appropriated or otherwise made available by sections 40001, 40002, 40003, and 40004 of Public Law 117-169, 136-2028 are hereby rescinded. Section 40009, reduction in annual transfer to Travel Promotion Fund. Subsection D2B of the Travel Promotion Act of 2009, 22 U.S.C. 2131 D2B is amended by striking $100 million and inserting $20 million. Section 40010, treatment of unobligated funds for alternative fuel and low emissions aviation technology. Out of the amounts made available in Section 40007A of Title IV of Public Law 117-169, 49 U.S.C. 44504 note, any obligated balances of such amounts are hereby rescinded. Section 40011, rescission of amounts appropriated to Public Wireless Supply Chain Innovation Fund. Of the unobligated balances of amounts made available under Section 106A of the CHIPS Act of 2022, Public Law 117-167, 136-1392, $850 million are permanently rescinded. Section 40012, support for artificial intelligence under the Broadband Equity, Access, and Deployment Program. A, in general, Section 60102 of Division F of Public Law 117-58, 47 U.S.C. 1702 is amended. 1, in subsection A2, A, by redesignating subparagraphs B through N as subparagraphs F through R, respectively. B, by redesignating subparagraph A as subparagraph D. C, by inserting before subparagraph D, as so redesignated, the following. A, artificial intelligence. The term artificial intelligence has the meaning given the term in Section 5002 of the National Artificial Intelligence Initiative Act of 2020, 15 U.S.C. 9401. B, artificial intelligence model. The term artificial intelligence model means a software component of an information system that implements artificial intelligence technology and uses computational, statistical, or machine learning techniques to produce outputs from a defined set of inputs. C, artificial intelligence system. The term artificial intelligence system means any data system, software, hardware, application, tool, or utility that operates in whole or in part using artificial intelligence. D, by inserting after subparagraph D, as so redesignated, the following. E, automated decision system. The term automated decision system means any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues a simplified output, including a score, classification, or recommendation, to materially influence or replace human decision-making. And E, by striking subparagraph O, as so redesignated, and inserting the following. O, project. The term project means an undertaking by a sub-grantee under this section to construct and deploy infrastructure for the provision of 1, broadband services, or 2, artificial intelligence models, artificial intelligence systems, or automated decision systems. 2, in subsection B, by adding at the end the following. 5, appropriation for fiscal year 2025. A, in general, in addition to any amounts otherwise appropriated to the program, there is appropriated to the Assistant Secretary for fiscal year 2025 out of any funds in the Treasury not otherwise appropriated, $500 million to remain available until expended to carry out the program. B, set aside for artificial intelligence infrastructure master services agreements of the amount appropriated under subparagraph A, $25 million shall be used by the Assistant Secretary for the purpose of negotiating master service agreements on behalf of subgrantees of an eligible entity or political subdivision to enable access to quantity purchasing and licensing discounts for the construction, acquisition, and deployment of infrastructure for the provision of artificial intelligence models, artificial intelligence systems, or automated decision systems funded under this section. 3, in subsection F, A in paragraph 5 by striking and at the end, B by redesignating paragraph 6 as paragraph 7, and C by inserting after paragraph 5 the following. 6, the construction and deployment of infrastructure for the provisions of artificial intelligence models, artificial intelligence systems, or automated decision systems, and 4, in subsection G3 by striking subparagraph B and inserting the following. B, may, in addition to other authority under applicable law, deobligate grant funds awarded to an eligible entity that 1, violates paragraph 2, 2, demonstrates an insufficient level of performance or wasteful or fraudulent spending as defined in advance by the Assistant Secretary, or 3, obligated any funds made available under subsection B5A is not in compliance with subsection Q or R, and 5, in subsection J1, A in subparagraph A, 1 in Clause 3 by striking and at the end, 2 by redesignating Clause 4 as Clause 5, and 3 by inserting after Clause 3 the following. 4, certifies that the eligibility entity of obligated any funds made available under subsection B5A is compliance with subsections Q and R, and B in subparagraph B, 1 in Clause 3 by striking and at the end, 2 by redesignating Clause 4 as Clause 5, and 3 by inserting after Clause 3 the following. 4, certifies that the eligibility entity of obligated any funds made available under subsection B5A is in compliance with subsections Q and R, and C in subparagraph C, 1 by redesignating clauses 4 and 5 as clauses 5 and 6 respectively, 2 by inserting after clause 3 the following. 4, certifies that the eligibility entity, if obligated, any funds made available under subsection B5A is in compliance with subsections Q and R, and 6, by adding at the end the following. P, receipt of funds conditioned on temporary pause and efficiencies. On and after the date of the enactment of this subsection, no funds made available under subsection B5A may be obligated to an eligible entity or political subdivision thereof that is not in compliance with subsections Q and R. Q, temporary pause. 1, in general, except as provided in paragraph 2, no eligible entity or political subdivision thereof to which funds made available under subsection B5A are obligated on or after the date of enactment of this subsection may enforce during the 10-year period beginning on the date of enactment of this subsection any law or regulation that eligible entity or political subdivision thereof limiting, restricting, or otherwise regulating artificial intelligence models, artificial intelligence systems, or automated decision systems entered into interstate commerce. 2, rule of construction. Paragraph 1 may not be construed to prohibit the enforcement of any law or regulation. A, the primary purpose and effect of which is to, 1, remove legal impediments to or facilitate the deployment or operation of an artificial intelligence model, artificial intelligence system, or automated decision system. Or 2, streamline licensing, permitting, routing, zoning, procurement, or reporting procedures in a manner that facilitates the adoption of artificial intelligence models, artificial intelligence systems, or automated decision systems. Or B, that does not impose any substantive design, performance, data holding, documentation, civil liability, taxation fee, or other requirement of artificial intelligence models, artificial intelligence systems, or automated decision systems, unless that requirement is imposed under 1, federal law, 2, a general applicable law, such as a body of common law, and C, that does not impose a fee or bond unless 1, the fee or bond is reasonable and cost-based, and 2, under the fee or bond, artificial intelligence models, artificial intelligence systems, and automated decision systems are treated in the same manner as other models and systems that perform comparable functions. R, master service agreements. An eligible entity or political subdivision thereof to which funds made available under subsection B5A are obligated on or after the date of the enactment of this subsection shall certify to the Assistant Secretary either that 1, each subgrantee of the eligible entity or political subdivision is utilizing applicable master service agreements negotiated using amounts made available under subsection B5B, or 2, each contract, license, purchase order, or service agreement entered into, procured, or made by a subgrantee of the eligible entity or political subdivision for purposes described in subsection B5B is at least as cost-effective as the terms of executable master services agreements as applicable negotiated by the Assistant Secretary using amounts made available under subsection B5B. B, technical conforming amendments. Section 60102A1 of Division F of Public Law 117-58, 47 U.S.C. 1702A1 is amended, 1, in subparagraph B by striking a project and inserting a project described in subsection A20I, and 2, in subparagraph D by striking a project and inserting a project described in subsection A20I. Title 5, Committee on Energy and Natural Resources. Subtitle A, Oil and Gas Leasing. Section 50101, Onshore Oil and Gas Leasing. A, Repeal of Inflation Reduction Act provisions. 1, onshore oil and gas royalty rates, subsection A of section 50262 of Public Law 117-169-136-2056 is repealed, and provision of law amended or repealed by that subsection is restored or revived as if the subsection had not been enacted into law. 2, non-competitive leasing. Subsection E of Section 50262 of Public Law 117-169-136.2057 is repealed, and any provision of law amended or repealed by that subsection is restored or revived as if the subsection had not been enacted into law. B, requirement to immediately resume onshore oil and gas leases. 1. In general, the Secretary of the Interior shall immediately resume quarterly onshore oil and gas lease sales in compliance with the Mineral Leasing Act, 30 U.S.C. 181 et sec. 2. Requirement, the Secretary of the Interior shall, A, that any oil and gas lease required under paragraph 1 is conducted immediately on completion of an applicable scoping, public comment, and environmental analysis requirements under the Mineral Leasing Act, 30 U.S.C. 181 et sec, and the National Environmental Policy Act of 1965, 42 U.S.C. 4321, and B, that the process described in subparagraph A are conducted in a timely manner to ensure compliance with subsection B1. 3. Lease of oil and gas lands, section 17B1A of the Mineral Leasing Act, 30 U.S.C. 226B1A, as amended by subsection A, is amended by inserting, for purposes of the previous sentence, the term eligible land means all lands that are subject to leasing under this act and are not excluded from leasing by statutory prohibition. And the term available with respect to eligible lands means those that have been designated as open for leasing under a land use plan developed under Section 202 of the Federal Land Policy and Management Act of 1976, 43 U.S.C. 1712, and that have been nominated for leasing through the submission of an expression of interest, are subject to drainage in the absence of leasing, or are otherwise designated as available pursuant to regulations adopted by the Secretary after sales are necessary. C, quarterly lease sales. 1, in general, in accordance with the Mineral Leasing Act, 30 U.S.C. 181, each fiscal year the Secretary of the Interior shall conduct a minimum of 4 oil and gas lease sales of available land in each of the following states: A, Wyoming, B, New Mexico, C, Colorado, D, Utah, E, Montana, F, North Dakota, G, Oklahoma, H, Nevada, I, Alaska. 2, requirement. In conducting a lease sale under paragraph 1 in a state described in that paragraph, the Secretary of the Interior, A, shall offer not less than 50% of available parcels nominated for oil and gas development under the applicable resource management plan in effect for relevant Bureau of Land Management resource management areas within the applicable state, and B, shall not restrict the parcels offered to one Bureau of Land Management field office within the applicable state unless all nominated parcels are located within the same Bureau of Land Management field office. 3, replacement sales. The Secretary of the Interior shall conduct a replacement sale during the same fiscal year if A, a lease sale under paragraph 1 is canceled, delayed, or deferred, including for a lack of eligible parcels, or B, during a lease sale under paragraph 1, the percentage of acreage that does not receive a bid is equal to or greater than 25% of the acreage offered. D, Mineral Leasing Act reforms. Section 17 of the Mineral Leasing Act, 30 U.S.C. 226, as amended by subsection A, is amended. 1, by striking the section designation and all that follows through the end of subsection A and inserting the following. Section 17, leasing of oil and gas parcels. A, leasing authorized. 1, in general, any parcel of land subject to disposition under this act that is known or believed to contain oil or gas deposits shall be made available for leasing subject to paragraph 2 by the Secretary of the Interior not later than 18 months after the date of the receipt of the Secretary of an expression of interest in the leasing applicable parcel of land available for disposition under this section. If the Secretary determines that the parcel of land is open to oil or gas leasing under the approved resource management plan applicable to the planning area in which the parcel of land is located, that is in effect on the date on which the expression of interest was submitted to the Secretary, referred to in this subsection as the approved resource management plan. 2, resource management plans. A, lease and terms and conditions. A lease issued by the Secretary under the section with respect to applicable parcel of land made available for leasing under paragraph 1. 1 shall be subject to the terms and conditions of the approved resource management plan, and 2 may not require any stipulations or mitigation requirements not included in the approved resource management plan. B, effective amendment. The initiation of an amendment to an approved resource management plan shall not prevent or delay the Secretary from making the applicable parcel of land available for leasing in accordance with the approved resource management plan if the other requirements in this section have been met as determined by the Secretaries. 2, in subsection P, by adding at the end the following. 4, term. A permit to drill approved under this section shall be valid for a single, non-renewable 4-year period beginning on the date that the permit to drill is approved. And 3, by striking subsection Q and inserting the following. Q, commingling of production. The Secretary of Interior shall approve applications allowing for the commingling of production from 2 or more sources, including the area of oil and a gas lease, the area included in a drilling spacing unit, a unit participating area, a communitized area, or a non-federal property. Before production reaches the point of royalty measurement, regardless of ownership, the royalty rates and the number of percentage of acres for each source, if the applicant agrees to install measurement devices for each source, utilize an allocation method that achieves volume measurement, uncertainty levels within plus or minus 2% during the production phase reported on a monthly basis, or utilize an approved periodic well testing methodology. Production from multiple oil and gas leases, drilling space units, communitized areas, or participating areas from a single wellbore shall be considered a single source. Nothing in this subsection shall prevent the Secretary of the Interior from continuing the current practice of exercising discretion to authorize higher percentage volume measurements, uncertainty levels, if appropriate technical and economic justifications have been provided. Section 50102, offshore oil and gas leasing. A, lease sales. 1, Gulf of America region. A, in general. Notwithstanding the 2024 to 2029 National Outer Continental Shelf Oil and Gas Leasing Program and any successor leasing program that does not satisfy the requirements of this section, in addition to lease sales, which may be held under the program and except within areas subject to existing oil and gas leasing moratoria, the Secretary of the Interior shall conduct a minimum of 30 region-wide oil and gas lease sales in a manner consistent with the schedule described in subparagraph B, in the region identified in the map, depicting the lease terms and economic conditions accompanying the final notice of sale of the Bureau of Oceanic Energy Management entitled Gulf of Mexico Outer Continental Shelf Region-Wide Oil and Gas Lease Sale 25485 Fed Reg 8010, February 12, 2020. B, timing requirement. Of the not fewer than 30 region-wide lease sales required under this paragraph, the Secretary of Interior shall, 1, hold not fewer than 1 lease sale in the region described in subparagraph A by December 15, 2025, 2, hold not fewer than 2 lease sales in the region in each of the calendar years 2026 to 2039, one of which shall be held by March 15th of the applicable calendar year, and one of which shall be held after March 15th, but not later than August 15th of the applicable calendar year, and 3, hold not fewer than 1 lease sale in the region in calendar year 2040, which shall be held on March 15th, 2040. Alaska region. A, in general, the Secretary of the Interior shall conduct a minimum of 6 offshore lease sales in a manner consistent with the schedule described in subparagraph B in the Cook Inlet Planning Area as identified in the 2017 to 2022 Outer Continental Shelf Oil and Gas Leasing Proposed Final Program published on November 18, 2016 by the Bureau of Ocean Energy Management, as announced in the Notice of Availability of the Bureau of Ocean Energy Management entitled Notice of Availability of the 2017 to 2022 Outer Continental Shelf Oil and Gas Leasing Program Proposed Final Program, 81 Federal Register 84612, November 23, 2016. B, timing requirements. Of the not fewer than 6 lease sales required under this paragraph, the Secretary of the Interior shall hold not fewer than 1 lease sale in the area described in subparagraph A in each calendar years 2026 to 2028, and in each of the calendar years 2030 to 2032, by March 15th of the applicable calendar year. B, requirements. 1, terms and stipulations for Gulf of America sales. In conducting lease sales under subsection A1, the Secretary of the Interior, A, shall subject to subparagraph C, offer the same lease form, lease terms, economic conditions, and lease stipulations 4 through 9 as contained in the final notice of the sale of the Bureau of Ocean Energy Management entitled Gulf of Mexico Outer Continental Shelf Region Wide Oil and Gas Sale 25485 Fed Reg 8010, February 12, 2020. B, may update lease stipulations 1 through 3 and 10 described in the final notice of sale to reflect current conditions for lease sales conducted under subsections A1. C, shall set the royalty rate at not less than 12.5%, but not greater than 16 2/3%. D, shall for a lease in water depths of 800 meters or deeper issue as a result of a sale, set the primary term for 10 years. 2, terms and stipulations for Alaska region sales. A, in general. In conducting lease sales under subsection A2, the Secretary of the Interior shall offer the same lease form, lease terms, economic conditions, stipulations as contained in the final notice of sale of the Bureau of Ocean Energy Management entitled Cook Inlet Planning Area Outer Continental Shelf Oil and Gas Lease Sale 24482 Fed Reg 23291, May 22nd, 2017. B, revenue sharing, notwithstanding Section 8G and Section 9 of the Outer Continental Shelf Lands Act, 43 U.S.C. 1337G, 1338, and beginning in fiscal year 2034 of the bonuses, rents, royalties, and other revenues derived from lease sales conducted under subsection 8.2. 1, 70% shall be paid to the state of the Alaska, and 2, 30% shall be deposited in the Treasury and credited to miscellaneous receipts. 3, area offered for lease. A, Gulf of America region. For each offshore lease sale conducted under subsection A1, the Secretary of the Interior shall, 1, offer not fewer than 80 million acres, or 2, if there are fewer than 80 million acres that are unleased and available, offer all unleased and available acres. B, Alaska region. For each offshore lease sale conducted under subsection A2, the Secretary of the Interior shall, 1, offer not fewer than 1 million acres, or 2, if there are fewer than 1 million acres that are unleased and available, offer all unleased and available acres. C, offshore commingling. The Secretary of the Interior shall approve a request of an operator to commingle oil and gas production from multiple reservoirs within a single wellbore completed on the Outer Continental Shelf in the Gulf of America region unless the Secretary of the Interior determines that conclusive evidence establishes that the commingling would, 1, could not be conducted by the operator in a safe manner, or 2, would result in the ultimate recovery from the applicable reservoirs to be reduced in comparison to the expected recovery of those reservoirs if they had not been commingled. D, offshore oil and gas royalty rate. 1, repeal Section 50261 of Public Law 117-169, 136-2056 is repealed, and any provision of law amended or repealed by that section is restored or revived as if that section had not been enacted into law. 2, royalty rate. Section 8A1 of the Outer Continental Shelf Lands Act, 43 U.S.C. 1337A1, as amended by paragraph 1, is amended. A, in subparagraph A, by striking not less than 12.5% and inserting not less than 12.5%, but not more than 16 2/3%. B, in subparagraph C, by striking not less than 12.5% and inserting not less than 12.5%, but not more than 16 2/3%. C, in subparagraph F, by striking no less than 12.5% and inserting not less than 12.5%, but not more than 16 2/3%. And D, in subparagraph H, by striking no less than 12.5% and inserting not less than 12.5%, but not more than 16 2/3%. E, limitations on amount of distributed qualified Outer Continental Shelf revenues. Section 105F1 of the Gulf of Mexico Energy Security Act of 2006, 43 U.S.C. 1331, note Public Law 109-432, is amended. 1, in subparagraph B, by striking "and" at the end. 2, in subparagraph C, by striking 2055 and inserting 2024, and 3, by adding at the end the following. D, $650 million for each of fiscal years 2025 to 2034, and E, $500 million for each of fiscal years 2035 through 2055. Section 50103, royalties on extracted methane. Section 50263 of Public Law 117-169, 30 U.S.C. 1727 is repealed. Section 50104, Alaska oil and gas leasing. A, definitions. In this section, 1, coastal plain. The term coastal plain has the meaning given the term in Section 2001A of Public Law 115-97, 16 U.S.C. 3143, note. 2, oil and gas program. The term oil and gas program means the oil and gas programs established under Section 20001B2 of Public Law 115-97, 16 U.S.C. 3143, note. 3, secretary. The term secretary means the Secretary of the Interior acting through the Bureau of Land Management. B, lease sales required. 1, in general, subject to paragraph 3, in addition to the lease sales required under Section 20001C1A of Public Law 115-97, 16 U.S.C. 3143, note, the Secretary shall conduct not fewer than 4 lease sales area-wide under the oil and gas program by not later than 10 years after the date of the enactment of this Act. 2, terms and conditions. In conducting lease sales under paragraph 1, the Secretary shall offer the same terms and conditions as contained in the record of decision described in the Notice of Availability of the Bureau of Land Management entitled Notice of Availability of the Record of Decision for the Final Environmental Impact Statement For the Coastal Plain Oil and Gas Leasing Program, Alaska 85, Federal Register 51754, August 21st, 2020. 3, sale acreage schedule. A, acreages. In conducting the lease sales required under paragraph 1, the Secretary shall offer for lease under the oil and gas program 1, not fewer than 400,000 acres area-wide in each lease sale, and 2, those areas that have the highest potential for the discovery of hydrocarbons. B, schedule. The Secretary shall offer 1, the initial lease sale under paragraph 1, not later than 1 year after the date of the enactment of this act. 2, a second lease sale under paragraph 1, not later than 3 years after the date of the enactment of this act. 3, a third lease sale under paragraph 1, not later than 5 years after the date of the enactment of this act. And 4, a fourth lease sale under the paragraph 1, not later than 7 years after the date of the enactment of this act. 4, rights of way. Section 20001C2 of Public Law 115-97, 16 U.S.C. 3143 note shall apply to leases awarded under this subsection. 5, surface development. Section 20001C3 of Public Law 115-97, 16 U.S.C. 3143 note shall apply to leases awarded under this subsection. C, receipts. Notwithstanding Section 35 of the Mineral Leasing Act, 30 U.S.C. 191, and Section 20001 B5 of Public Law 115-97, 16 U.S.C. 3143 note of the amount adjusted bonus, rental, and royalty receipts derived from the oil and gas program operations on the coastal plain pursuant to this section. 1A, for each fiscal years 2025 through 2033, 50% shall be paid to the state of Alaska, and B, for the fiscal year 2034, each fiscal year thereafter, 70% shall be paid to the state of Alaska, and 2, the balance shall be deposited into the Treasury as miscellaneous receipts. Section 50105, National Petroleum Reserve, Alaska. A, definitions. In this section, 1, NPRA, Final Environmental Impact Statement. The term NPRA, Final Environmental Impact Statement, means the final environmental impact statement published by the Bureau of Land Management entitled National Petroleum Reserve in Alaska, Integrated Activity Plan Final Environmental Impact Statement, and dated June 2020, including the errata sheet dated October 6, 2020, and excluding the errata sheet dated September 20th, 2022.
2, NPRA, record of decision. The term NPRA, record of decision, means the record of decision published by the Bureau of Land Management entitled National Petroleum Reserve in Alaska, Integrated Activity Plan Record of Decision, and dated December 2020. 3, program. The term program means the competitive oil and gas leasing, exploration, development, and production program established under Section 107 of the Naval Petroleum Reserves Production Act of 1976, 42 U.S.C. 6506A. 4, secretary. The term secretary means the Secretary of the Interior. B, restoration of NPRA oil and gas leasing program, effective beginning on the date of enactment of this act. 1, the Secretary shall expeditiously restore and resume oil and gas lease sales under the program for domestic energy production and federal revenue, subject to the requirements of this section. And 2, the final rule of the Bureau of Land Management entitled Management and Protection of the National Petroleum Reserve in Alaska, 89 Fed Reg 38712, May 7, 2024, shall have no force or effect until January 1, 2035. C, resumption of NPRA lease sales. 1, in general, subject to paragraph 2, the Secretary shall conduct not fewer than 5 lease sales under the program by not later than 10 years after the date of enactment of this act. 2, sales acreages schedule. A, acreages. In conducting the lease sales required under paragraph 1, the Secretary shall offer not fewer than 4 million acres in each sale. B, schedule. The Secretary shall offer I, an initial lease sale under paragraph 1 not later than 1 year after the date of enactment of this act, and II, an additional lease sale under paragraph 1 not later than every 2 years after the date of enactment of this act. D, terms and stipulations for NPRA lease sales. In conducting lease sales under subsection C, the Secretary shall offer the same lease form, lease terms, economic conditions, and stipulations as described in NPRA Final Environmental Impact Statement and the NPRA Record of Decision. C, receipts. Section 107I of the Naval Petroleum Reserves Production Act of 1976, 42 U.S.C. 6506A1 is amended. 1, by striking all receipts from and inserting the following. 1, in general, except as provided in paragraph 2, all receipts from. 2, by adding at the end the following, 2% share for fiscal year 2034 and thereafter. Beginning in fiscal year 2034, the receipts from sales, rentals, bonuses, and royalties on leases issued pursuant to the section after the date of enactment of the act entitled an act to provide for reconciliation pursuant to Title II of H. Con. Res. 14, 119th Congress. A, 70% shall be paid to the state of Alaska, and B, 30% shall be paid into Treasury of the United States. Subtitle B, Mining. Section 50201, Coal Leasing. A, definitions. In this section, 1, coal lease. The term coal lease means a lease entered into by the United States as a lessor through the Bureau of Land Management and an applicant on Bureau of Land Management Form 3400012 or a successor form that contains the terms of coal lease. 2, qualified application. The term qualified application means an application for a coal lease pending as of the date of enactment of this act or submitted within 90 days thereafter under the lease by application program administered by the Bureau of Land Management pursuant to Mineral Leasing Act 30 U.S.C. 181 et sec, for which any required environmental review is commenced or the Director of the Bureau of Land Management determines can commence within 90 days after receiving the application. B, coal leasing activities. Not later than 90 days after the date of enactment of this act, the Secretary of the Interior, 1, shall, A, with respect to each qualified application, 1, if not previously published for public comment, publish any required environmental review. 2, establish the fair market value of the applicable coal tract. 3, hold a lease sale with respect to the applicable coal tract. 4, identify the highest bidder or at above the fair market value and take all other intermediate actions necessary to identify the winning bidder and grant the qualified application. And 2, may, A, with respect to a previously issued coal lease, grant any additional approvals of the Department of the Interior required for mining activities to commence, and B, after completing the actions required by Clause I through 4 of Paragraph 1A, grant the qualified application and issue that applicable lease to the person that submitted the qualified application if that person submitted the winning bid in the lease sale held under Clause 3 of Paragraph 1A. Section 50202, coal royalty. A, rate. Section 7A of the Mineral Leasing Act 30 U.S.C. 207A is amended in the fourth sentence by striking 12.5% and inserting 12.5%, except such amounts shall not be more than 7% during the period that begins on the date of enactment of the act entitled An Act to Provide for Reconciliation pursuant to Title II of H. Con. Res. 14, 119th Congress and ends September 30th, 2034. B, applicability to existing leases. The amendment made by subsection A shall apply to a coal lease, 1, issued under Section 2 of the Mineral Leasing Act 30 U.S.C. 201 before, on, or after the date of enactment of this act, and 2, that has not been terminated. C, advanced royalties. With respect to a lease issued under Section 2 of the Mineral Leasing Act 30 U.S.C. 201, for which the leasee has paid advanced royalties under Section 7B of that act, 30 U.S.C. 207B, the Secretary of the Interior shall provide to the leasee a credit for the difference between the amount paid by the leasing and advanced royalties for the lease before the date of the enactment of this act and the amount the leasee would have to be repaid if the amendment made by subsection A had been made before the leasee paid advanced royalties for the lease. Section 50203, leases for known recoverable coal resources. Notwithstanding Section 2A3A of the Mineral Leasing Act 30 U.S.C. 201A3A and Section 202A of the Federal Land Policy and Management Act of 1976, 43 U.S.C. 1712A, not later than 90 days after the date of enactment of this act, the Secretary of the Interior shall make available for lease known recoverable coal resources of not less than 4 million additional acres on federal land located in the 48 contiguous states in Alaska, subject to the jurisdiction of the Secretary, but which shall not include any federal land within 1, a national monument, 2, a national recreation area, 3, a component of the National Wilderness Preservation System, 4, a component of the National Wild and Scenic River System, 5, a component of the National Trail System, 6, a National Conservation Area, 7, a unit of the National Wildlife Refuge System, 8, a unit of the National Fish Hatchery System, or 9, a unit of the National Park System. Section 50204, authorization to mine federal coal. Authorization in order to provide access to coal reserves in adjacent state or private land that without an authorization could not be mined economically, federal coal reserves located in federal land subject to a mining plan previously approved by the Secretary of the Interior as of the date of enactment of this act and adjacent to coal reserves in adjacent state or private land are authorized to be mined. B, requirement. Not later than 90 days after the date of the enactment of this act, the Secretary of the Interior shall, without substantial modification, take such steps as are necessary to authorize the mining of federal land described in subsection A. C, NEPA. Nothing in this section shall prevent a review under the National Environmental Policy Act of 1969, 42 U.S.C. 4321 et sec. Subtitle C, lands. Section 50302, timber sales and long-term contracting for the Forest Service and the Bureau of Land Management. A, Forest Service. Definitions in this subsection. A, forest plan. A term forest plan means a land and resource management plan prepared by the Secretary for a unit of the National Forest System pursuant to Section 6 of the Forest and Rangeland Renewable Resources Planning Act of 1974, 16 U.S.C. 1604. B, National Forest System. 1, in general, the term National Forest System means land of the National Forest System as defined in Section 11A of the Forest and Rangeland Renewable Resources Planning Act of 1974, 16 U.S.C. 1609A, administered by the Secretary. 2, exclusions. The term National Forest System does not include any forest reserve not created from the public domain. C, Secretary. The term Secretary means the Secretary of Agriculture acting through the Chief of the Forest Service. 2, timber sales on public domain forest reserves. A, in general, for each of fiscal years 2026 through 2034, the Secretary shall sell timber annually on National Forest System land in a total quantity that is not less than 250 million board feet greater than the quantity of board feet sold in the previous fiscal year. B, limitation. The timber sales under subparagraph A shall be subject to the maximum allowable sale quality of timber and projected timber sale quality under the applicable forest plan in effect on the date of enactment of this act. 3, long-term contracting for the Forest Service. A, long-term contracting. For the period of fiscal years 2025 through 2034, the Secretary shall enter into not fewer than 40 long-term timber sale contracts with private persons or other public-private entities under subsection A of Section 14 of the National Forest Management Act of 1976, 16 U.S.C. 472A, for the sale of national forest materials as defined in subsection E1 of that section in the National Forest System. B, contract length. The period of a timber sale contract entered into meet the requirement under subparagraph A shall be not less than 20 years, with options for extensions or renewals as determined by the Secretary. C, receipts. Any monies derived from the timber sale contract entered into meet the requirements under subparagraphs A and B shall be deposited in the general fund of the Treasury. B, Bureau of Land Management. 1, definitions in this subsection. A, public lands. The term public lands has the meaning given term in Section 103 of the Federal Land Policy and Management Act of 1976, 43 U.S.C. 1702. B, resource management plan. The term resource management plan means a land use plan prepared for public lands under Section 202 of the Federal Land Policy and Management Act of 1976, 43 U.S.C. 1712. C, Secretary. The term Secretary means the Secretary of the Interior acting through the Director of the Bureau of Land Management. 2, timber sales on public land. A, in general, for each of fiscal years 2026 through 2034, the Secretary shall sell timber annually on public lands in a total quantity that is not less than 20 million board feet greater than the quantity of board feet sold in the previous year. B, limitation. The timber sales under subparagraph A shall be subject to the applicable resource management plan in effect on a date of enactment of this act. 3, long-term contracting for the Bureau of Land Management. A, long-term contracting. For the period of fiscal years 2025 through 2034, the Secretary shall enter into not fewer than 5 long-term contracts with private persons or other public or private entities under Section 1 of the Act of July 31st, 1947, commonly known as the Materials Act of 1947, 61 Stat 681, Chapter 406, 30 U.S.C. 601, for the disposal of vegetative materials described in that section on public lands. B, contract length. The period of a contract entered into to meet the requirement under subparagraph A shall be not less than 20 years, with options for extensions or renewals as determined by the Secretary. C, receipts. Any monies derived from a contract entered into to meet the requirements under subparagraphs A and B shall be deposited in the general fund of the Treasury. Section 50303. Renewable energy fees on federal land. A, definitions in this section. 1, annual adjustment factor. The term annual adjustment factor means 3%. 2, encumbrance factor. The term encumbrance factor means A, 100% for a solar energy generation facility, and B, an amount determined by the Secretary but not less than 10% for a wind energy generation facility. 3, National Forest System. A, in general, the term National Forest System means land of the National Forest System as defined in Section 11A of the Forest and Rangeland Renewable Resources Planning Act of 1974, 16 U.S.C. 1609A, administered by the Secretary of Agriculture. B, exclusion. The term National Forest System does not include any forest reserve not created from the public domain. 4, per acre rate. The term per acre rate with respect to a right-of-way means the average of the per acre pasture land rental rates published in the cash rent survey by the National Agricultural Statistics Service for the state in which the right-of-way is located over the 5 calendar year period preceding the issuance or renewal of the right-of-way. 5, project. The term project means a system described in Section 2801.9A4 of Title 43, Code of Federal Regulations, as in effect on the date of enactment of this act. 6, public land. The term public land means A, public lands as defined in Section 103 of the Federal Land Policy and Management Act of 1976, 43 U.S.C. 1702, and B, National Forest System land. 7, renewable energy project. The term renewable energy project means a project located on public land that uses wind or solar energy to generate energy. 8, right-of-way. The term right-of-way has the meaning given the term Section 103 of the Federal Land Policy and Management Act, 1976, 43 U.S.C. 1702. 9, secretary. The term secretary means A, Secretary of the Interior with respect to land controlled or administered by the Secretary of the Interior, and B, the Secretary of Agriculture with respect to National Forest System land. B, acreage rent for wind and solar rights-of-way. 1, in general, pursuant to Section 504G of the Federal Land Policy and Management Act of 1976, 43 U.S.C. 1764G, the Secretary shall, subject to paragraph 3 and not later than January 1 of each calendar year, collect from the holder of a right-of-way for a renewable energy project an acreage rent in an amount determined by the equation described in paragraph 2. 2, calculation of acreage rent rate. A, equation. The amount of acreage rent collected under paragraph 1 shall be determined using the following equation. Acreage rent equals A times B times 1 plus C D squared. B, definitions. For purposes of the equation described in subparagraph A, 1, the letter A means per acre rate. 2, the letter B means the encumbrance factor. 3, the letter C means the annual adjustment factor. 4, the letter D means the year and the term of right-of-way. 3, payment until production. The holder of a right-of-way for renewable energy project shall pay an acreage rent collected under paragraph 1 until the date of which energy generation begins. C, capacity fees. In general, the Secretary shall, subject to paragraph 3, annually collect a capacity fee from the holder of a right-of-way for a renewable energy project based on the amount described in paragraph 2. 2, calculation of capacity fee. The amount of a capacity fee collected under paragraph 1 shall be equal to the greater of A, an amount equal to the acreage rent described in subsection B, and B, 3.9% of the gross proceeds from the sale of electricity produced by the renewable energy project. 3, multiple use reduction factor. A, application. The holder of a right-of-way for a wind energy generation project may request that the Secretary apply a multiple use reduction factor of 10% to the amount of a capacity fee determined under paragraph 2 by submitting to the Secretary an application at such time in such manner and containing such information as the Secretary may require. B, approval. The Secretary may approve an application submitted under subparagraph A only if not less than 25% of the land within the area of the right-of-way is authorized for use, occupancy, or development with respect to an activity other than the generation of wind energy for the entirety of the year in which the capacity fee is collected. C, late determination. 1, in general, if the Secretary approves an application under subparagraph B for a wind energy generation project after the date on which the holder of the right-of-way for the project begins paying a capacity fee, the Secretary shall apply the multiple use reduction factor described in subparagraph A to the capacity fee for the first year beginning after the date of approval and each year thereafter for the period during which the right-of-way remains in effect. 2, refund. The Secretary may not refund the holder of a right-of-way for the difference in the amount of a capacity fee paid in a previous year. D, late payment fee termination. 1, in general, the Secretary may charge the holder of a right-of-way for a renewable energy project a late payment fee if the Secretary does not receive payment for the acreage rent under subsection B or the capacity fee under subsection C by the date that is 15 days after the date on which the payment was due. 2, termination of right-of-way. The Secretary may terminate a right-of-way for a renewable energy project if the Secretary does not receive payment for the acreage rent under subsection B of the capacity fee under subsection C by the date that is 90 days after the date on which payment was due. Section 50304, renewable energy revenue sharing. A, definitions. In this section, 1, county. The term county includes a parish, township, borough, and other similar independent unit of local government. 2, covered land. The term covered land means that land that is A, public land administered by the Secretary, and B, not excluded from the development of solar or wind energy under 1, a land use plan, or 2, other federal law. 3, national forest system. A, in general, the term national forest system means the land of the national forest system as defined in Section 11A of the Forest and Rangeland Renewable Resources Planning Act of 1974, 16 U.S.C. 1609A, administered by the Secretary of Agriculture. B, exclusion. The term National Forest System does not include any forest reserve not created from the public domain. 4, public land. The term public land means A, public lands as defined in Section 103 of the Federal Land Policy and Management Act of 1976, 43 U.S.C. 1702, and B, National Forest System land. 5, renewable energy project. The term renewable energy project means a system described in Section 2801.9A4 of Title 43 Code of Federal Regulations as in effect on the date of enactment of this act, located on covered land that uses wind or solar energy to generate energy. 6, secretary. The term secretary means A, the Secretary of the Interior with respect to land controlled or administered by the Secretary of the Interior, and B, the Secretary of Agriculture with respect to the National Forest System land. B, disposition of revenue. 1, disposition of revenues. Beginning on January 1, 2026, the amounts collected from a renewable energy project as bonus bids, rentals, fees, or other payments under a right-of-way permit, lease, or other authorization shall A, be deposited in the general fund of the Treasury, and B, without further appropriation for fiscal year limitation, has allocated as follows. 1, 25% shall be paid from amounts in the general fund of the Treasury to the state within the boundaries of which the revenue is derived. 2, 25% shall be paid from amounts in the general fund of the Treasury to each county and a state within the boundaries of which the revenue is derived, to be allocated among each applicable county based on the percentage of county land from which the revenue is derived. 2, payments to states and counties. A, in general, amounts paid to states and counties under paragraph 1 shall be used in accordance with the requirements of Section 35 of the Mineral Leasing Act, 30 U.S.C. 191. B, payments in lieu of taxes. A payment to a county under paragraph 1 shall be in addition to a payment in lieu of taxes received by the county under Chapter 69 of Title 31 United States Code. C, timing. The amounts required to be paid under paragraph 1B for an applicable fiscal year shall be made available for the fiscal year that immediately follows fiscal year for which the amounts were collected. Section 50305, rescission of National Park Service and Bureau of Land Management funds. There are rescinded the unobligated balances of amounts made available by the following sections of Public Law 117-169, commonly known as the Inflation Reduction Act of 2022, 136 Statute 1818. 1, Section 50221, 136 Statute 2052. 2, Section 50221, 136 Statute 2052. 3, Section 50223, 136 Statute 2052. Section 50306, celebrating America's 250th anniversary. In addition to amounts otherwise available, there is appropriated to the Secretary of the Interior, acting through the Director of the National Park Service, for fiscal year 2025, out of any money in the Treasury not otherwise appropriated, $150 million for events, celebrations, and activities surrounding the observance and commemoration of the 250th anniversary of the founding of the United States to remain available through fiscal year 2028. Subtitle D, Energy. Section 50401, Strategic Petroleum Reserve. A, Energy Policy and Conservation Act definitions. In this section, the terms related facility, storage facility, and strategic petroleum reserve have the meanings given those terms in Section 152 of the Energy Policy and Conservation Act, 42 U.S.C. 6232. B, appropriations. In addition to the amounts otherwise available, there is appropriated to the Department of Energy for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. $218 million for maintenance of, including repairs to, storage facilities and related facilities of Strategic Petroleum Reserve, and to $171 million to acquire by purchase petroleum products for storage in the Strategic Petroleum Reserve. C, repeal of Strategic Petroleum Reserve drawdown and sale mandate. Section 200003 of Public Law 115-97, 42 U.S.C. 6241, note, is repealed. Section 50402, repeals, rescissions. A, repeal and rescission. Section 50142 of Public Law 117-169, 163, Statute 2044, commonly known as the Inflation Reduction Act of 2022, is repealed, and the unobligated balance of amounts made available under that section as in effect on the day before the date of enactment of this act is rescinded. B, rescissions. 1, in general, the unobligated balances of amounts made available under the sections described in paragraph 2 are rescinded. 2, sections described. The sections referred to in paragraph 1 are the following sections of Public Law 117-179, commonly known as the Inflation Reduction Act of 2022. A, Section 50123, 42 U.S.C. 1879B5. B, Section 50141, 136, Statute 2042. C, Section 50144, 136, Statute 2044. D, Section 50145, 136, Stat 2045. E, Section 50151, 42 U.S.C. 18715. 5, F, Section 50152, 42 U.S.C. 18715A. G, Section 50153, 42 U.S.C. 18715B. H, Section 50161, 42 U.S.C. 17113B. Section 50403, Energy Dominance Financing. A, in general, Section 1706 of the Energy Policy Act of 2005, 42 U.S.C. 16517, is amended, 1, in subsection A in paragraph 1 by striking "or" at the end, B, in paragraph 2 by striking "avoid," and all that follows through the period at the end, and insert increased capacity or output, or, and C, by adding at the end the following: 3, support or enable the provision of known or forecastable electric supply at time intervals necessary to maintain or enhance grid reliability or other system adequacy needs. 2, by striking subsection C. 3, by redesignating subsections D through F as subsections C through E respectively. 4, in subsection C, as so redesignated. A, in paragraph 1 by adding "and" at the end. B, by striking paragraph 2, and C, by redesignating paragraph 3 as paragraph 2. 5, in subsection E, as so redesignated, by striking "for" in the matter preceding paragraph 1, and all that follows through the period at the end of the paragraph 2, and inserting "for enabling the identification, leasing, development, production, processing, transportation, transmission, refining, and generation needed for energy and critical minerals," and 6, by adding at the end of the following: F, funding. I, in general, in addition to amounts otherwise available, there is appropriated to the Secretary for fiscal years 2025 out of any money in the Treasury not otherwise appropriated, $1 trillion to remain available through September 30, 2028 to carry out activities under the section. 2, administrative costs. Of the amount made available under paragraph 1, the Secretary shall not use more than 3% for administrative expenses. B, commitment authority. Section 50144B of Public Law 117-169, commonly known as the Inflation Reduction Act of 2022. 136 Stat 2045 is amended by striking 2026 and inserting 2028. Section 50404, Transformational Artificial Intelligence Models. A, definitions in this section. 1, American Science Cloud. The term American Science Cloud means a system of United States government, academic, and private sector programs and infrastructures utilizing cloud computing technologies to facilitate and support scientific research, data sharing, and computational analysis across various disciplines while ensuring compliance with applicable legal, regulatory, and privacy standards. 2, artificial intelligence. The term artificial intelligence has the meaning given term in Section 5002 of the National Artificial Intelligence Initiative Act of 2020, 15 U.S.C. 9401. B, transformational models. The Secretary of Energy shall: 1, mobilize national laboratories to partner with industry sectors within the United States to curate the scientific data of the Department of Energy across the national laboratory complex so that the data is structured, cleaned, and pre-processed in a way that makes it suitable for use in artificial intelligence and machine learning models. And 2, initiate seed efforts for self-improving artificial intelligence models for science and engineering powered by the data described in paragraph 1. C, uses. Microelectronics. The curated data described in subsection B1 may be used to rapidly develop next-generation microelectronics that have greater capabilities beyond Moore's law while requiring lower energy consumption. 2, new energy technologies. The artificial intelligence models developed under subsection B2 shall be provided to the scientific community through the American Science Cloud to accelerate innovation in discovery, science, and engineering for new energy technologies. D, appropriations. There is appropriated out of any funds in the Treasury not otherwise appropriated $150 million to remain available through September 30th, 2026 to carry out this section. Subtitle E, water. Section 50501. Water conveyance and surface water storage enhancement. In addition to amounts otherwise available, there is appropriated to the Secretary of the Interior acting through the Commissioner of Reclamation for fiscal year 2025 on any funds in the Treasury not otherwise appropriated, $1 billion to remain available through September 30th, 2034 for construction and associated activities that restore or increase the capacity or use of existing conveyance facilities constructed by the Bureau of Reclamation or for construction and associated activities and increase the capacity of existing Bureau of Reclamation surface water storage facilities in a manner as determined by the Secretary of the Interior, acting through the Commissioner of Reclamation, provided that for the purposes of Section 203 of the Reclamation Reform Act of 1982, 43 U.S.C. 390cc, or Section 3404A of the Reclamation Projects Authorization and Adjustment Act of 1992, Public Law 102-575, 106 Stat 4708, a contract or agreement entered into pursuant to this section shall not be treated as a new or amended contract, provided further that none of the funds provided under this section shall be reimbursable or subject to matching or cost-sharing requirements. Title VI, Committee on Environment and Public Works, Section 60001, rescission of funding for clean heavy-duty vehicles. The unobligated balances of amounts made available to carry out Section 132 of the Clean Air Act, 42 U.S.C. 7432, are rescinded. Section 60002, repeal of Greenhouse Gas Reduction Fund. Section 134 of the Clean Air Act, 42 U.S.C. 7434, is repealed, and the unobligated balances of amounts made available to carry out that section as in effect on the day before the date of enactment of this act are rescinded. Section 60003, rescission of funding for diesel emissions reductions. The unobligated balances of amounts made available to carry out Section 60104 of Public Law 117-169, 136 Stat 2067 are rescinded. Section 60004, rescission of funding to address air pollution. The unobligated balances of amounts made available to carry out Section 60105 of Public Law 117-169, 136 Stat 2067 are rescinded. Section 60005, rescission of funding to address air pollution at schools. The unobligated balances of amounts made available to carry out Section 60106 of Public Law 117-169, 136 Stat 2069 are rescinded. Section 60006, rescission of funding for the Low Emissions Electricity Program. The unobligated balances of amounts made available to carry out Section 135 of the Clean Air Act, 42 U.S.C. 7435 are rescinded. Section 6007, rescission of funding for Section 2110 of the Clean Air Act. The unobligated balances of amounts made available to carry out Section 60108 of Public Law 117-169, 136 Stat 2070 are rescinded. Section 60008, rescission of funding for implementation of the American Innovation and Manufacturing Act. The unobligated balances of amounts made available to carry out Section 60109 of Public Law 117-169, 136 Stat 2071 are rescinded.
Section 60009, rescission of funding for enforcement technology and public information. The unobligated balances of amounts made available to carry out Section 60110 of Public Law 117-169, 136 Stat 2071 are rescinded. Section 60010, rescission of funding for greenhouse gas corporate reporting. The unobligated balances of amounts made available to carry out 60111 of Public Law 117-169, 136 Stat 2072 are rescinded. Section 60011, rescission of funding for environmental product declaration assistance. The unobligated balances of amounts made available to carry out Section 60112 of Public Law 117-169, 42 U.S.C. 4321, Note 136, Stat 2072 are rescinded. Section 60012, rescission of funding for methane emissions and waste reduction incentive program for petroleum and natural gas systems. A, rescission. The unobligated balances of amounts made available to carry out subsections A and B of Section 136 of the Clean Air Act, 42 U.S.C. 7436 are rescinded. B, period. Section 136G of the Clean Air Act, 42 U.S.C. 7436G is amended by striking calendar year 2024 and inserting calendar year 2034. Section 60013, rescission of funding for greenhouse gas air pollution plans and implementation grants. The unobligated balances of amounts made available to carry out Section 137 of the Clean Air Act, 42 U.S.C. 7437 are rescinded. Section 60014, rescission of funding for Environmental Protection Agency efficient, accurate, and timely reviews. The unobligated balances of amounts made available to carry out Section 60115 of Public Law 117-169, 136 Stat 2077 are rescinded. Section 60015, rescission of funding for low embodied carbon labeling for construction materials. The unobligated balances of amounts made available to carry out Section 60116 of Public Law 117-169, 42 U.S.C. 432, Note 136, Stat 2077 are rescinded. Section 60016, rescission of funding for environmental and climate justice block grants. The unobligated balances of amounts made available to carry out Section 138 of the Clean Air Act, 42 U.S.C. 7438 are rescinded. Section 60017, rescission of funding for ESA recovery plans. The unobligated balances of amounts made available to carry out Section 60301 of Public Law 117-169, 136 Stat 2079 are rescinded. Section 60018, rescission of funding for environmental and climate data collection. The unobligated balances of amounts made available to carry out 60401 of Public Law 117-169, 136 Stat 2079 are rescinded. Section 60019, rescission of neighborhood access and equity grant program. The unobligated balances of amounts made available to carry out Section 177 of Title 23 United States Code are rescinded. Section 60020, rescission of funding for federal building assistance. The unobligated balances of amounts made available to carry out Section 60502 of Public Law 117-169, 136 Stat 2083 are rescinded. Section 60021, rescission of funding for low-carbon materials for federal buildings. The unobligated balances of amounts made available to carry out Section 60503 of Public Law 117-169, 136 Stat 2083 are rescinded. Section 60022, rescission of funding for GSA emerging and sustainable technologies. The unobligated balances of amounts made available to carry out 60504 of Public Law 117-169, 136 Stat 2083 are rescinded. Section 60023, rescission of environmental review implementation funds. The unobligated balances of amounts made available to carry out Section 178 of Title 23 United States Code are rescinded. Section 60024, rescission of low carbon transportation material grants. The unobligated balances of amounts made available to carry out Section 179 of Title 23 United States Code are rescinded. Section 60025, John F. Kennedy Center for the Performing Arts. In general, in addition to amounts otherwise available, there is appropriate for fiscal year 2025 out of any money in the Treasury not otherwise appropriated, $256,657,000 to remain available until September 30th, 2029 for necessary expenses for capital repair, restoration, maintenance, backlog, and security structures of the building site and site of the John F. Kennedy Center for Performing Arts. B, administrative costs. Of the amounts made available under subsection A, not more than 3% may be used for administrative costs necessary to carry out this section. Section 60026, project sponsor, opt-in fees for environmental reviews. Title I of the National Environmental Policy Act of 1969, 42 U.S.C. 4331 at sequence is amended by adding the following. Section 112, project sponsor opt-in fees for environmental reviews. A, process. 1, project sponsor. A project sponsor that intends to pay a fee under the section for the preparation or supervision of the preparation of an environmental assessment or environmental impact statement for a project shall submit to the council A, a description of the project, and B, a declaration of whether the project sponsor intends to prepare the environmental assessment or environmental impact statement under section 10(7)(f). 2, Council of Environmental Quality. Note, not later than 15 days after the date on which the council receives information described in paragraph 1 from a project sponsor, the council shall provide to the project sponsor notice of the amount of the fee to be paid under this section as determined under subsection B. 3, payment of fee. A project sponsor may pay a fee under this section after the receipt of the notice described in paragraph 2. 4, deadline for environmental reviews for which a fee is paid. Notwithstanding section 107G1A, an environmental assessment for which a fee is paid under the section shall be completed not later than 180 days after the date on which the fee is paid. And B, an environmental impact statement for which a fee is paid under the section shall be completed not later than 1 year after the date of publication of the notice of the intent to prepare the environmental impact statement. B, fee amount. The amount of a fee under the section shall be 1, 125% of the anticipated cost to prepare the environmental assessment or environmental impact statement. And 2, in the case of an environmental assessment or environmental impact statement to be prepared in whole or in part by a project sponsor under section 107F, 125% of the anticipated cost to supervise preparation of and, as applicable, prepare the environmental assessment or environmental impact statement. Title 7, Finance, Subtitle A, Tax, Section 70001, references to the Internal Revenue Code of 1986, etc. A, references, except as otherwise expressly provided whenever in this title an amendment or repeal is expressed in terms of an amendment to or repeal of a section or other provision, the reference shall be considered to be made to a section or other provision of the Internal Revenue Code of 1986. B, certain rules regarding effect of rate changes not applicable. Section 15 of the International Revenue Code of 1986 shall not apply to any change in rate of tax by reason of any provision of or amendment made by this title. Chapter 1, providing permanent tax relief for middle-class families and workers. Section 70101, extension and enhancement of reduced rates. A, in general, Section 1J is amended. 1, in paragraph 1 by striking and before January 1, 2026, and 2, by striking 2018 through 2025 in the heading and inserting beginning after 2017. B, inflation adjustment. Section 1J3BI is amended by inserting solely for the purpose is of determining the dollar amounts at which any rate bracket higher than 12% ends and at which any rate bracket higher than 22% begins before subsection F3. C, effective date. The amendments made by this section shall be apply to taxable years beginning after December 31st, 2025. Section 70102, extension and enhancement of increased standard reduction. A, in general, Section 63C7 is amended 1, by striking and before January 1st, 2026 in the matter preceding subparagraph A, and 2, by striking 2018 through 2025 in the heading and inserting beginning after 2017. B, additional increase in standard deduction. Paragraph 7 of Section 63C is amended 1, by striking $18,000, both places it appears in subparagraphs AI and BII, and inserting $23,625. 2, by striking $12,000, both places it appears in subparagraphs AII and BII, and inserting $15,750. 3, by striking 2018 in subparagraph BII and inserting 2025. And 4, by striking 2017 in subparagraph BII and inserting 2024. C, effective date. The amendments made by this section shall apply to taxable years beginning after December 31st, 2024. Section 70103, termination of deduction for personal exemptions other than temporary senior deduction. A, in general, Section 151D5 is amended 1, by striking 2018 through 2025 in the heading and inserting beginning after 2017. 2, by striking and before January 1st, 2026. And 3, by adding at the end the following new subparagraph. C, deductions for seniors. I, in general, in the case of a taxable year beginning before January 1st, 2029, there shall be allowed a deduction in an amount equal to $6,000 for each qualified individual with respect to the taxpayer. II, qualified individual. For purposes of Clause I, the term qualified individual means I, the taxpayer, if the taxpayer has attained age 65 before the close of the taxable year, and II, in the case of a joint return, the taxpayer's spouse, if such spouse has attained age 65 before the close of the taxable year. III, limitation based on modified adjusted gross income. I, in general, in the case of any taxpayer for any taxable year, the $6,000 amount in Clause I shall be reduced, but not below 0, by 6% of so much of that taxpayer's modified adjusted gross income as exceeds $75,000, $150,000 in the case of a joint return. II, modified adjustment gross income. For the purpose of this clause, the term modified adjusted gross income means the adjusted gross income of the taxpayer for the taxable year increased by any amount excluded from gross income under sections 911, 931, or 933. 4, Social Security number required. 1, in general clause, I shall not apply with respect to a qualified individual unless the taxpayer includes such qualified individual Social Security number on the return of tax for the taxable year. 2, Social Security number. For the purpose is of subclause 1, the term Social Security number has the meaning given such term in Section 24H7. 5, married individuals. If the taxpayer is a married individual within this meaning of Section 7703, this subparagraph shall apply only if the taxpayer and the taxpayer's spouse file a joint return for the taxable year. B, omission of correct Social Security number treated as mathematical or clerical error. Section 6213G2 is amended by striking and at the end of subparagraph U, by striking the period at the end of subparagraph V and inserting and by inserting after subparagraph V the following new subparagraph W. An omission of a correct Social Security number required under Section 151D5C relating to deduction for seniors. C, effective date. The amendments made by this section shall apply to taxable years beginning after December 31st, 2024. Section 70104, extension and enhancement of increased child tax credit. A, extension and increase of expanded child tax credit. Section 24H is amended, 1, in paragraph 1 by striking and before January 1st, 2026, 2, in paragraph 2 by striking $2,000 and inserting $2,200, and 3, by striking 2018 through 2025 and in the heading and inserting beginning after 2017. B, Social Security number required. Section 24H7 is amended to read as follows. 7, Social Security number required. A, in general, no credit shall be allowed under the section to a taxpayer with respect to any qualifying child unless the taxpayer includes on the return of the tax for the taxable year 1, the taxpayer's Social Security number, or in the case of a joint return, the Social Security number of at least one spouse, and 2, the Social Security number of such qualifying child. B, Social Security number. For the purposes of this paragraph, the term Social Security number means any Social Security number issued to an individual by the Social Security Administration, but only if the Social Security number is issued 1, to a citizen of the United States or pursuant to subclause I, or that portion of subclause III that relates to subclause I of Section 205C2BI of the Social Security Act, and 2, before the due date for such return. C, inflation adjustments. In general, Section 24I is amended to read as follows. I, inflation adjustments. 1, maximum amount of refundable credit. In the case of a taxable year beginning after 2024, the $1,400 amount in subsection H5 shall be increased by an amount equal to A, such dollar amount multiplied by B, the cost of living adjustment determined under Section 1F3 for the calendar year in which the taxable year begins, determined by substituting 2017 for 2016 in subparagraph A, II thereof. 2, special rule for adjustment of credit amount. In the case of a taxable year beginning after 2025, the $2,200 amount in subsection H2 shall be increased by an amount equal to A, such dollar amount multiplied by B, the cost of living adjustment determined under Section 1F3 for the calendar year in which the taxable year begins, determined by substituting 2024 for 2016 in subparagraph A, II thereof. 3, rounding. If any increase under the subsection is not a multiple of $100, such increase shall be rounded to the next lowest multiple of $100. D, conforming amendment. Section 24H5 is amended to read as follows. 5, maximum amount of refundable credit. The amount determined under subsection D1A with respect to any qualifying child shall not exceed $1,400, and such subsection shall appear without regard to paragraph 4 of this subsection. E, omission of correct Social Security number treated as mathematical or clerical error. Section 6213G2I is amended by striking Section 24E and inserting Section 24F, effective date. The amendments made by this section shall apply to taxable years beginning after December 31st, 2024. Section 70105, extension and enhancement of deduction for qualified business income. A, increase in taxable income limitation phase-in amounts. 1, in general. Subparagraph B of Section 199AB3 is amended by striking $50,000, $100,000 in case of a joint return. Each place it appears and inserting $75,000, $150,000 in the case of a joint return. 2, conforming amendment. Paragraph 3 of Section 199AD is amended by striking $50,000, $100,000 in the case of a joint return. Each place it appears and inserting $75,000, $150,000 in the case of a joint return. B, minimum deduction for active qualified business income. 1, in general. Subsection I of Section 199A is amended to read as follows. I, minimum deduction for active qualified business income. 1, in general. In the case of an applicable taxpayer for any taxable year, the deduction allowed under subsection A for the taxable year shall be equal to the greater of A, the amount of such deduction determined without regard to the subsection, or B, $400. 2, applicable taxpayer. For the purpose of this subsection A, in general, the term applicable taxpayer means with respect to any taxable year, a taxpayer whose aggregate qualified business income with respect to all active qualified trades or businesses of the taxpayer for such taxable year is at least $1,000. B, active qualified trade or business. The active qualified trade or business means with respect to any taxpayer for any taxable year, any qualified trade or business of the taxpayer in which the taxpayer materially participates within the meaning of Section 469H. 3, inflation adjustment. In the case of any taxable year beginning after 2026, the $400 amount in paragraph 1B and the $1,000 amount in paragraph 2A shall be increased by an amount equal to A, such dollar amount multiplied by B, the cost of living adjustment determined under Section 1F3 for the calendar year in which the taxable year begins, determined by substituting calendar year 2025 for calendar year 2016 in subparagraph A, II thereof. If Any increase under this paragraph is not a multiple of 5. Such increase shall be rounded to the nearest multiple of $5. 2, conforming amendment. Section 199AA is amended by inserting except as provided in subsection I before there. C, effective date. The amendments made by this section shall apply to taxable years beginning after December 31st, 2025. Section 70106, extension and enhancement of increased estate and gift tax exemption amounts. A, in general. Subsection 2010C3 is amended 1, in subparagraph A by striking $5 million and inserting $15 million. 2, in subparagraph B, A, in the matter preceding clause I by striking 2011 and inserting 2026, and B in clause II by striking calendar year 2010 and inserting calendar year 2025, and 3 by striking subparagraph C. B, effective date. The amendments made by this section shall apply to estates of decedents dying and gifts made after December 31st, 2025. Section 70107, extension of increased alternative minimum tax exemption amounts and modification of phase-out thresholds. A, in general, Section 55D4 is amended 1 in subparagraph A by striking and before January 1st, 2026, and 2 by striking and before 2026 in the heading. B, modification of inflation adjustment. Section 55D4B is amended 1 by striking 2018 and inserting 2018-2026 in the case of $1 million, amount in subparagraph AIII, and 2 by striking determined by substituting calendar year 2017 for calendar year 2016 in subparagraph AII thereof, and inserting determined by substituting for calendar year 2016 in subparagraph AII thereof. 1, calendar year 2017 in the case of $109,400 amount in subparagraph AII, and the $70,300 amount in subparagraph AIII, and 2, calendar year 2025 in the case of $1 million amount in subparagraph AIII. C, modification of phase-out amount. Section 55D4AII is amended by striking and at the end of subclause II and by adding at the end of the following new subclause. 4, by substituting 50% for 25%, and D, effective date. The amendments made by the section shall apply to taxable years beginning after December 31st, 2025. Section 70108, extension and modification of limitation on deduction for qualified resident interest. A, in general, Section 163H3F is amended 1 in clause I, A, by striking and before January 1st, 2026. B, by redesignated subclauses 3 and 4 as subclauses 4 and 5 respectively. C, by striking out subclauses 3 and subclause 5 as so redesignated and inserting subclause 4. And D, by inserting after subclause 2 the following new subclause 3, mortgage insurance premiums treated as interest. Clause 4 of subparagraph E shall not apply. 2, by striking clauses 2 and redesignated clauses 3 and 4 as clauses 2 and 3 respectively, and 3 by striking 2018 through 2025 in the heading and inserting beginning after 2017. B, effective date. The amendments made by the section shall apply to taxable years beginning after December 31st, 2025. Section 70109, extension and modification of limitation on casualty loss deduction. In general, Section 165H5 is amended 1 in subparagraph A by striking and before January 1st, 2026, and 2 by striking 2018 through 2025 in the heading and inserting beginning after 2017. B, extension to state-declared disasters. 1 in general, subparagraph A of Section 165H5 is amended by subsection A is further amended by striking I-5 and inserting I-5 or a state-declared disaster. 2, exception related to personal casualty gains. Clause I of Section 165H5B is amended by striking as so defined and inserting as so defined or a state-declared disaster. 3, state-declared disaster. Paragraph 5 of Section 165H is amended by adding at the end the following new subparagraph. C, state-declared disaster for the purpose is of this paragraph. 1, in general, the term state-declared disaster means with respect to any state, any natural catastrophe, including any hurricane, tornado, storm, high water, wind-driven water, tidal wave, tsunami, earthquake, volcanic eruption, landslide, mudslide, snowstorm, or drought, or regardless of case, any fire, flood, or explosion in any part of the state, which in the determination of the governor of such state or mayor in the case of the District of Columbia and the secretary causes damage of sufficient severity and magnitude to warrant the application of the rules of this section. 2, state. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, American Samoa, and the Commonwealth of the Northern Mariana Islands. C, effective date. The amendments made by the section shall apply to taxable years beginning after December 31st, 2025. 70110, termination of miscellaneous itemized deductions other than educator expenses. A, in general, Section 67G is amended by striking and before January 1st, 2026, and 2 by striking 2018 through 2025, the heading inserting beginning after 2017. B, deduction for educator expenses. 1, in general, Section 67B is amended by striking "and" at the end of paragraph 11, by striking the period at the end of paragraph 12, and inserting "and by adding the following new paragraph. 13, the deductions allowed by Section 162 for educator expenses as defined in subsection G. 2, inclusion of coaches and certain non-athletic instructional equipment. Section 67 is amended by redesignated subsection G as amended by the section as subsection H, and by inserting after subsection F the following new section: G, educator expenses. For the purpose of subsection B13, the term educator expenses means expenses of a type which would be described in section 62A2D if 1, such section were applied, A, without regard to dollar limitation, and B, without regard to other than non-athletic supplies for courses of instruction in health or physical education in clause 2 thereof, and C, by substituting as part of instructional activity for in the classroom in clause 2 thereof, and 2, section 62D1A, where were applied to inserting interscholastic sports administrator or coach after counselor. C, effective date. The amendments made by the section shall apply to taxable years beginning after December 31st, 2025. Section 70111, limitation on tax benefit of itemized deductions. A, in general, Section 68 is amended to read as follows. A, in general, in the case of an individual, the amount of the itemized deductions otherwise allowable for the taxable year determined without regard to this section shall be reduced by 2/37 of the lesser of 1. Such amount of itemized deductions, or 2, so much of the taxable income of the taxpayer for the taxable year determined without regard to the section increased by such amount of itemized deductions as exceeds the dollar amount at which the 37% tax bracket under Section 1 begins with respect to the taxpayer. B, coordination with other limitations. The section shall be applied after the application of any other limitation on allowance of any itemized deductions. B, limitation not applicable to determination of deduction for qualified business income. 1, in general, Section 199 AE1 is amended by inserting without regard to Section 68 and after shall be computed. 2, patrons of specified agricultural and horticultural cooperatives. Section 199 AG2B is amended by inserting Section 68 or after without regard to. C, effective date. The amendments made by this section shall apply to taxable years beginning after December 31st, 2025. Section 70112, extension and modification of qualified transportation fringe benefits. A, in general, Section 132F is amended 1 by striking subparagraph D of paragraph 1, 2, and paragraph 2 by inserting and at the end of subparagraph A by striking and at the end of subparagraph B and inserting a period, and by striking subparagraph C. 3, by striking other than a qualified bicycle commuting reimbursement in paragraph 4, 4 by striking subparagraph F of paragraph 5, and 5 by striking paragraph 8. B, inflation adjustment. Clause 2 of Section 132F6A is amended by striking 1998 in Clause 2 and inserting 1997. C, coordination with disallowance of certain expenses. Subsection 1 of Section 274 is amended 1 by striking benefits and all that follows through no deduction and inserting benefits, no deduction, and 2 by striking paragraph 2. D, effective date. The amendments made by the section shall apply to taxable years beginning after December 31st, 2025. Section 70113, extension and modification of limitation on deduction and exclusion for moving expenses. A, extension of limitation on deduction. Section 217K is amended 1 by striking and before January 1st, 2026, and 2 by striking 2018 through 2025 in the heading and inserting beginning after 2017. B, allowance of deduction for members of the intelligence community. Section 217K, as amended by subsection A, is further amended 1 by striking 2017, accepting the case and inserting 2017, 1 in general, accepting the case, and 2 by adding at the end of the following new paragraph, 2 members of the intelligence community, an employee or new appointee of the intelligence community as defined in Section 3 of the National Security Act of 1947, 50 U.S.C. 3003, other than a member of the Armed Forces of the United States who moves pursuant to a change in assignment which requires relocation shall be treated for the purposes of this section in the same manner as an individual to whom subsection G applies. C, extension of limitation on exclusion. Section 132G2 is amended 1 by striking and before January 1st, 2026, and 2 by striking 2018 through 2025 in the heading and inserting beginning after 2017. D, allowance of exclusion for members of the intelligence community. 132G2 of the Internal Revenue Code of 1986 is amended by inserting "or an employee or new appointee of the intelligence community as defined in Section 3 of the National Security Act of 1947, 50 U.S.C. 3003, other than a member of the Armed Forces of the United States who moves pursuant to a change in assignment that requires relocation after a change of station." E, effective date. The amendments made by the section shall apply to taxable years beginning after December 31st, 2025. Section 70114, extension and modification of limitation on wagering losses. A, in general, Section 165 is amended by striking subsection D and inserting the following. D, wagering losses. 1, in general, for purpose of losses from wagering transactions, the amount allowed as a deduction for any taxable year, A, shall be equal to 90% of the amount of such losses during such taxable year, and B, shall only be allowed to the extent of the gains from such transactions during such taxable year. 2, special rule. For the purpose is of paragraph 1, the term losses from wagering transactions includes any deduction otherwise allowable under this chapter incurred in carrying on any wagering transaction. B, effective date. The amendments made by the section shall apply to taxable years beginning after December 31st, 2025. Section 70115, extension and enhancement of increased limitation on contributions to able accounts. A, in general, Section 529AB2B is amended. 1, in clause 1 by inserting determined by substituting 1996 for 1997 in paragraph 2B thereof after section 2503B, and 2, in clauses 2 by striking before January 1st, 2026. B, effective dates. 1, in general, except as otherwise provided in the subsection, the amendments made. The section shall apply to the contributions made after December 31st, 2025. 2, modified inflation adjustment. The amendment made by subsection A1 shall apply to taxable years beginning after December 31st, 2025. Section 70116, extension and enhancement of savers credit allowed for able contributions. A, extension. 1, in general, section 25BD1 is amended to read as follows. 1, in general, the term qualified retirement savings contributions means with respect to any taxable year, the sum of A, the amount of contributions made by the eligible individual during such taxable year to the able account within the meaning of Section 529A, of which such an individual is the designated beneficiary, and B, in the case of any taxable year beginning before January 1st, 2027. 1, the amount of the qualified retirement contributions as defined in Section 219E made by the eligible individual. 2, the amount of 1, any elective deferrals as defined in Section 402G3 of such individual, and 2, any elective deferral of compensation by such individual under an eligible deferred compensation plan as defined in Section 457B of an eligible employer described in Section 457E1A, and 3, the amount of voluntary employee contributions by such individual to any qualified retirement plan as defined in Section 4974C, 2, coordination with Secure 2.0 Act of 2022 Amendment, paragraph 1 of Section 103E of the Secure 2.0 Act of 2022 was repealed, and the Internal Revenue Code of 1986 shall be applied and administered as though such paragraph were never enacted. 3, effective date. The amendments and repeal made by the subsection shall apply to taxable years ending after December 31st, 2025. B, increase of credit amount. 1, in general, Section 25BA is amended by striking $2,000 and inserting $2,100. 2, effective date. The amendment made by the subsection shall apply to taxable years beginning after December 31st, 2026. Section 70117, extension of rollovers from qualified tuition programs to able accounts permitted. A, in general, Section 529C3C 13 is amended by striking before January 1st, 2026. B, effective date. The amendment made by the section shall apply to taxable years beginning after December 31st, 2025. Section 70118, extension of treatment of certain individuals performing services in the Sinai Peninsula and enhancement to include additional areas. Treatment made permanent. Section 11026A of Public Law 115-97 is amended by striking with respect to the applicable period. Kenya, Mali, Burkina Faso, and Chad included as hazardous duty areas. Section 11026B of Public Law 15-97 is amended to read as follows. B, qualified hazardous duty area. For purposes of the section, the term qualified hazardous duty area means each of the following locations, but only
during the period for which any member of the Armed Forces of the United States is entitled to special pay under Section 310 of Title 37, United States Code, relating to special pay, duty subject to hostile fire or imminent danger for services performed in such location. 1, the Sinai Peninsula of Egypt. 2, Kenya. 3, Mali. 4, Burkina Faso. 5, Chad. C, conforming amendment. Section 1126 of Public Law 115-97 is amended by striking subsections C and D. D, effective date. The amendments made by this section shall take effect on January 1st, 2026. Section 70119, extension and modification of exclusion from gross income of student loans discharged on account of death or disability. A, in general, Section 108F5 is amended to read as follows. 5, discharges on account of death or disability. A, in general, in the case of an individual, gross income does not include any amount which, but for this subsection, would be includable in gross income for such taxable year by reason of the discharge, in whole or in part, of any loan described in subparagraph B, if such a discharge was 1, pursuant to subsection A or D of Section 437 of the Higher Education Act of 1965, or the parallel benefit under Part D of Title IV of such act relating to the repayment of loan liability. 2, pursuant to Section 464C1F of such act, or 3, otherwise discharged on account of death or total and permanent disability of the student. B, loans discharged. A loan is described in this subparagraph if such loan is 1, a student loan as defined in paragraph 2, or 2, a private education loan as defined in Section 140A of the Consumer Credit Protection Act, 15 U.S.C. 1650A. C, Social Security number requirement. 1, in general, subparagraph A shall not apply with respect to any discharge during any taxable year unless the taxpayer includes the taxpayer's Social Security number on the return of tax for such taxable year. 2, Social Security number. For purposes of this subparagraph, the term Social Security number has the meaning given such term in Section 24H7. B, omission of correct Social Security number treated as mathematical or clerical error. Section 6213G2, as amended by this Act, is further amended by striking "and" at the end of subparagraph 5, by striking the period at the end of subparagraph W, and inserting "and by inserting after subparagraph W the following new subparagraph. X, an omission of a correct Social Security number required under Section 108F5C relating to discharges on account of death or disability. C, effective date. The amendments made by this section shall apply to discharges after December 31st, 2025. Section 70120, limitation on individual deductions for certain state and local taxes, etc. A, in general, Section 164B6 is amended, 1, by striking "and before January 1, 2026, and 2, by striking $10,000, $5,000 in the case of a married individual filing a separate return, and inserting the applicable limitation amount, half the applicable limitation amount in the case of a married individual filing a separate return. B, applicable limitation amount. Section 164B is amended by adding at the end the following new paragraph. 7, applicable limitation amount. A, in general. For purposes of paragraph 6, the term applicable limitation amount means 1, in the case of any taxable year beginning in calendar year 2025, $40,000. 2, in the case of any taxable year beginning in calendar year 2026, $40,400. 3, in the case of any taxable year beginning after calendar year 2026 and before 2030, 101% of the dollar amount in effect under this subparagraph for taxable years beginning in the preceding calendar year. And 4, in the case of any taxable year beginning after calendar year 2029, $10,000. B, phase down based on modified adjusted gross income. 1, in general, except as provided in Clause 3, in the case of any taxable year beginning before January 1st, 2030, the applicable limitation amount shall be reduced by 30% of the excess, if any, of the taxpayer's modified adjusted gross income over the threshold amount, half the threshold amount in the case of a married individual filing a separate return. 2, threshold amount. For purposes of this subparagraph, the term threshold amount means 1, in the case of any taxable year beginning in calendar year 2025, $500,000. 2, in the case of any taxable year beginning in calendar year 2026, $505,000. And 3, in the case of any taxable year beginning after calendar year 2026, 101% of the dollar amount in effect under this subparagraph for taxable years beginning in the preceding calendar year. 3, limitation on reduction. The reduction under Clause 1 shall not result in the applicable limitation amount being less than $10,000. 4, modified adjusted gross income. For purposes of this paragraph, the term modified adjusted gross income means adjusted gross income increased by any amount excluded from gross income under Section 911, 931, or 933. C, effective date. The amendments made by this section shall apply to taxable years beginning after December 31, 2024. Chapter 2, delivering on presidential priorities to provide new middle-class tax relief. Section 70201, no tax on tips. A, deduction allowed. Part 7 of Subchapter B of Chapter 1 is amended by redesignating Section 224 as Section 225 and by inserting after Section 223 the following new section. Section 224, qualified tips. A, in general, there shall be allowed as a deduction an amount equal to the qualified tips received during the taxable year that are included on statements furnished to the individual pursuant to Section 6041D3, 6041AE3, 6050WF2, or 6051A18, or reported by the taxpayer on Form 4137 or successor. B, limitation. 1. In general, the amount allowed as a deduction under this section for any taxable year shall not exceed $25,000. 2. Limitation based on adjusted gross income. A, in general, the amount allowable as a deduction under subsection A after application of paragraph 1 shall be reduced, but not below zero, by $100 for each $1,000 by which the taxpayer's modified adjusted gross income exceeds $150,000, $300,000 in the case of a joint return. B, modified adjusted gross income. For purposes of this paragraph, the term modified adjusted gross income means the adjusted gross income of the taxpayer for the taxable year increased by any amount excluded from gross income under Section 911, 931, or 933. C, tips received in course of trade or business. In the case of qualified tips received by an individual during any taxable year in the course of trade or business, other than the trade or business of performing services as an employee of such individual, such qualified tips shall be taken into account under subsection A only to the extent that the gross income for the taxpayer for such trade or business for such taxable year, including such qualified tips, exceeds the sum of the deductions other than the deduction allowed under this section, allocable to the trade or business in which such qualified tips are received by the individual for such taxable year. D, qualified tips. For purposes of this section, 1, in general, the term qualified tips means cash tips received by an individual in an occupation which customarily and regularly received tips on or before December 31, 2024, as provided by the Secretary. 2, exclusions. Such term shall not include any amount received by an individual unless A, such amount is paid voluntarily without any consequence in the event of non-payment, is not the subject of negotiation, and is determined by the payer. B, the trade or business in the course of which the individual receives such amount is not a specified service, trade, or business as defined in Section 199AD2. And C, such other requirements as may be established by the Secretary and regulations or other guidance are satisfied. For purposes of subparagraph B, in the case of an individual receiving tips in the trade or business of performing services as an employee, such individual shall be treated as receiving tips in the course of a trade or business which is a specified service, trade, or business if the trade or business of the employer is a specified service, trade, or business. 3, cash tips. For purposes of paragraph 1, the term cash tips includes tips received from customers that are paid in cash or charged, and in the case of an employee, tips received under any tip-sharing arrangement. E, Social Security number required. 1, in general, no deduction shall be allowed under this section unless the taxpayer includes on the return of tax for the taxable year such individual's Social Security number. 2, Social Security number defined. For purposes of paragraph 1, the term Social Security number shall have the meaning given such term in Section 24H7. F, married individuals. If the taxpayer is a married individual within the meaning of Section 7703, this section shall apply only if the taxpayer and the taxpayer's spouse file a joint return for the taxable year. G, regulations. The Secretary shall prescribe such regulations or other guidance as may be necessary to prevent reclassification of income as qualified tips, including regulations or other guidance to prevent abuse of the deduction allowed by this section. H, termination. No deduction shall be allowed under this section for any taxable year beginning after December 31, 2028. B, deduction allowed to non-itemizers. Section 63B is amended by striking "and" at the end of paragraph 3, by striking the period at the end of paragraph 4 and inserting "and by adding at the end of the following new paragraph. 5, the deduction provided in section 224. C, omission of correct Social Security number treated as mathematical or clerical error. Section 6213G2, as amended by the preceding provisions of this act, is amended by striking "and" at the end of subparagraph W, by striking the period at the end of subparagraph X and inserting "and by inserting after subparagraph X the following new subparagraph. Y, an omission of a correct Social Security number required under Section 224E relating to deduction for qualified tips. D, exclusion from qualified business income. Section 199AC4 is amended by striking "and" at the end of subparagraph B, by striking the period at the end of subparagraph C and inserting "and by adding at the end of the following new subparagraph. D, any amount with respect to which a deduction is allowable to the taxpayer under Section 224A for the taxable year. E, extension of tip credit to beauty service business. 1, in general, Section 45BB2 as amended is amended to read as follows. 2, application only to certain lines of business. In applying paragraph 1, there shall be taken into account only tips received from customers or clients in connection with the following services. A, the providing, delivering, or serving of food or beverages for consumption if the tipping of employees delivering or serving food or beverages by customers is customary. B, the providing of any of the following services to a customer or client if the tipping of employees providing such services is customary. 1, barbering and hair care. 2, nail care. 3, aesthetics. 4, body and spa treatments. 2, credit determined with respect to minimum wage in effect. Section 45BB1B is amended, A, by striking "as in effect on January 1, 2007, and B, by inserting "and in the case of food or beverage establishments, as in effect on January 1, 2007, after, without regard to Section 3M of such act." F, reporting requirements. 1, returns for payments made in the course of a trade or business. A, statement furnished to Secretary. Section 6041A is amended by inserting "including a separate accounting of any such amounts reasonably designated as cash tips and the occupation described in Section 224D1 of the person receiving such tips after such gains, profits, and income." B, statement furnished to payee. Section 6041D is amended by striking "and" at the end of paragraph 1, by striking the period at the end of paragraph 2 and inserting and by inserting after paragraph 2 the following new paragraph. 3, in the case of compensation to non-employees, the portion of payments that have been reasonably designated as cash tips and the occupation described in Section 224D1 of the person receiving such tips. 2, returns for payments made for services and direct sales. A, statement furnished to Secretary. Section 6041A is amended by inserting "including a separate accounting of any such amounts reasonably designated as cash tips and the occupation described in Section 224D1 of the person receiving such tips after amount of such payments." B, statement furnished to payee. Section 6041AE is amended by striking "and" at the end of paragraph 1, by striking the period at the end of paragraph 2 and inserting and by inserting after paragraph 2 the following new paragraph. 3, in the case of subsection A, the portion of payments that have been reasonably designated as cash tips and the occupation described in Section 224D1 of the person receiving such tips. 3, returns relating to third-party settlement organizations. A, statement furnished to Secretary. Section 6050WA is amended by striking "and" at the end of paragraph 1, by striking the period at the end of paragraph 2 and inserting and by adding at the end the following new paragraph. 3, in the case of a third-party settlement organization, the portion of reportable payment transactions that have been reasonably designated by payers as cash tips and the occupation described in Section 224D1 of the person receiving such tips. B, statement furnished to payee. Section 6050 WF2 is amended by inserting, including a separate accounting of any such amounts that have been reasonably designated by payers as cash tips and the occupation described in Section 224D1 of the person receiving such tips after reportable payment transactions. 4. Returns related to wages. Section 6051A is amended by striking "and" at the end of paragraph 16, by striking the period at the end of paragraph 17, and inserting "and by inserting after paragraph 17 the following new paragraph. 18. The total amount of cash tips reported by the employee under Section 6053A and the occupation described in Section 224D1, such person. G. Clerical amendment. The table of sections for Part 7 of Subchapter B of Chapter 1 is amended by redesignating the item relating to Section 224 as relating to Section 225, and by inserting after the item relating to Section 223 the following new item. Section 224, Qualified Tips. H. Published list of occupations traditionally receiving tips. Not later than 90 days after the date of the enactment of this Act, the Secretary of the Treasury or the Secretary's delegate shall publish a list of occupations which customarily and regularly received tips on or before December 31, 2024 for purposes of Section 224D1 of the Internal Revenue Code of 1986 as added by subsection A. 1. Withholding. The Secretary of the Treasury or the Secretary's delegate shall modify the procedures prescribed under Section 3402A of the Internal Revenue Code of 1986 for taxable years beginning after December 31, 2025, to take into account the deduction allowed under Section 224 of such code as added by this Act. J. Effective date. The amendments made by this section shall apply to taxable years beginning after December 31, 2024. K. Transition rule. In the case of any cash tips required to be reported for periods before January 1, 2026, persons required to file returns or statements under Section 6041A, 6041D3, 6041AA, 6041AE3, 6050WA, or 6050WF2 of the Internal Revenue Code of 1986, as amended by this section, may approximate a separate accounting of amounts designated as cash tips by any reasonable method specified by the Secretary. Section 70202, no tax on overtime. A, deductions allowed. Part 7 of Subchapter B of Chapter 1, as amended by the preceding provisions of this Act, is amended by redesignating Section 225 as Section 226 and by inserting after Section 224 the following new section. Section 225, qualified overtime compensation. A, in general, there shall be allowed as a deduction an amount equal to the qualified overtime compensation received during the taxable year and included on statements furnished to the individual pursuant to Section 6041D4 or 6051A19. B, limitation. 1, in general, the amount allowed as a deduction under this section for any taxable year shall not exceed $12,500, $25,000 in the case of a joint return. 2, limitation based on adjusted gross income. A, in general, the amount allowable as a deduction under subsection A after application of paragraph 1 shall be reduced, but not below zero, by $100 for each $1,000 by which the taxpayer's modified adjusted gross income exceeds $150,000, $300,000 in the case of a joint return. B, modified adjusted gross income. For purposes of this paragraph, the term modified adjusted gross income means the adjusted gross income of the taxpayer for the taxable year increased by any amount excluded from gross income under Section 911, 931, or 933. C, qualified overtime compensation. 1, in general, for purposes of this section, the term qualified overtime compensation means overtime compensation paid to an individual required under Section 7 of the Fair Labor Standards Act of 1938 that is in excess of the regular rate as used in such section at which such individual is employed. 2, exclusions. Such term shall not include any qualified tip as defined in Section 224D. D, Social Security number required. 1, in general, no deduction shall be allowed under this section unless the taxpayer includes on the return of tax for the taxable year such individual's Social Security number. 2, Social Security number defined. For purposes of paragraph 1, the term Social Security number shall have the meaning given such term in Section 24H7. E, married individuals. If the taxpayer is a married individual within the meaning of Section 7703, this section shall apply only if the taxpayer and the taxpayer's spouse file a joint return for the taxable year. F, regulations. The Secretary shall issue such regulations or other guidance as may be necessary or appropriate to carry out the purposes of this section, including regulations or other guidance to prevent abuse of the deduction allowed by this section. G, termination. No deduction shall be allowed under this section for any taxable year beginning after December 31, 2028. B, deduction allowed to non-itemizers. Section 63B, as amended by the preceding provisions of this Act, is amended by striking "and" at the end of paragraph 4, by striking the period at the end of paragraph 5 and inserting "and by adding at the end a following new paragraph. 6, the deduction provided in Section 225. C, reporting. 1, requirement to include overtime compensation on W-2. Section 6051A, as amended by the preceding provision of this Act, is amended by striking "and" at the end of paragraph 17, by striking the period at the end of paragraph 18 and inserting "and by inserting after paragraph 18 the following new paragraph. 19, the total amount of qualified overtime compensation as defined in Section 225C. 2, payments to persons not treated as employees under tax laws. A, statement furnished to Secretary. Section 6041A, as amended by Section 70201E1A, is amended by inserting "and a separate accounting of any amount of qualified overtime compensation as defined in Section 225C after occupation of the person receiving such tips." B, statement furnished to payee. Section 6041D, as amended by Section 70201E1B, is amended by striking "and" at the end of paragraph 2, by striking the period at the end of paragraph 3 and inserting "and by inserting after paragraph 3 the following new paragraph. 4, the portion of payments that are qualified overtime compensation as defined in Section 225C. Omission of correct Social Security number treated as mathematical or clerical error. Section 6213G2, as amended by the preceding provisions of this Act, is amended by striking "and" at the end of subparagraph X, by striking the period at the end of subparagraph Y and inserting "and by inserting after subparagraph Y the following new subparagraph. Z, an omission of a correct Social Security number required under Section 225D relating to deduction for qualified overtime. E, clerical amendment. The table of sections for Part 7 of Subchapter B of Chapter 1, as amended by the preceding provisions of this Act, is amended by redesignating the item relating to Section 225 as an item relating to Section 226, and by inserting after the item relating to Section 224 the following new item. Section 225, qualified overtime compensation. F, withholding. The Secretary of the Treasury or the Secretary's delegate shall modify the procedures prescribed under Section 3402A of the Internal Revenue Code of 1986 for taxable years beginning after December 31st, 2025, to take into account the deduction allowed under Section 225 of such code as added by this Act. G, effective date. The amendments made by this section shall apply to taxable years beginning after December 31, 2024. H, transition rule. In the case of qualified overtime compensation required to be reported for periods before January 1, 2026, persons required to file returns or statements under Section 6051A19, 6041A, or 6041D4 of the Internal Revenue Code of 1986, as amended by this section, may approximate a separate accounting of amounts designated as qualified overtime compensation by any reasonable method specified by the Secretary. Section 70203, no tax on car loan interest. A, in general, Section 163H is amended by redesignating paragraph 4 as paragraph 5 and by inserting after paragraph 3 the following new paragraph. 4, special rules for taxable years 2025 through 2028 relating to qualified passenger vehicle loan interest. A, in general, in the case of taxable years beginning after December 31, 2024 and before January 1, 2029, for purposes of this subsection, the term personal interest shall not include qualified passenger vehicle loan interest. B, qualified passenger vehicle loan interest defined. 1, in general, for purposes of this paragraph, the term qualified passenger vehicle loan interest means any interest which is paid or accrued during the taxable year on indebtedness incurred by the taxpayer after December 31, 2024 for the purchase of and that is secured by a first lien on an applicable passenger vehicle for personal use. 2, exceptions. Such term shall not include any amount paid or incurred on any of the following. 1, a loan to finance fleet sales. 2, a loan incurred for the purchase of a commercial vehicle that is not used for personal purposes. 3, any lease financing. 4, a loan to finance the purchase of a vehicle with a salvage title. 5, a loan to finance the purchase of a vehicle intended to be used for scrap or parts. 3, VIN requirement. Interest shall not be treated as qualified passenger vehicle loan interest under this paragraph unless the taxpayer includes the vehicle identification number of the applicable passenger vehicle described in Clause 1 of the return of tax for the taxable year. C, limitations. 1, dollar amount. The amount of interest taken into account by a taxpayer under subparagraph B for any taxable year shall not exceed $10,000. 2, limitation based on modified adjusted gross income. 1, in general, the amount which is otherwise allowable as a deduction under subsection A is qualified passenger vehicle loan interest determined without regard to the application of Clause 1 shall be reduced, but not below zero, by $200 for each $1,000 or portion thereof by which the modified adjusted gross income of the taxpayer for the taxable year exceeds $100,000, $200,000 in the case of a joint return. 2, modified adjusted gross income. For purposes of this clause, the term modified adjusted gross income means the adjusted gross income of the taxpayer for the taxable year increased by any amount excluded from gross income under section 911, 931, or 933. D, applicable passenger vehicle. The term applicable passenger vehicle means any vehicle, 1, the original use of which commences with the taxpayer, 2, which is manufactured primarily for use on public streets, roads, and highways, not including a vehicle operated exclusively on a rail or rails. 3, which has at least 2 wheels. 4, which is a car, minivan, sport utility vehicle, pickup truck, or motorcycle. 5, which is treated as a motorcycle for purposes of Title II of the Clean Air Act. And 6, which has a gross vehicle weight rating of less than 14,000 pounds. Such term shall not include any vehicle, the final assembly of which did not occur within the United States. E, other definitions and special rules. For purposes of this paragraph, 1, final assembly. For purposes of subparagraph D, the term final assembly means the process by which a manufacturer produces a vehicle at or through the use of a plant, factory, or other place from which the vehicle is delivered to a dealer with all component parts necessary for the mechanical operation of the vehicle included with the vehicle, whether or not the component parts are permanently installed in or on the vehicle. 2, treatment of refinancing. Indebtedness described in subparagraph B shall include indebtedness that results from refinancing any indebtedness described in such subparagraph and that is secured by a first lien on the applicable passenger vehicle with respect to which the refinanced indebtedness was incurred, but only to the extent the amount of such resulting indebtedness does not exceed the amount of such refinanced indebtedness. 3, related parties. Indebtedness described in subparagraph B shall not include any indebtedness owed to a person who is related within the meaning of section 267B or 707B1 to the taxpayer. B, deduction allowed to non-itemizers. Section 63B, as amended by the preceding provisions of this act, is amended by striking "and" at the end of paragraph 5, by striking the period at the end of paragraph 6, and inserting and by adding at the end the following new paragraph. 7, so much of the deduction allowed by section 163A as is attributable to the exception under section 163H4A. C, reporting. 1, in general, subpart B of part 3 of subchapter A of chapter 61 is amended by adding at the end the following new section.
Section 6050AA, returns relating to applicable passenger vehicle loan interest received in trade or business from individuals. A, in general, any person, 1, who is engaged in a trade or business, and 2, who, in the course of such trade or business, receives from any individual interest aggregating $600 or more for any calendar year on a specified passenger vehicle loan, shall make the return described in subsection B with respect to each individual from whom such interest was received at such time as the Secretary may provide. B, form and manner of returns. A return is described in this subsection if such return 1 is in such form as the Secretary may prescribe, and 2 contains A, the name and address of the individual from whom the interest described in subsection A2 was received, B, the amount of such interest received for the calendar year, C, the amount of outstanding principal on the specified passenger vehicle loan as of the beginning of such calendar year, D, the date of the origination of such loan, E, the year, make, model, and vehicle identification number of the applicable passenger vehicle which secures such loan, or such other description of such vehicle as the Secretary may prescribe, and F, such other information as the Secretary may prescribe. C, statements to be furnished to individuals with respect to whom information is required. Every person required to make a return under subsection A shall furnish to each individual whose name is required to be set forth in such a return a written statement shown, 1, the name, address, and phone number of the information contact of the person required to make such return, and 2, the information described in some paragraphs B, C, D, and E of subsection B2 with respect to such individual, and such information as is described in subsection B2F with respect to such individual as the Secretary may provide for purposes of this subsection. The written statement required under the preceding sentence shall be furnished on or before January 31st of the year following the calendar year for which the return under subsection A was required to be made. D, definitions for purposes of this section 1 in general terms used in this section, which are also used in paragraph 4 of sections 163H, shall have the same meaning as when used in such paragraph. 2, specified passenger vehicle loan. The term specified passenger vehicle loan means the indebtedness described in section 163H4B with respect to any applicable passenger vehicle. E, regulations. The Secretary shall issue such regulations or other guidance as may be necessary or appropriate to carry out the purposes of this section, including regulations or other guidance to prevent the duplicate reporting of information under this section. F, applicability. No return shall be required under this section for any period to which section 163H4 does not apply to. Penalties, section 6724D is amended. A, in paragraph 1B by striking or at the end of the clause XXVII, by striking and at the end of clause XXVIII, and inserting or, and by adding at the end of the following new clause. 29, section 6050A, relating to returns relating to applicable passenger vehicle loan interest received in trade or business from individuals, and B, in paragraph 2 by striking or at the end of subparagraph KK, by striking the period at the end of subparagraph LL, and inserting or, and by inserting after subparagraph LL the following new paragraph MM. Section 6050AAC, relating to statements relating to applicable passenger vehicle loan interest received in trade or business from individuals. D, conforming amendments. 1, section 56E1B is amended by striking section 163H4 and inserting section 163H5. 2, the table of sections for subpart B of part 3 of chapter A of chapter 61 is amended by adding at the end of the following new item, section 6050AA, returns relating to applicable passenger vehicle loan interest received in trade or business from individuals. E, effective date. The amendments made by this section shall apply to indebtedness incurred after December 31st, 2024. Section 70204, Trump Accounts and Contribution Pilot Program. A, Trump Accounts, 1 in general, subchapter F of Title 1 is amended by adding at the end the following new part, Part 9, Trump Accounts, Section 530A, Trump Accounts, Section 538, Trump Accounts, A, General Rule, except as provided in a section or under regulations or guidance established by the Secretary, a Trump account shall be treated for purposes of this title in the same manner as an individual retirement account under Section 408A. B, Trump account for purposes of this section. 1, in general, the term Trump account means an individual retirement account is defined in Section 408A, which is not designated as a Roth IRA, and which meets the following requirements. A, the account, I, is created or organized by the Secretary for the exclusive benefit of an eligible individual or such eligible individual's beneficiaries, or 2, is 1, created or organized in the United States for the exclusive benefit of an individual who has not attained the age of 18 before the end of the calendar year or such individual's beneficiaries, and 2, funded by a qualified rollover contribution. B, the amount is designated in such manner as the Secretary shall prescribe at the time of the establishment of the account as a Trump account. C, the written governing instrument creating the account meets the following requirements. 1, no contribution will be accepted, 1, before the date that is 12 months after the date of the enactment of this section, or 2, in the case of a contribution made in any calendar year before the calendar year in which the account beneficiary attains age 18, if such contribution would result in aggregate contributions other than exempt contributions for such calendar year in excess of the contribution limit specified in subsection C2A. 2, except as provided in subsection D, no distribution will be allowed before the first day of the calendar year in which the account beneficiary attains age 18. 3, no part of the account funds will be invested in any asset other than an eligible investment during any period before the first day of the calendar year in which the account beneficiary attains age 18. 2, eligible individual. The term eligible individual means any individual, A, who has not attained the age of 18 before the close of the calendar year in which the election under subparagraph C is made. B, for whom a Social Security number within the meaning of Section 24H7 has been issued before the date on which an election under subsection C is made. And C, for whom, 1, an election is made under the subparagraph by the Secretary if the Secretary determines, based on information available to the Secretary from tax returns or otherwise, that such individual meets the requirements of subparagraphs A and B, and no prior election has been made for such individual under Clause 2, or 2, an election is made under this subparagraph by a person other than the Secretary at such time in such a manner as the Secretary may prescribe for the establishment of the Trump account if no prior election has been made for such individual under Clause 1. 3, eligible investment. A, in general, the term eligible investment means any mutual fund or exchange-traded fund which, 1, tracks the returns of a qualified index, 2, does not use leverage, 3, does not have annual fees and expenses of more than 0.1% of the balance of the investment in the fund, and 4, meets such other criteria as the Secretary determines appropriate for purposes of the Section B qualified index. The term qualified index means 1, the Standard & Poor's 500 stock market index, or 2, any other index. 1, which is comprised of equity investments in United States companies, and 2, for which regulated futures contracts as defined in Section 1256G1 are traded on a qualified board or exchange as defined in Section 1256G7. Such terms shall not include any industry or sector-specific index, but may include an index based on market capitalization. 4, account beneficiary. The term account beneficiary means the individual on whose behalf the Trump account was established. C, treatment of contributions. 1, no deduction allowed. No deduction shall be allowed under Section 219 for any contribution which is made before the first day of the calendar year in which the account beneficiary attains age 18. 2, contribution limit. In the case of any contribution made before the calendar year in which the account beneficiary attains age 18. A, in general, the aggregate amount of contributions other than exempt contributions for such calendar year shall not exceed $5,000. B, exempt contribution. For purposes of this paragraph, the term exempt contribution means 1, qualified rollover contribution, 2, any qualified general contribution, or 3, any contribution provided under Section 6434. C, cost of living adjustment. 1, in general, in the case of any calendar year after 2027, the $5,000 amount under subparagraph A shall be increased by an amount equal to 1, such dollar amount multiplied by 2, the cost of living adjustment determined under Section 1F3 for the calendar year determined by substituting calendar year 2026 for calendar year 2016 in subparagraph A2 thereof. 2, rounding. If any increase under this subparagraph is not a multiple of 100, such amount shall be rounded to the next lower multiple of 100. 3, timing of contributions. Section 219F3 shall not apply to any contribution made to a Trump account for any taxable year ending before the calendar year in which the account beneficiary attains age 18. D, distributions. 1, in general, except as otherwise provided in the subsection, no distribution shall be allowed before the first day of the calendar year in which the account beneficiary attains age 18. 2, tax treatment of allowable distributions. For purposes of applying Section 72 to any amount distributed from a Trump account, the investment in the contract shall not include A, any qualified general contribution, B, any contribution provided under Section 6434, and C, the amount of any contribution which is excluded from the gross income under Section 128. 3, qualified rollover contributions. Paragraph 1 shall not apply to any distribution which is a qualified rollover contribution, and the amount of such distribution shall not be included in the gross income of the beneficiary. 4, qualified able rollover contributions. A, in general, paragraph 1 shall not apply to any distribution which is a qualified able rollover contribution, and the amount of such distribution shall not be included in the gross income of the beneficiary. B, qualified able rollover contribution. For purposes of this section, the term qualified able rollover contribution means an amount which is paid during the calendar year in which the account beneficiary attains age 17 and a direct trustee-to-trustee transfer from a Trump account maintained for the benefit of the account beneficiary to an able account as defined in Section 529 AE6 for the benefit of such account beneficiary, but only if the amount of such payment is equal to the entire balance of the Trump account from which the payment is made. 5, distributions of excess contributions. In the case of any contribution which is made before the calendar year in which the account beneficiary attains age 18 and which is in excess of the limitation in effect under subsection C2A for the calendar year. A, paragraph 1 shall not apply to the distribution of such excess. B, the amount of such distribution shall not be included in gross income of the account beneficiary. And C, the tax imposed by this chapter on the distributee for the taxable year in which the distribution is made shall be increased by 100% of the amount of net income attributable to such excess determined without regard to subparagraph B. 6, treatment of death of account beneficiary. If, by reason of the death of the account beneficiary before the first day of the calendar year in which the account beneficiary attains age 18, any person acquires the account beneficiary's interest in the Trump account, A, paragraph 1 shall not apply. B, such account shall cease to be a Trump account as of the date of death. And C, an amount equal to the fair market value of the assets reduced by the investment in the contract in such account on such date shall, 1, if such person is not the estate of such beneficiary, be includable in such person's gross income for the taxable year, which includes such date, or 2, if such person is the estate of such beneficiary, be includable in such beneficiary's gross income for the last taxable year of such beneficiary. E, qualified rollover contribution. For purposes of this section, the term qualified rollover contribution means an amount which is paid in a direct trustee-to-trustee transfer from a Trump account maintained for the benefit of the account beneficiary to a Trump account maintained for such beneficiary, but only if the amount of such payment is equal to the entire balance of the Trump account from which the payment is made. F, qualified general contribution. For purposes of this section, 1, in general, the term qualified general contribution means any contribution which A, is made by the Secretary pursuant to a general funding contribution, B, is made to the Trump account of an account beneficiary in the qualified class of account beneficiary specified in the general funding contribution, and C, is in an amount which is equal to the ratio of 1, the amount of such general funding contribution, to 2, the number of account beneficiaries in such qualified class. 2, general funding contribution. The term general funding contribution means a contribution which A, is made by 1, an entity described in section 170C1 other than a possession of the United States or a political subdivision thereof or an Indian tribal government, or 2, an organization described in section 501C3 and exempt from tax under section 501A, and B, which specifies a qualified class of account beneficiaries to whom such contribution is to be distributed. 3, qualified class. A, in general, the term qualified class means any of the following. 1, all account beneficiaries who have not attained the age of 18 before the close of the calendar year in which the contribution is made. 2, all account beneficiaries who have not attained the age of 18 before the close of the calendar year in which the contribution is made and who reside in one or more states or other qualified geographic areas specified by the terms of the general funding contribution. 3, all account beneficiaries who have not attained the age of 18 before the close of the calendar year in which the contribution is made and who were born in one or more calendar years specified by the terms of the general funding contribution. B, qualified geographic area. The term qualified geographic area means any geographic area in which not less than 5,000 account beneficiaries reside and which is designated by the Secretary as a qualified geographic area under the subparagraph. G, trustee selection. In the case of any Trump account created or organized by the Secretary shall take into account the following criteria to select in selecting the trustee. 1, the history of reliability and regulatory compliance of the trustee. 2, the customer service experience of the trustee. 3, the costs imposed by the trustee on the account or the account beneficiary. H, other special rules in coordination with individual retirement account rules. 1, in general, the rules of subsections K and P of section 408 shall not apply to a Trump account, and the rules of subsections D and I of section 408 shall not apply to a Trump account for any taxable year beginning before the calendar year in which the account beneficiary attains age 18. 2, custodial accounts. In the case of a Trump account, section 408H shall be applied by substituting a Trump account described in section 530AB1 for an individual retirement account described in subsection A. 3, contributions. In the case of any taxable year beginning before the first day of the calendar year in which the account beneficiary attains age 18, contribution to a Trump account shall not be taken into account in applying any contribution limit to any individual retirement plan other than a Trump account. 4, distribution. Section 408D2 shall be applied separately with respect to Trump accounts and other individual retirement plans. 5, excess contributions for purposes of applying section 4973B to a Trump account for any taxable year beginning before the first day of the calendar year in which the account beneficiary attains age 18. The term excess contributions means the sum of A, the amount by which the amount contributed to the account for the calendar year in which taxable year begins exceeds the amount permitted to be contributed to the account under subsection C2, and B, the amount determined under this paragraph for the preceding taxable year. For purposes of this paragraph, the excess contributions for a taxable year are reduced by the distributions to which subsection D5 applies that are made during the taxable year by the date prescribed by law, including extensions of time for filing the account beneficiary's return for the taxable year. 1, reports. 1, in general, the trustee of a Trump account shall make such reports regarding such account to the Secretary and to the beneficiary of the account at such time and in such a manner that as may be required by the Secretary. Such reports shall include information with respect to A, contributions including the amount and source of any contribution in excess of $25 made from a person other than the Secretary, the account beneficiary, or the parent. or legal guardian of the account beneficiary. B, distributions, including distributions which are qualified rollover contributions. C, the fair market value of the account. D, the investment in the contract with respect to such account. And E, such other matters as the Secretary may require. 2, qualified rollover contributions. Not later than 30 days after the date of any qualified rollover contribution, the trustee of the Trump account to which the contribution was made shall make a report to the Secretary. Such report shall include A, the name, address, and social security number of the account beneficiary. B, the name and address of such trustee. C, the account number. D, the routing number of the trustee. And E, such other information as the Secretary may require. 3, period of reporting. This subsection shall not apply to any period after the calendar year in which the beneficiary attains age 17. 2, qualified able rollover contributions exempt from able contribution limitation. A, in general, section 529A(b)(2)(b) is amended by inserting or received in a qualified able rollover contribution described in section 530A(d)(4)(b) after except as provided in the case of contributions under subsection C1C. B, prohibition on excess contributions. The second sentence of section 529A(b)(6) is amended by inserting but do not include any contributions received in a qualified able rollover contribution described in section 530A(d)(4)(b) before the period at the end. C, conforming amendment. Section 4973H1 is amended by inserting or contributions received in a qualified able rollover contribution described in section 530A(d)(4)(b) after other than contributions under section 529AC1C. 3, failure to provide reports on Trump accounts. Section 6693A2 is amended by striking and at the end of subparagraph E, by striking the period at the end of subparagraph F and inserting and by inserting after subparagraph F the following new subparagraph G. Section 530A1 relating to Trump accounts. 4, clerical amendment. A, the table of parts for subchapter F of chapter 1 is amended by adding at the end the following new item, Part 9, Trump accounts. B, employer contributions. 1, in general. Part 3 of subchapter B of chapter 1 is amended by inserting after section 127 the following new section, section 128, employer contributions to Trump accounts. A, in general, gross income of an employee does not include amounts paid by the employer as a contribution to the Trump account of such employee or of any dependent of such employee if the amounts are paid or incurred pursuant to a program which is described in subsection C. B, limitation. 1, in general, the amount which may be excluded under subsection A with respect to any employee shall not exceed $2,500. 2, inflation adjustment. A, in general, in the case of any taxable year beginning after 2027, the $2,500 amount in paragraph 1 shall be increased by an amount equal to 1, such dollar amount multiplied by 2, the cost of living adjustment determined under section 1F3 for such calendar year by substituting calendar year 2026 for calendar year 2016 in subparagraph A2 thereof. B, rounding. If any increase determined under subparagraph A is not a multiple of $100, such increase shall be rounded to the nearest multiple of $100. C, Trump account contribution program. For purposes of this section, a Trump account contribution program is a separate written plan of an employer for the exclusive benefit of his employees to provide contributions to the Trump accounts of such employees or dependents of such employees, which meets requirements similar to the requirements of paragraphs 2, 3, 6, 7, and 8 of section 129D. 2, clerical amendment. The table of sections for part 3 of subchapter B of chapter 1 is amended by inserting after the item relating to section 127 the following new item, section 128, employer contributions to Trump accounts. C, certain contributions excluded from gross income. 1, in general, part 3 of subchapter B of chapter 1 is amended by inserting before section 140 the following new item, section 139J, certain contributions to Trump accounts. A, in general, gross income of an account beneficiary shall not include any qualified general contribution to a Trump account of the account beneficiary. B, definitions. Any term used in this section which is used in section 530A shall have the meaning given to such term under section 530A. 2, clerical amendment. The table of sections for part 3 of subchapter B is amended by inserting before the item relating to section 140 the following new item, section 139J, certain contributions to Trump accounts. D, Trump accounts contribution pilot program. 1, in general, subchapter B of chapter 65 is amended by adding at the end the following new section, section 6434, Trump accounts contribution pilot program. A, in general, in the case of an individual who makes an election under this section with respect to an eligible child of the individual, such eligible child shall be treated as making a payment against the tax imposed by subtitle A for the taxable year for which the election was made in an amount equal to $1,000. B, refund of payment. The amount treated as a payment under subsection A shall be paid by the Secretary to the Trump account with respect to which such eligible child is the account beneficiary. C, eligible child. For purposes of this section, the term eligible child means qualifying child as defined in section 152C. 1, who was born after December 31st, 2024 and before January 1st, 2029. 2, with respect to whom no prior election has been made under this section by such individual or any other individual. 3, who is a United States citizen, and 4, at least one parent of whom was a United States citizen at the time of such qualifying child's birth. D, election. An election under this section shall be made at such time and in such manner as the Secretary shall provide each Social Security number required. 1, in general, this section shall not apply to any taxpayer unless such individual includes with the election made under this section A, such individual's Social Security number, and B, the Social Security number of the eligible child with respect to whom the election is made. 2, Social Security number defined. For purposes of paragraph 1, the term Social Security number shall have the meaning given such terms in section 24H7 determined by substituting before the date of the election made under section 6434 for before the due date of such return in subparagraph B thereof. F, exception from reduction or offset. Any payment made to any individual under this section shall not be 1, subject to reduction or offset pursuant to subsection C, D, E, or F of section 6402 for any similar authority permitting offset, or 2, reduced or offset by other assessed federal taxes that would otherwise be subject to levy or collection. G, special rule regarding interest. The period determined under section 6611. A, with respect to any payment under this section shall not begin before January 1st, 2028. H, mirror code possessions. In the case of any possession of the United States with a mirror code tax system as defined in section 24K, this section shall not be treated as part of the income tax laws of the United States for purposes of determining the income tax law of such possession unless such possession elects to have this section be so treated. 1, definitions. For purposes of this section, the term Trump account and account beneficiary have the meaning given such terms in section 530AB. 2, penalty for negligent claim or fraudulent claim. Part 1 of subchapter A of chapter 68 is amended by adding at the following new section. Section 6659, improper claim for Trump account, contribution pilot program credit. A, in general. In the case of any individual who makes an election under section 6434 with respect to an individual who is not an eligible child of the taxpayer, 1, if such election was made due to negligence or disregard of the rules or regulations, there shall be imposed a penalty of $500, or 2, if such election was made to fraud, there shall be imposed a penalty of $1,000. B, definitions. 1, eligible child. The term eligible child has the meaning given such term under section 6434. 2, negligence, disregard. The term negligence and disregard have the same meaning as when such terms are used in section 6662. 3, omission of correct Social Security number treated as mathematical or clerical error. Section 6213G2, as amended by the preceding provisions of this act, is amended by striking and at the end of subparagraph Y, by striking the period at the end of subparagraph Z, and inserting and by inserting after subparagraph Z, the following new paragraph, AA, an omission of a correct Social Security number required under section 6434E1 relating to the Trump Accounts Contribution Pilot Program. 4, confirming amendments. A, the table of sections for subchapter B of chapter 65 is amended by adding at the end of the following new item, section 6434, Trump Accounts Contribution Pilot Program. B, the table of sections for part 1 of subchapter A of chapter 68 is amended by inserting after the item relating to section 6658 the following new item, section 6659, improper claim for Trump Account Contribution Pilot Program credit. E, effective date. The amendments made by this section shall apply to taxable years beginning after December 31st, 2025. F, funding. In addition to amounts otherwise available, there is appropriated to the Department of Treasury out of any money in the Treasury not otherwise appropriated $410 million to remain available until September 30th, 2034 to carry out the amendments made by this section. Chapter 3, establishing certainty and competitiveness for American job creators. Subchapter A, permanent U.S. business tax reform and boosting domestic investment. Section 70301, full expensing for certain business property. A, made permanent. 1, in general. Section 168K2A is amended by adding and at the end of clause 1 and striking and at the end of clause 2 and inserting a period and by striking clause 3. 2, property with longer production periods. Section 168K2B is amended A in clause 1 by striking subclauses 2 and 3 and redesignating subclauses 4, 5, and 6 as subclauses 2, 3, and 4 respectively, and B by striking clause 2 and redesignating clauses 3 and 4 as clauses 2 and 3 respectively. 3, self-constructed property. Section 168K2E is amended by striking clause 1 and redesignating clauses 2 and 3 as clauses 1 and 2 respectively. For certain plants, section 168K5A is amended by striking planted before January 1st, 2027, or is grafted before such date to a plant that has already been planted in the matter preceding clause 1 and inserting planted or grafted. 5, conforming amendments. A, section 168K2A2 is amended by striking clause 2 of subparagraph E and inserting clause 1 of subparagraph E. B, section 168K2C1 is amended by striking and subclauses 2 and 3 of subparagraph B1. C, section 168K2C2 is amended by striking subparagraph B3 and inserting subparagraph B2. D, section 460C6B is amended by striking which and all that follows through the period and inserting which has a recovery period of 7 years or less. B, 100% expensing. 1, in general, section 168K is amended A in paragraph 1A by striking the applicable percentage and inserting 100%, and B, by striking paragraph 6 and 8. 2, certain plants, section 168K5A1 is amended by striking the applicable percentage and inserting 100%. 3, transitional election of reduced percentage, section 168K10 is amended by striking subparagraph A and by redesignating subparagraph B as subparagraph C and by inserting before subparagraph C as so redesignated the following new subparagraphs: A in general, in the case of qualified property placed in service by the taxpayer during the first taxable year ending after January 19, 2025, the taxpayer elects to have this paragraph apply for such taxable year, paragraph 1A shall be applied. 1, in the case of property which is not described in clause 2 by substituting 40% for 100%, or 2, in the case of property which is described in subparagraph B or C of paragraph 2 by substituting 60% for 100%. B, specified plants, in the case of any specified plant planted or grafted by the taxpayer during the first taxable year ending after January 19, 2025, that the taxpayer elects to have this paragraph apply for such taxable year, paragraph 5A1 shall be applied by substituting 40% for 100%. C, effective date: 1, in general, except as otherwise provided in this subsection, the amendments made by this section shall apply to property acquired after January 19, 2025. 2, specified plants, except as provided in paragraph 3, and in the case of any specified plant as defined in section 168K 5B of the Internal Revenue Code of 1986 as amended by this section. The amendments made by this section shall apply to such plants which are planted or grafted after January 19, 2025. 3, transitional election of reduced percentage. The amount made by subsection B3 shall apply to taxable years ending after January 19, 2025. 4, acquisition date determination for purposes of paragraph 1. Property shall not be treated as acquired after the date on which a written binding contract is entered into for such acquisition. Section 70302, full expensing of domestic research and experimental expenditures. A, in general. Part 6 of subchapter B of Chapter 1 is amended by inserting after Section 174 the following new section. Section 174A, domestic research or experimental expenditures. A, treatment as expenses. Notwithstanding Section 263, there shall be allowed as a deduction any domestic research or experimental expenditures which are paid or incurred by the taxpayer during the taxable year. B, domestic research or experimental expenditures for purposes of this section. The term domestic research or experimental expenditures means research or experimental expenditures paid or incurred by the taxpayer in connection with the taxpayer's trade or business other than such expenditures which are attributable to foreign research within the meaning of Section 41D4F. C, amortization of certain domestic research or experimental expenditures in general at the election of the taxpayer made in accordance with regulations or guidance provided by the Secretary in the case of domestic research or experimental expenditures which would, but for subsection A, be chargeable to capital account but not chargeable to property of the character which is subject to the allowance under Section 167 relating to allowance for depreciation, etc., or Section 611 relating to allowance for depletion. Subsection A shall not apply, and the taxpayer shall A, charge such expenditures to capital account, and B, be allowed an amortization deduction of such expenditures ratably over such period of not less than 60 months as may be selected by the taxpayer, beginning with the month in which the taxpayer first realizes benefits from such expenditures. 2, time for and scope of election. The election provided by paragraph 1 may be made for any taxable year, but only if made not later than the time prescribed by law for filing the return for such taxable year, including extensions thereof. The method so elected and the period selected by the taxpayer shall be adhered to in computing taxable income for the taxable year for which the election is made, and for all subsequent taxable years unless with the approval of the Secretary a change to a different method or to a different period is authorized with respect to part or all of such expenditures. The election shall not apply to any expenditure paid or incurred during any taxable year before the taxable year for which the taxpayer makes the election. D, special rules. 1, land and other property. This section shall not apply to any expenditure for the acquisition or improvement of land or for the acquisition or improvement of property to be used in connection with the research or experimentation and of a character which is subject to the allowance under Section 167 relating to allowance for depreciation, etc., or Section 611 relating to allowance for depletion, but for the purposes of this section, allowances under Section 167 and allowances under Section 611 shall be considered as expenditures. 2, expiration expenditures. This section shall not apply to any expenditure paid or incurred for the purpose of ascertaining the existence, location, extent, or quality of any deposit of ore or other mineral, including oil and gas. 3, software development. For purposes of this section, any amount paid or incurred in connection with the development of any software shall be treated as a research or experimental expenditure. B, coordination with certain other provisions. 1, foreign research expenses. Section 174 is amended. A in subsection A, 1, by striking a taxpayer's specified research or experimental expenditures and inserting a taxpayer's foreign research or experimental expenditures, and 2, by striking over the 5-year period, 15-year period in the case of any specified research or experimental expenditures which are attributable to foreign research within the meaning of section 41D4F, then paragraph 2B, and inserting over the 15-year period, B in subsection B, 1, by striking specified research and inserting foreign research, 2, by inserting and which are attributable to foreign research within the meaning of section 41D4F before the period at the end, and 3, by striking specified in the heading thereof, inserting foreign, and C in subsection D, 1, by striking specified research or experimental expenditures and inserting foreign research or experimental expenditures, and 2, by inserting or reduction to amount realized after no deduction.
Two, research credit. A, section 41D1A is amended to read as follows. A, with respect to which expenditures are treated as domestic research or experimental expenditures under section 174A. B, section 280CE1 is amended to read as follows. 1, in general, the domestic research or experimental expenditures otherwise taken into account under sections 174A shall be reduced by the amount of the credit allowed under section 41A. 3, AMT adjustment. Section 56B2 is amended. A, in subparagraph A, 1, by striking or 174A in the matter preceding clause 1 and inserting 174A or 174AA, and 2, by striking research and experimental expenditures described in section 174A in clause 2 thereof and inserting foreign research or experimental expenditures described in section 174A and domestic research or experimental expenditures in section 174AA, and B, in paragraph C, by inserting or 174A after 174AA. 4, optional 10-year write-off. Section 59E2B is amended by striking section 174A relating to research and experimental expenditures and inserting section 174AA relating to domestic research or experimental expenditures. 5, qualified small issue bonds. Section 144A4C4 is amended by striking 174A and inserting 174AA. 6, startup expenditures. Section 195C1 is amended by striking or 174 in the last sentence and inserting 174 or 174A. 7, capital expenditures. A, section 263A1B is amended by inserting or 174A after 174. B, section 263A-C2 is amended by inserting or 174A after 174. 8, active business computer software royalties. Section 543D4A1 is amended by inserting 174A after 174. 9, source rules. Section 864G2 is amended, A, by striking research and experimental expenditures within the meaning of section 174 in the first sentence and inserting foreign research or experimental expenditures within the meaning of section 174, or domestic research or experimental expenditures within the meaning of section 174, and B, in the last sentence, 1, by striking treated as deferred expenses under subsection B of section 174 and inserting allowed as an amortization deduction under section 174A or section 174AC, and 2, by striking such subsection and inserting such section as the case may be. 10, basis adjustment. Section 1016A14 is amended by striking deductions as deferred expenses under section 174B1 relating to research and experimental expenditures, and inserting deductions under section 174 or 174AC. 11, small business stock. Section 1202E2B is amended by striking which may be treated as research and experimental expenditures under section 174 and inserting which are treated as foreign research or experimental expenditures under section 174 or domestic research or experimental expenditures under section 174A. E, change in method or accounting. 1, in general, the amendments made by subsection A shall be treated as a change in method of accounting for purposes of section 481 of the Internal Revenue Code of 1996, and A, Such change shall be treated as initiated by the taxpayer. B, such change shall be treated as made with the consent of the Secretary. And C, such change shall be applied only on a cutoff basis for any domestic research or experimental expenditures as defined in Section 174A(b) of such code as added by this section, and determined by applying the rules of Section 174A(d) of such code, paid or incurred in taxable years beginning after December 31st, 2024, and no adjustments under Section 41A shall be made. 2, special rules. In the case of a taxable year which begins after December 31st, 2024, and ends before the date of the enactment of this Act, A, paragraph 1C shall not apply, and B, the change in method of accounting under paragraph 1 shall be applied on a modified cutoff basis, taking into account for purposes of Section 481A of such code only the domestic research or experimental expenditures as defined in Section 174A(b) of such code as added by the section, and determined by applying the rules of Section 174A(d) of such code, paid or incurred in such taxable year, but not allowed as a deduction in such taxable year. D, clerical amendment. The table of sections for Part 6 of Subchapter B of Chapter 1 is amended by inserting after the item relating to Section 174 the following new item. Section 174A, domestic research or experimental expenditures. C, effective date. 1, in general, except as otherwise provided in the subsection or subsection F1, the amendments made by this section shall apply to amounts paid or incurred in taxable years beginning after December 31st, 2024. 2, treatment of foreign research or experimental expenditures upon disposition. A, in general, the amendment by subsection B1, C2 shall apply to property disposed, retired, or abandoned after May 12th, 2025. B, no inference. The amendment made by subsection B1, C2 shall not be construed to create any inference with respect to the proper application of Section 174D of the Internal Revenue Code of 1996 with respect to taxable years beginning before May 13th, 2025. 3, coordination with research credit. The amendment made by subsection B2B shall apply to taxable years beginning after December 31st, 2024. 4, no inference with respect to coordination with research credit for prior periods. The amendment made by subsection B2B shall not be construed to create any inference with respect to the proper application of Section 280CE of the Internal Revenue Code of 1996 with respect to taxable years beginning before January 1st, 2025. F, transition rules. 1, election for retroactive application by certain small businesses. A, in general, at the election of an eligible taxpayer, paragraphs 1 and 3 of subsection E shall each be applied by substituting December 31st, 2021 for December 31st, 2024. An election made under this subparagraph shall be made in such manner as the Secretary may provide and not later than the date that is 1 year after the date of the enactment of this Act. The taxpayer shall file an amended return for each taxable year affected by such election. B, eligible taxpayer. For purposes of this paragraph, the term eligible taxpayer means any taxpayer other than the tax shelter prohibited from using the cash receipts and disbursements methods of accounting under Section 448A3, which meets the gross receipts test of Section 448E for the first taxable year beginning after December 31st, 2024. C, election treated as change in method of accounting. In the case of any taxpayer which elects the application of subparagraph A, 1, such election may be treated as a change in method of accounting for purposes of Section 41 of such code for the taxpayer's first taxable year affected by such election. 2, such change shall be treated as initiated by the taxpayer for such taxable year. 3, such change shall be treated as made with the consent of the Secretary. And 4, subsection C shall not apply to such taxpayer. D, election regarding coordination with research credit. An election under Section 280C E2 of the Internal Revenue Code of 1986, or revocation of such election for any taxable year beginning after December 31st, 2021, by an eligible taxpayer making an election under subparagraph A shall not fail to be treated as timely made or as made on the return if made during the 1-year period beginning on the date of the enactment of this Act on an amended return for such taxable year. 2, election to deduct certain unamortized amounts paid or incurred in taxable years beginning before January 1st, 2025. A, in general, on the case of any domestic research or experimental expenditures as defined in Section 174A as added by subsection A, which are paid or incurred in taxable years beginning after December 31st,